Aussie, no, your sound is working fine.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiffel...
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was...
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what, if you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
Wait, what the fuck? He just walked out like that? What the fuck? Whoa.
And my decision here today. And I guess I am glad I had the opportunity to spend the night to do some deliberation on this matter and think about it. But I want to kind of begin with a sidebar before I go to the motion itself.
Yeah, it's over, kids.
It's an apology I'm going to make to the defense team here. Before you made your motion, I made a few statements that were probably an effort at humor, but I think they could have been interpreted as intemperate, unnecessary, or perhaps even offensive. And that was certainly not my intention. And I likewise did not in any way try to imply that your motion was simply a matter of the record and an administrative act and perhaps without merit. And I say that not only because that wasn't my intention, but your arguments were well-spoken, compelling, well done, and very professional. And in fact, I want to say that both lawyers have been professional throughout this entire case. You're the kind of lawyers that any judge would want on his or her docket trying a case. And I want you to know that. And I regret a lack of reciprocal professionalism for that moment there. And I wanted you to know how I felt. And I wanted to share that with you. It's not reflective, I hope, of who I am. The court, as I said, has had an opportunity to consider this case for a significant period of time last night. And
wow.
I note
wow,
that,
guys.
In my 20 years, both as a sitting judge and a visiting judge,
Oh my God.
rendered decisions on Rule 29 motions in every criminal case, and I've denied those motions and I have granted those motions. But I think I can say this has been the most difficult motion for me to consider. And again, I'm glad I had the time to reflect upon the arguments made by counsel. And I think probably one of the reasons it's difficult is that both the state and the defense have made very compelling and good arguments. Perhaps it's more the state of the evidence presented that I'm
about to.
That, I've had to spend a lot of time thinking about. I want to begin this decision by saying what is not a part of the court's consideration. I am not judging the credibility of any of the witnesses who have testified, nor giving weight to any of the witnesses, nor in any way whatsoever injecting my personal opinion, if any, as to what I would think the state of the evidence is. I am certainly not considering this case on the standard of beyond a reasonable doubt. As we all know, the standard is to look at the evidence in the light most favorable to the state without any of those other considerations. And the court has done so, and my job, if you will, is to determine whether or not there's evidence in which jurors could come to even different conclusions, but one which would be a decision in favor of the state. Now, I have already indicated, and I reaffirm at this point in time, that the state has amply satisfied its burden in regard to the motion, in regard to the establishment of this being a homicide and a staged suicide. With that determination, following that,
he's being generous.
a vast majority, if not the great majority of the elements of murder, both purposeful murder and felony murder, as well as felonious assault, are satisfied by that finding by itself. The issue that's primarily before the court is the question of the identification of the perpetrator who has committed this homicide and staged suicide from the evidence. What probably has made this case most difficult is that there is no direct evidence establishing the defendant as the perpetrator in this case. Now, the state is not legally required to do that, but it does enhance the decision process at this time to be more circumspect. Clearly, as the state has acknowledged as well, that circumstantial evidence is the cornerstone of this case. And the inference reasonably raised from the evidence that in a natural and logical way would follow and according to the common experience of mankind as to what those inferences are drawn from direct evidence is what the court must look at. And I think consistent with the requirement that the court look at the evidence in the light most favorable to the state, the court must also look at the inferences in the light most favorable to the state. So the court has considered the circumstantial evidence provided. The state has, I believe, and perhaps a bit ironically, established the question of motive. The defendant is married to the deceased. The evidence is presented that they've had chats and messages to each other that have been classified as difficult, argumentative, including one not to each other, but one on May 7th where the defendant declared that his marriage was over. Evidence that 2 weeks prior to the argument, there was testimony that there was a very loud argument in their garage. Statements made that are inconsistent with some of the facts determined by law enforcement, and misstatements or even lies made to police. And of course, evidence in regard to the argument that Mr. Moore made statements in the past tense, which inferentially is that the speaker would have known that even though the deceased was not discovered, she was not going to be discovered alive. This kind of is the evidence that demonstrates that the defendant could very well have been unhappy and angry with his wife, and the behavior after he reported her missing could circumstantially infer that he knew something that he was not telling the police. The state also presented evidence, largely through the digital forensic evaluation of the defendant's cell phone, which, as we all know, reflects the usage activity and non-user activity of the phones, that reflected for approximately 3.5 hours on the evening of May 24th and the morning of May 25th, that there was no activity for which time period any acts of the defendant were unaccounted for. Now, again, several inferences may be drawn from that, certainly, but the inference most favorable to the state is that he could very well have been engaged in the conduct that resulted in the demise of his wife. The argument presented by the state, based upon the evidence presented in its totality, is that, again, under the rule, the court has made the finding that this was a homicide and staged suicide from the evidence in the view most favored to the state. And the question raised from that evidence, by working from that, is who would be a perpetrator, who would take the time and necessity not only of ending the life of an individual, but taking the effort to stage it so it would appear to be a suicide. Now, we obviously know, and the evidence reflects, that within 48 hours, the police provided the Miranda rights to the defendant. So he certainly began this case as a person of interest upon whom suspicion would fall, and that's virtually the case every time when a spouse is missing or is found to be a victim of a homicide. Certainly, circumstantially, based upon that evidence, based upon the conclusion that the court's finding that this is a homicide and state suicide
Oh
is
no.
also rather consistent with the thought that the evidence provided the fact that suicide.
That's an asshole
over a
move. You walk
significant
behind
period
your
of time
table.
has affected the difficulty in the lives of both the defendant and his wife, which likewise has a bearing upon why that could very well have been staged by her husband. Again, at this time, considering all of this evidence and in light of what the court has preliminarily addressed regarding the nature of the court's decision, I find at this time that taken in total, the state has met its threshold burden to allow this matter to be considered by the jury, and thus the Rule 29 motion
Are you
presented
fucking
timely
serious?
at the close of the state's case will not be granted.
What the
The
fuck?
court will simply state for the record at this time, and particularly since we are coming to the close of the state's case due to our unique agreed circumstances, that the court on its own motion is going to take under advisement a Rule 29 motion at the conclusion of all of the state's presentation of evidence, and will proceed accordingly. Now, with this decision, we are now at the point where I guess we should take this opportunity, if you wish, to go over jury instructions. Are there any, is the state ready or willing to discuss jury instructions at this point?
Yes, Your Honor.
Wow.
Thank you.
All right, what would you, what changes,
Judge,
deletions,
you are a
additions, or corrections would you
pussy.
seek?
Thank you. Hold on a second. Sorry. about
Come on, Judge.
that. I actually only just have a few things to point out to the court. Respectfully, Your Honor, the first one being the inclusion of the defense's request for the suicide instruction on page 3 of the jury instructions. Your Honor, in their trial brief, they provided one case from the state of Pennsylvania to support that request. I found no Ohio case law to support that request in an Ohio court. Also, Your Honor, this instruction is not included within the Ohio Jury Instructions Manual, which you know has been around for decades and years and ages. And if it was something of such an importance,
OJIs are a
that
framework.
instruction would have been included in that manual and used before in other cases besides this one. Certainly, the fact that they're arguing suicide is not a novel theory in the world of all of the homicide cases that the courts in the state of Ohio have heard. But Your Honor, it's a little bit more than that too. I find no legal basis for that request. But the way that it is said, phrased even, Your Honor, it says, the defendant's attorneys contend in this case that Emily Noble committed suicide. The fact that those attorneys presented some evidence, there's been no evidence that Emily Noble was suicidal. None. None. Not a single witness came in here and said she was suicidal, that she had suicidal ideations, that she would ever consider killing herself. It's quite the opposite, Your Honor. They all came in here and told you how strong she was, how she persevered, how she would never do that to her sister, Amy Thomas. So for an instruction to go in there, that there's some evidence of it, there is no evidence that Emily Noble was suicidal. None. And to put the words, some evidence in there, based upon the facts of this case, the facts and the evidence that came from the witness stand, there is nothing in her mental health records to indicate she was suicidal. You've been through those records, Your Honor. You know the words suicide, suicidal ideation are not in there. There are medical records now admitted. You know, there's nothing in there to indicate she's suicidal. Dr. Hickman sat on the stand and said he reviewed all those records. Did you find any indication of suicide, that this was a suicide? No. So we wholly object to that inclusion in the jury instructions. Do you want me to move on to my other ones?
Anything else you'd like to have, I'd like to hear.
Okay. Your Honor, on page 4 of the indictment, where it says, ladies and gentlemen, direct evidence and circumstantial evidence are of equal weight and probative value. And then in the following paragraph, it talks about the evidence does not include the indictment, the opening statements, or closing arguments of counsel. Your Honor, I believe OJI actually may take it a step further, and I think it's appropriate given what's occurred in this case to go even more regarding the statements of counsel. Just give me 1 second to get my papers organized. So OJI says the evidence does not include any statement made by counsel during trial unless such statement was an admission or an agreement of certain facts. The opening statements and closing arguments are not evidence. They are designed to assist you in evaluating that evidence. So I would ask that that be followed with the inclusion that questions in the statement that says the opening statements and closing arguments are not evidence. I would like included there the opening statements, closing arguments, and questions by counsel are not evidence.
Isn't that in there somewhere already?
I didn't see that, Your Honor, but
Okay.
so, and I think it's appropriate given, the lines of questionings that have occurred in this courtroom to go even one step further and to give the jury an example. And the example could be something, I'd leave it to the court's discretion, but you told law enforcement that she was wearing a blue shirt. Did you not? That's not evidence, Your Honor. If the witness...
If the witness agrees with that answer, it is. That's cross-examination.
Correct. But if the witness says, I don't know,
Then it's not.
the evidence is not evidence. And because that line of questioning has continued and continued and continued and continued and continued, I believe it's important to give additional instructions to the jury so they understand that the evidence is coming from the witness stand. If they say yes, okay, that's the evidence. If they say, I don't know, that's the evidence. If they say no, then the evidence is that they didn't tell police that person was wearing a blue shirt. And then, Your Honor, on page, may I move to the next topic, please?
I'm sorry?
May I move to the next topic?
Yes, please.
Okay, then bottom of page 5, top of page 6, where the court is talking about expert testimony. And I'll admit, I've seen something like this before. But when I went to Ohio jury instructions again, I did not see that exact paragraph and that language as instructions for expert witnesses.
Starting with it's on the bottom of page 5, that's what you're referring to?
I have allow me next to briefly comment. Oh, but then yes, yeah. That
Okay.
paragraph that goes through. So I would ask that OJI strictly follow, when we're talking about the expert witnesses, that we follow strictly Ohio jury instructions. I wholly object to that its purpose is not to supplant, where the court emphasizes that word, but is instead to supplement your judgment. I wholly object to that. And any emphasis to be placed on that is not rooted, again, in OJI.
I missed that it was underlined. So I'm in agreement.
Again, and OJI says the weight of testimony, of expert testimony, the weight of expert testimony. As with other witnesses, upon you alone rests the duty of deciding the weight that should be given to the testimony of experts. In determining its weight, you may take into consideration his skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. Period. No extraneous jury instruction language should be included when we're talking about the expert witness. There's no basis in OJI for it.
Okay.
I believe, Your Honor, with that, those are the states.
Okay,
Yes,
thank you.
Thank you, Judge. As drafted, the defense has no objections. Just for the record, I will address the arguments that have been made with respect to the suicide construction.
Sure.
There was no Ohio case law on point. That is correct. It's also not an OJI. We did tender, as the state said, a case from Pennsylvania. That case is very similar and certainly is on point.
Well, yeah, it's only a framework, Diane. You're gonna get it.
Distinguished from perhaps other homicides where suicide is argued, is that this has really been a case, as this court has watched, where the state has, for the last 6 days of testimony, worked to refute that this was a suicide, versus work to prove that that's the man that killed him. And that is why this instruction is so critical in this particular case, because the jury has watched the state for 6 days refute that she was killed, and the refuting of evidence seemingly shifts a burden to us. And we have no burden, as this court knows, which is exactly why we supplied the instruction and the case that supports it. Your Honor, I would note on page 4, there is the inclusion with respect to questions not being evidence. It is last full paragraph on page 4 as we read it. Lastly, I know my OJI, but I just want to make sure. I believe wait is also followed by if any in OJI. So I would just make the note that it's wait if any.
Where is that? I'm sorry.
Well, repeatedly wait when the experts section, I believe, and I don't have the instruction in front of me, but I believe it's whatever weight, if any, you give to boom, 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 boom.
That's not in there, if any?
If any's not in.
I have the jury instruction for weight, Your Honor. I don't see.
Okay, well, I will look at that,
Thank you.
because I believe that's probably a correct statement.
Would you like me to approach you with the Ohio jury instruction? Printed off this morning.
Okay, sure, yeah, thank you, that would be very helpful.
I would just note, Your Honor, when the instruction references the credibility, circles back, the credibility instruction says, obviously, as this court well knows, you can believe, disbelieve all, some, or none of any witness's testimony. So
That's in there, right?
it is in there. It's an inaccurate statement to just have weight alone, because the jurors do not have to, by law, give any weight to an expert's testimony, which is why the if any words have always been included routinely in cases, even with courts that follow OJI. Otherwise, nothing further, Your Honor.
Okay. Does this respond to what you just said? The paragraph on page 5, you're not required to believe testimony of any witness simply because the witness took an oath to tell the truth. You may believe or disbelieve all or any part of the testimony of any witness.
No, and I believe that's an accurate statement with respect to that instruction. I went to the weight in the expert instruction, which I believe was on top of 6. I just want to, I would ask that after weight, it says if any. The jurors aren't required to give weight to experts just because they're experts. And that goes for all experts.
Well, it goes for all witnesses.
Absolutely.
And Your Honor, that's the point. It should be included in the credibility of all witnesses section and not highlighted again in the experts section. It does not say that in the expert witness instruction in OJI.
All right. Well, thank you. Thank you all. I'll work on those, and we'll go on the record as to how we're going to ultimately set those exhibits. It's my understanding the defense has a witness they wish to call.
Yes, Your Honor, let me make sure that he's outside. He was supposed to be here.
He's
He's here?
Okay.
Great. Thank you.
Just for housekeeping purposes, do you anticipate this will be your last witness?
I do, Your Honor. We just need to plug this in for my next witness.
That's fine. That's fine. Does the state anticipate any rebuttal witnesses?
Not anticipated this time, obviously. We'll see if something surprising happens with a witness, but no, we would expect that.
Okay, fair enough.
Your Honor, before the jury's come in, we do stipulate to this witness being tendered as an expert in biomechanics engineering. There's an agreement about that. Has that changed?
Council and the state talked about this yesterday. We're not going to object to that. We're going to expedite that a little bit. We have no issue with that. Thank you.
Thank you, Corey.
And then, but I'll tender, no objection, and then just, of course, ask him where he works and what he does, and then I will go into the testimony.
Okay,
Thank you.
however you want to do it. Whenever you're ready, bring it. Well, I guess we need to read the jury. I guess that's kind of important. Let me get my staff to get the jury in.
Give me 1 second, guys. I'll be on.
Just want to mark it for identification.
Okay, guys. So, there was one comment I wanted to touch on from Miss Cabby. When they said the evidence is not evidence, witness testimony is evidence. But if the question asked is, was the defendant wearing a red hat or a blue hat when he robbed the bank? The answer would be evidence. So if the witness said it was a blue hat, that's evidence the jury could consider. If it's a red hat, the jury can consider that. Or if the witness says, I don't know, that's also evidence. the answers itself are the evidence. So in this case, the answer would be, I don't know. That's evidence. The witness did not know the answer. You can't then, the question itself is not evidence. It's only the answer is evidence. Because the witness did not offer the question. The witness only offers the answer. I hope that makes sense. The defense and the prosecution both still have witnesses. From what I understand, the state had to call their people out of order, so they haven't officially rested their case. So at this point, they both have people still to go, actually. And I apologize for not really recognizing that earlier. But that is the situation as we see it. Is he chewing them out for being late right now? No. He wouldn't be doing that in front of the courtroom. That would be done formally. Also, when the prosecutor came in like that and walked in front of the table, that was kind of poor form. You always walk behind the table. You don't really have an excuse to go in front of it unless you're asking for permission. So that was kind of a bitchy thing. Luke, you're asking, are Rule 29 motions decided de novo on appeal? Well, the court basically sits as a 13th juror and determines whether or not it could have happened. There's a whole standard for them. But they initially based the presumption on the trial court was correct in its assessment of the evidence. Harris Riley, you're asking, is tonight's stream still on? Yes, 100%. We're going to be doing this tonight, brother. So I hope I kind of got you guys caught up on everything here. Yes, Miss Cabby, he was very disrespectful. The way he acted, I would never do that to a judge, but hey, some attorneys do, and sometimes they get away with it. Okay, and I'm glad, Miss Cabby, you're saying.
Just for the record, you're juror number 6, correct? All right. You expressed to the court.
Juror problems.
An event that occurred in your presence last night. Would you share that with counsel?
Yeah, I was approached in the parking lot by a young lady. I think the first comment was, I saw you on TV. And I was kind of taken aback. I kept walking. She said, you're on the jury. And I kept walking. And then I turned and said, I've been instructed, I cannot talk to you. And then I moved. I kept walking. Sheriff, I think the gentleman over there, one of the sheriffs.
Gentleman back there.
No hair. One of the two. Sheriff, I think as I'm driving off, I think he approached her and basically, I would guess he asked her to leave. But I informed Carla first, and then Carla talked to you, and I just wanted to make you aware that I did not talk to this lady at all.
Okay, thank you. State have any inquiry?
Just briefly, anything about that interaction that gives you any concern about your ability to still sit as a fair and impartial jury and decide this case on the facts you've heard here? Okay, thank you.
Should be fine.
All right. Why don't you just stay in your seat? We're going to bring the rest of your colleagues in.
Okay, thank you.
All right. I'm comfortable going forward.
That's an interesting issue. Yes, everybody who's asking or wondering, I don't think she's ginger. I think she's more, just brown or auburn hair. But yes, the woman at the prosecution table is Melissa Scheifel. She is she's the prosecuting attorney for Delaware County, Ohio. She is the elected position. So yes, The boss itself is actually trying this one.
Thank you. All have a seat.
So, guys, that sidebar was probably about the juror issue.
As
So-
always, everyone, good morning. Have a good night and follow the court's admonition.
Here we go with day 7.
Thank you very much.
We're starting.
You're in the defense case, and you may call your next witness.
Thank you, Your Honor. The defense, we call Dr. John Bolte.
I wonder if this is the body farm guy.
I do.
Nice tie. I really like that,
Good morning.
especially with the shirt color.
Introduce yourself to the jury, if you could.
My name is John Bolte, and I'm a professor at Ohio State University.
Before I ask you just a few questions about that, Your Honor, at this time, the parties agree that Dr. Bolte is an expert in biomechanical engineering.
That's true, no objection, thank you.
Thank you. So noted for the record. Please.
Thank you.
They're going to talk about the
Dr.
hanging.
Bolte, you just indicated that you're a professor. Tell us about what you do at Ohio State.
I am a full professor in the School of Health and Rehab Sciences, which is within the College of Medicine at Ohio State University. I'm also the director of research for the school, and I serve as the founder and director of the Injury Biomechanics Research Center at Ohio State.
Do you have a CV?
I do.
Showing the witness what has been marked as Defendant's Exhibit SS.
I'm sorry, what was your name again?
Sam.
Thank you.
Dr. Bolte, does this look familiar? And let me go to the last page. It appears to be 46 pages long.
That is familiar, yes.
And when did you provide this to me at some point since we've met?
Yes, when you came to my office to meet the first time, I provided this copy to you.
And if you recall, when was that meeting?
I do not recall. I would say two to 3 weeks ago.
Does this appear to be a fair and accurate copy of your current CV marked as Defendant's Exhibit SS?
It is.
Tell us a little bit about how you became involved in this case with respect to Emily Noble.
I first became involved on October 26, 2020. I received an email from Detective Grubbs requesting if I knew anyone that could help test a tree to see how much mass the tree could suspend. And it was just an open email, and I respond with, I don't have a lot of expertise with the tree, but I might be able to support this.
When you say mass, what does mass mean in that context?
Weight.
And as a result of that initial outreach from Detective Grubbs, what, if anything, happened next?
We exchanged a few emails. I believe there was an email from a tree expert that had a suggestion of how to test the tree. We decided to meet on November 6th at 9 a.m. at the location so I could view the tree and brainstorm what engineering tests we could do to potentially test this tree branch. So the first meeting was there at the scene on November 6th of 2020.
If you recall, who was there at the scene on November 6th?
Detective Grubbs in Alloway, myself, Dr. Yoon Siak Kang, who is another professor in the IBRC, along with myself, and Dr. Amanda Agnew, who is also within the IBRC.
Was there another time that you went out to that same location?
We actually went back out on November 11th to run the tests that are in my report.
Which takes me to, did you write a report in this case?
Yes, I did.
Showing you what's been marked as Defendant's Exhibit VV, as in Victor. And Dr. Bolte, there is a copy of that same report in front of you.
Thank you.
If you could flip through it, 6-page report, and let the jurors know if that appears to be a fair and accurate copy of the report that you issued in this case.
It is an accurate copy.
Let's go through it if we could. The date of the issuance of the report,
It was January 31st, 2021.
when the report was finished, to whom did you send it?
I sent it to Dr. Grubb, or Detective Grubb, excuse me.
Let's go through. You mentioned that you went back to the scene again on November 11th of 2020. Let's talk about what you did when you went back. But before we talk about what you did, tell the jurors what you brought with you to do the testing.
So after we visited on the 6th and looked at the landscape to see what we might be able to bring to run the test, we came back on the 11th with several pieces of equipment to allow us to do a couple different tests. One was a camera, a regular camera that could take still photos and video, and a tripod to set that camera up on. We also brought a data acquisition system, which is used to, when you're running a scientific test, collect data, whether that's from an accelerometer or any type of instrument that could record motion or something along those lines. So it just is like a computer. We had a laptop to connect to the data acquisition system to collect the data. We had a inline load cell that I have with me here this morning to suspend from the branch so we can record how much weight was hanging from the branch. We had a empty milk carton basket to hold weights. We had a series of different weights of different amounts so that we could add to it slowly to see what would happen to the branch. And then finally, we had a 5th percentile female anthropomorphic test dummy, which is known as a crash test dummy, which is used to crash test frontal. When they do a frontal crash test in the United States, NHTSA, they use this dummy. And they also use it actually in a couple other tests. It is a size of a small female. It weighs approximately 105 pounds.
Were you given at any point prior to the scene on November 11th a weight with respect to the tree branch, a weight that the Westerville Police Office wanted you to test against, if that question makes sense?
I was not given a specific weight. I was just told a small female. And we happen to have the dummy that we could use that is supposed to represent a small female.
And the dummy, the crash test dummy that you used again weighs approximately how much?
It's between 105 to 110 pounds, depending on what instrumentation is inside of it. We did not use any instrumentation in the dummy. We just used the dummy as a weight.
Did you bring a USB cord with you?
I did. I brought 2 USB cables. I had asked Detective Grubbs if he knew a serial number, something that we could try to match the USB cable. And I went out and purchased 2 10-foot long gray USB cables that I thought were similar to the best of my ability.
Going now to what you did at the scene. You indicated that you had a camera and video. Did you run tests at the scene?
We did. We ran 2 different sets of tests.
And before I actually go into the test, from your perspective as an expert, biomechanical engineer, and you walked down there in early November and you first saw the branch, what was your thought?
As a biomechanical expert, I do not know anything about trees. So I don't know the strength of trees. So it's really, I can't really comment further than that. I know the body, I don't really know trees.
Show the jurors sort of how big the branch was in terms of circumference.
I would approximate it to have been maybe 1 to 2 inches in circumference. And it was about an inch over my head. So we measured, and I'm a 6'6", so it was about 6 foot 7 inches off the ground when we tested it on the 11th.
Let's talk through the first test that you did at the scene. A static mass test. What is that?
So we thought the first test would just be something to add weight step by step to see how much weight the branch could hold. I had no idea, as I mentioned, I'm not a tree expert. I know how to run scientific tests to look at boundary conditions or to test something that's similar to maybe what occurred there. And so we thought, let's just start with an empty crate hanging from a USB cable through this device and add weight in steps to see if we could get close to 100 pounds without the brake branching in a very static, meaning no motion. Just put the weight, wait a few seconds, add the next weight.
How did you know how to tie or fasten the USB cord to the branch?
I didn't fasten the cord to the branch. I fastened the cable, one end of the cable. So this load cell records weight by pulling on it. It's a tension. So if you pull it, it can measure how much I'm pulling on it right now. So we looped the USB cable through one end of it, and it had two wires coming up over top of the branch, and then came down to the basket. On the first static test, it came back to this, and then we had a separate USB cable going to the basket. We used two cables, I believe, on the first test. So it wasn't tied directly to the tree. They were more tied to the load cell. There were two marks in the tree branch that we were able to see, that we made sure the two cables from the USB were sitting in those same two marks that were already in the branch. So that's how it was set to the tree. They were in the grooves that were in the branch.
And in paragraph, the last full paragraph of your report, you talk about the discrete intervals of adding the weights. Tell the jurors what those numbers mean at the end there with respect to the static test.
Honestly, before we went to the scene, we walked around our lab to find weights that we could throw into the basket. And so we have, over the years of doing different tests, we have different weights of different masses, and we found ones that were 33, 15. And I apologize as I look at this. I know there was a 2-pound weight as well. So we got up to around 96 pounds of total static weights. We put 5 different segments of weight in before the basket slipped to the ground.
And each time you added a weight to the basket, was that captured on film?
It was. We had the camera, I forget if it was our Sony camera, it's probably stated in here, running the entire time in regular motion, regular speed, recording the weights. The camera just ran constantly, and we just kept adding weights to it.
I want to walk through each video, each time the weights were added, and we can talk about them, and then I'll ask you if they're fair and accurate copies. We'll play the first one that we've marked as we'll do Defendant's Exhibit UU, and we'll mark all 5 as that, Your Honor. And Dr. Bolte, the screen in front of you works as well, too.
Okay, thank you.
So before we play it, tell us what we're seeing here.
So what you're seeing here, and it's a little hard to see because of the branches in the background to see the gray cables, but it's an empty milk crate that is hanging from one USB cable that's tied to all 4 corners. There are no weights in the basket this time. Going up to the load cell that's in the middle there, and then again the USB cable going up and over the tree. And as I look at this video, I apologize, there was a knot around the tree at this time. It was a knot that was below the tree with the 2 wires on top. But as we placed the weights, you'll see the knot slipped up against the tree. Thus my forgetting at the beginning that initially the knot was not on the tree.
You can mark your screen too, but tell us you have something in front of you, and I circled something there on the scene. If you can see it, what is that?
This what you just circled is this load cell that's hanging in there. There was a turnbuckle hook on each end in addition to what I have here today. I did not bring those, so there was hooks that we could run the wires to, but this is what's in the middle of the red there, this interface tension load cell.
And what this appears to be something in your hands there.
That is the first weight that we placed in the basket. This is a 33-pound piece of material that we had in the lab from past testing.
Let's go ahead.
You guys asking?
That first weight was 33 pounds.
Correct.
Let's go to the next video, please.
His murder case is hinging upon a USB cable tied to a milk crate.
Was there a certain amount of time that you waited between adding weights?
It was a judgment weight. We just paused for a second to see if the branch was going to be stable. As you saw when I added the first weight, I didn't know how the weight would fall in the basket and what would happen. But then the knot that was just kind of between the branch and the load cell, as I mentioned, it slid up and tightened, and that's why the basket dropped so much, and that caught us off guard. So then we kind of waited each time to see if there'd be a little more slippage as that knot continued to tighten and tighten. So it was more just a judgment call to say, okay, the system is balanced, the basket's not going to fall, the tree branches are going to break, let's add the next weight.
Let's play the next. As part of the static test, are you also measuring the deflection of the branch?
Yes, so we didn't measure the deflection in between each weight. We had the original height, and then once we were done with all the weight that we added to the basket, we were able to pause the film, and we calculated about, I think it's almost 3 inches, 2.96 inches that the branch deflected down from the static test.
And is that 2.96 inches, page 4 of 6 in your report? Or no?
It is 2.98 inches, excuse me. It's written on page 3, and the data, the plot that shows it is on page 4, figure 3.
And I will toggle back to that as soon as we're done with the videos. Let's look at the next video. So we're still at the static test here where you're getting nearing 100 pounds?
The last weight that I just added there was roughly around 14 to 15 pounds. And then
There's one more video. We'll play that now.
the last weight is identical, again, around 14 to 15 pounds.
And then in that last image, we seem to see the USB slips and the basket falls. And what, if any, effect does even that have on that branch?
It wouldn't have any effect on the branch. It was just a matter of we were afraid if the milk crate was going to break. We thought we were already close to 100 pounds. Right before I put the last weight in, which would have taken, I think, to 110, we were at 96. And I felt that was enough to say that, okay, we can hang the crash test dummy on the branch and the dummy won't break when we initially hang the dummy. So the static test was one, to see if we could get close to 100 pounds without it breaking, and then also making sure that when we try to hang the heavy crash test dummy, that it also would support the dummy weight.
So I want to go back to page 3 of 6 of your report, where we talked about the deflection of the branch in the static mass test. You indicated 2.9 inches when 96 pounds was statically suspended. Just explain to us one more time what that visually looks like.
So again, the branch was initially 6'7" off the ground. Once the 96 pounds was added, the branch at the location of the USB cable had deflected towards the ground about 3 inches.
And that finding, is that what's calculated on test 1, static max basket, in your report?
Correct. So this is the data that the data acquisition system sends to the computer, that this measured the weight. And so on the bottom, you can see it says time in seconds. And so that you can see how often I added a weight. It starts at 0, and on the left is mass in pounds. And so, we started recording. There was nothing in the basket. I should state that obviously when the wire and the basket are hanging on this picks up a pound and a half, and we're able to zero that off and say, okay, we're going to call this 0 now. And so then when we start the test, it's at 0, and you can see then at approximately 4 or 5 seconds in, I added the first weight, and you can see it hung there at 33 pounds, and then you see the large jump in the data line at about 13 seconds.
You
Can
mark
I
the screen.
circle?
Yeah.
Oh. So that, sorry. That's at which time that slip occurred, and you saw the basket drop. That's what that is. That's that jolt from the basket. And then after that, you can see it's stayed at 33. And then about 20 seconds, I added the next 33 pound, and then the smaller 1 to 2 pounds, and then the 2 that were about 15 pounds. So the entire test lasted 1 minute and 10 seconds.
And the time interval is what's indicated by that bottom line right there?
Yes, that's the time that each weight was placed.
You mentioned earlier about the knot that slipped. I'm just moving up page 4 of 6. Can you describe what picture B is depicting? And we'll start there.
So, can I start with picture A?
You sure can. Let me zoom in so the jurors can see it. How's that?
Thank you. In picture A, you can see what we attempted to do at first. So you can see in the bottom of the picture this load cell, and you can see the little turnbuckle that was added with the hook. We ran the one USB cable up, and as I stated, there were 2 indentations on the branch, and so I ran the USB cable through those 2 indentations, and then tried to put a knot below that, and just had the rest of the wire off. So that picture was taken when the basket was hanging there empty. And then as we added weights, my knot slid up against the tree, and that's when it became against the tree. So I obviously did not tie a correct knot to begin with.
And when you talk about the knot, will you circle the knot for the jurors, or how you originally tied it and then how it slipped afterwards?
I think it's just a quick through and pulled once, a very simplistic knot. And so obviously when the mask got added, all the USB cable was able to slide through it and pull that knot up to the branch.
Let's now turn to, after the static mass test, did you do a second test on the branch?
We did, and we called that the dynamic test. It was also trying to be perhaps a realistic scientific test. And we started by just hanging that 5th small female crash test dummy to make sure the branch suspended the dummy. And then we tried to lift the dummy about 6 inches and give it a little bit of a dynamic event so that there was some energy from gravity pulling on the dummy back down.
Did the crash test dummy have its legs on it, anatomically speaking?
When we first got to the scene, yes, it had its legs. When we realized with the height of the branch and with the load cell and trying to get everything to fit, we had to take the legs close to the knees off. A female, any crash test dummy, a frontal crash test dummy, has a fixed pelvis because they're seated in a vehicle usually. And so that pelvis is at about 90 degrees. And then the legs come out, and then you have knees that come down and obviously ankle and feet. Unfortunately, dummies are built to survive crash tests of vehicles. And so they don't move like we do. They're very stiff. They're hard to maneuver. And so once we had the dummy in place, we realized the legs, as they came off the knees and down, would be resting on the ground. So we took mid-shaft femur just above the knees off. I think the report says knees. It's very close. And then once we hung the dummy without the knees, we then put the knees in the lap of the dummy and just held them there with, I believe it was tape, just to make sure we had all the mass of the dummy there. It looks funny though, because the legs were not attached. No, they were just sitting in the lap.
And this test, like the static mass, was this captured on camera?
It was. We ran video for all the events. In this event, it's critical because there's motion and that tree limb's really going to bow down, perhaps break. We didn't know when we ran the test. We wanted to have the camera rolling so that we can go back and analyze the film and try to see exactly at what point, if it failed, what point it failed, or how much it deflected.
And before we play the video, tell the jurors what we see here.
So we actually ran a video while I was attempting to suspend the dummy in a manner that we felt was similar to how the remains were discovered.
And for the dynamic tests, was the USB cord placed in the same or similar spot or different?
For this case, or this test, excuse me, we used one USB cable and we tried to simulate what I knew of how things were found. And so I'm staring and kind of pulling down on the limb slightly there to ensure that the two cables are running through those same indentations when we set up this test.
And any information that you had at that point in November as to the remains or even the branch, where did that information come from?
Detective Grubbs brought with him one picture that showed the USB cable kind of coming off the back and how one end was hanging down. I asked because I really wanted to try to mimic exactly how the remains were discovered to make sure the test was realistic as possible.
Playing what's the 6th video in Defendant's Exhibit U, Your Honor? Tell the jurors what you're doing right there with the USB cord.
So in this case, we used one, what we purchased, gray 10-foot USB cable. Once we got out of the package and measured it on the scene, we discovered that a 10-foot USB cable is actually, I think, 126, almost 127 inches. It's actually longer than 10 feet. And so what we did is there was this hook, remember, on this load cell. So we just doubled folded the USB cable in half, hooked it around the hook. So you had two wires coming off, ran them through the indentations on the tree. And then there was a hook on the bottom. As we came down, I used the one end of the USB just to latch in that hook, just the normal end, and it hooked. And so there was this loop then, two coming off the top around the tree, one cable coming back to the hook. And so the loop was there, and my son, who assisted on this test, helped me place the ATD then with that loop under the chin, and the second end actually then freely hung down. So the entire setup was only hooked with one end of the USB cable. So at this point, I'm trying to make sure the one end is hooked and that the dummy would actually hang before we unhook the other end to mimic the one picture.
Let's watch the rest. If we could pause it right there. What you were just doing at the branch there, why were you doing that?
I was trying to ensure that the USB wires were sitting in the indentation.
At this point in time, there's two videos. At this point in time, without the legs, do you know how much the cross?
I do not know the exact number, no.
Okay. And then at some point, did you add the legs to the dummy?
Yeah, if you can go
Yes.
back to the beginning, you can see that the legs, oops.
Right there?
So no, the legs are still not on at this point.
Right.
The next video, just bring it up if you would, please. Try to pause. So you can see, and I'll circle it. That is the shoe and the foot of one of the legs. So if you remember the last video, it kind of stopped with the dummy with just the knees. Here, we've now placed the legs across the thighs of that dummy, and they're in the dummy's lap.
And so initially in the last video, the dummy was statically hanging. The dynamic test, before we watch this next video, tell us what you do to create the dynamic, if you will.
Well, in this situation, what you see here is the dummy, again, is around 105 to 108 pounds, and it is sitting, you might have noticed at the end of the last video, probably 6 to 10 inches off the ground. And so my son and I, and my son worked in the IBRC at this time, we tried to just lift the dummy approximately 6 inches to get the dummy in the air. And so this video starts right when we basically have lifted the dummy up and are pulling our hands out to see what would occur.
We'll start from the beginning. Dr. Bolte, is this in regular speed or slow motion?
That's slowed down.
When you dropped the crash test dummy, that was the weight that you indicated, I noticed that you ducked down. What happened as you dropped the dummy?
The dummy just ended up falling. The branch did not fail. The dummy swung down, swung up. So you'll see a little bit of motion as it oscillates until it gets back to zero. Unfortunately, I did not know. I did not want a 105-pound dummy falling on my head. So I ducked.
And it's showing you what's been marked as page 5 of 6. The results with respect to the dynamic test, are those included in your report?
They are. They're bold. Kind of this sentence right here is what I thought the most important findings were, given that the branch did not fail. We ran the test twice. In science, we like to run multiple tests just to make sure that we know the correct answer or something close to that. And so we ran it twice. One time we had 6 inches of deflection. One time we had 7 inches total that it deflected before it settled back down. And the difference in those deflections is due to not knowing exactly if my son and I lifted the dummy exactly the same height each time. You know, if we had a mechanism that we could have raised it 6 inches, pulled it out, and dropped it, then you probably would see very similar findings. But you see an inch difference just because of the attempt of trying to lift the dummy and kind of throw it in the air.
And with respect to the findings regarding the deflection of the branch, what is depicted in those two graphs that I just bracketed?
So these are similar to the last figure that we showed. Again, on the bottom is time. And as in what we call the static test, I mentioned it took 1 minute and 10 seconds. You'll see that the time across the bottom is a total of 3 seconds. So this is a much quicker event, even though the video is slowed down. You'll also notice that on the mass or the weight on this side, you know, I mentioned the dummy weighs around 105 to 110 pounds, and this only reads 90. That's due to the way we had to conduct the test. My son and I had to already kind of have some of that mass in our arms when they hit go on the data recorder, so we don't really know what the zero was. And so you don't get the whole 105 pounds because we were holding some of that mass. And so that's why when it comes out, you see the dummy weighs around 50 pounds. That means my son and I were originally holding about 60 pounds in our arms when we were suspending him, if you will.
As you conducted the dynamic test, though, there's a point when you're not holding any of the weight.
Correct. And so at time 0 is back when we kind of threw the dummy up, you will, and the dummy starts to come down the branch. So the first oscillation of the first peak is kind of that initial when the dummy comes all the way down. And then you'll see the oscillations as the dummy and the branch kind of settled out. And so from this point 00 on, we are no longer holding the dummy. It is suspended.
In total, how many tests did you conduct on that same branch that day in November?
So we conducted the static test, which took 1 minute and 10 seconds. We did the first video you showed, I apologize, I forget what exhibit it was called, but the second to last video where I was just putting the USB cable around, we hung the dummy, and then we added the legs. You could call that a test, but we didn't record any data. We were just getting the dummy in position. And then we actually, I think, total ran 3 tests where we did the lift and drop. The one test, the data recorder failed and we didn't get any data. That's why it's not in the report. So in total, two static tests where the dummy was hanging, and then 3 tests that we added some energy to the dummy.
And of those 5 tests, how did the branch, was the branch able to sustain those 5 tests?
The branch did not fail, so I would say it sustained the 5 tests.
In addition to the graphs that we've talked about in your report, did you also include some photographs of the testing in your report as well?
There are photographs depicting the slipping knot and depicting how page 3, figure 2.
Showing you page 3 of 6?
Yes.
Tell the jurors what we see here in these 3 pictures.
So this is trying to show how we match the one photo that Detective Grubbs brought to the scene. And here in the middle, and I apologize, I'm not very good at this, but there you can see the end of the USB cable just sitting in the hook. And the tension of the dummy hanging off of there was able to keep that USB cable in the hook. And as I mentioned, you can see it up here a little bit. You can see the 2 cables coming up off the load cell going around the tree. The one comes and gets hooked in the hook, and you can see then the other one that was hanging down over the shoulder, which was similar to the picture that I was shown.
A couple of questions about these. How is the USB cord around the head of the crash test dummy?
This is a point that's I'm not sure if you've ever seen a crash test dummy before today, but they don't look exactly like us. The neck is metal and rubber, and there's no skin around the neck. So you see the simple, you can kind of see right here the metal going up into the head, and then there's rubber metal. So there's no skin. So when you come down on the mandible, you do not have the skin that kind of attaches your mandible down to your neck. And so it actually gave us an advantage because we could slide the cable up along that metal rubber neck and it actually hooked. A real person, it would have been much more difficult because of the skin. But on the crash test dummy, it was able to hang based on how it's built.
And you testified about images that you had seen with one of the cords hanging down. Is that also depicted in image 1 and 3?
It is, to the best of our ability and my memory of that picture.
In image 3, it seems to be a little more clear than the video, but tell us, do you see the foot or the legs of the dummy in that image?
Yes, so here is the knee of where it was taken off of the one side, and the foot for that one would be over to the dummy's right. And then this is obviously the shoe or the foot on the other leg, and the knee for that one would be over, almost as if the dummy was sitting cross-legged, but with the knees disconnected.
How long would you say you were overall at that scene in November of 2020? I believe it was the 11th.
I would say, I don't recall exactly, but I would say approximately an hour.
I think I asked you who was with you on November 8th when you first went to the scene. I didn't ask you, though, who was with you other than your son on November 11th.
So November 6th was the first time, to clarify. On November 11th, it was Detective Grubbs and Alloway again, and then myself, Dr. Yoon Siak Kang, who was there on the 6th, and then the third person was my son.
Your findings and conclusions with respect to those tests that you administered on November 11th, 2020, are those all in the report marked Defendant's Exhibit UU?
They are.
Fair and accurate copy of your report?
It is.
And the findings in your report, those are made to a reasonable degree of scientific certainty?
They are.
Just a few more questions about the report itself. After November 11th, who did you send the report to?
I sent the report in January 2021, January 31st, to Detective Grubbs.
And at any point after the report was sent, when was the next time that an individual from this case made contact with you, either by phone or email or any kind of communication?
Objection if it's to a statement. If it's to just a time or a yes or no objection, but I just want to make sure it's not being a hearsay statement. Thank you.
Just the time. When did you next hear from someone affiliated, associated with this case?
I do not recall the exact date as I stated earlier, but it was an email that I received from you.
And at some point, did you and I meet at your office?
We did.
And was that just a general time frame? I won't ask the exact date, but if you could tell the jurors.
The week following your email, we met in my office for an hour and we went through my report.
The videos that we watched today, the first 5 and the last one, how did you send those videos to me? Did you give them to me?
When you visited my office for that meeting, I gave you the photos and the videos in my report, my CV on a USB stick.
Your time today, with respect to your hourly rate, what is your hourly rate?
My hourly rate is $300 an hour.
Prior to me contacting you, as you testified to, has you done any work for the defense at all in this case?
I have not.
And when you conducted the tests and wrote this report, was this before or after you and I even meeting?
This was before we met.
Nothing further. Thank you.
Sir, I spoke with you just before your testimony, but my name is Corey Go. I'm representing the state and just have a few questions. Do you know Dr. Agnew?
I do know Dr. Agnew.
Okay. I told her I'd be nice to you today, so bear with me. I'll do my best. Have you ever done a test like this before?
No, we have not done a test like this.
Okay, so the videos, the report, this was kind of a first time trying this type of test. Is that fair?
That is a fair statement, yes.
Okay. First time you've worked with a tree like this, I think you testified to?
That is correct.
Okay. You're not a crime scene recreationist or anything of that nature, correct?
I am not. I'm a biomechanical engineer.
Okay. And your goal in performing this test was to determine whether the tree branch could hold somewhere around 100 pounds, correct?
Correct.
And that was the only goal of this test?
That was the only goal, was to see if the branch could suspend the mast without breaking or failing.
Okay. And we saw that in the videos and some of the pictures that we've walked through so far?
Correct.
Okay. Can you stand for me, sir?
Mm-hmm.
You said, how tall are you?
I'm about 6'6", if I stand the way Mom said I should.
Okay. How tall did you say the branch was when you went out there and did your initial testing?
We measured it to be 6'7".
Okay, you can have a seat. Thank you very much. A little taller than me, but that's fine. Got an extra couple inches on the ramp there, but just for the record. Again, let's talk about, you did 2 different tests. You did a static mass test 1 and then a dynamic ATD test 2, correct?
Correct.
All right. Let's first talk about the static mass test, the first test you did. All right.
Mm-hmm.
And actually, before I get there, you talked about the 2 cords you used. You used 2 10-foot cords, correct?
On the static test, we used 2 10-foot cords, correct.
Okay, and those were just USB cords?
USB standard cords, yes.
Okay, so USB on both ends?
Sorry, no. USB on one end, USB printer cable to be exact. So it was a printer end on one end, USB on the other.
And other than the 2 ends of the cord, do you recall anything else being in between those 2 ends other than just the USB cord?
Just the cable itself.
Okay. So if there are pictures of the actual cord used in this case that suggest it was a different type of cord, you wouldn't have any knowledge of that, correct?
I based what I purchased off the numbers Detective Grubbs gave me and the one picture that I was shown. So I tried to match color and as best I could.
Sure. Now, when it comes to the static mass test, again, you did that test involving two separate 10-foot cords, correct?
Correct.
Did you ever perform that test with one 20-foot cord?
No.
So you're not able to render an opinion if there would be any differences to your test based on one 20-foot longer cord versus two separate 10-foot cords, correct?
Correct.
Now, I'm going to show you what's been previously labeled Defense Exhibit VV. I'm going to zoom out first, but I'll zoom in for a couple portions here. Was this picture taken before you started adding weight to the basket?
Correct.
And there's a red circle in the middle of this picture. I'll zoom in a little bit. Can you identify what we're looking at there?
That is this interface load cell that's shown here.
And can you hold that up for the jury, please? You mentioned that there are hooks that go into the top and bottom, I believe.
So this load cell obviously has, I should know the mechanical term, but screws in a slot that you can hook other devices in. And so in the picture, you can see two turnbuckles with, it's better below the red. Right here, you can see the turnbuckle coming down and then just has a hook, a basic hook.
And that's made mostly out of metal?
It's all metal, yes.
Okay. So in looking at this picture for your first test, is it fair to say this top portion here is a 10-foot cord?
It is, but you can see the tails coming off to the left side of the picture as I look at it. This cable coming in here is this cable that goes to the load cell, but here you can see some of the extra USB cable that we did not use going off to the side.
And then the bottom portion here would be the other 10-foot cord that you described?
Correct. And we used all of that because it goes down to the middle, another attempt at a knot, and then to the four corners of the basket, trying to figure out, or at least that handles towards the corners to figure out how to suspend that mass.
And in this initial test, you described a knot. Where does the knot begin before you start loading weight?
The knot is actually, if you can see it, is right there where those other cables are coming out. So I would estimate it's about 2 inches below the bottom of the branch there.
And that was a knot that was put there so that the cord would hang up on the branch there and not move, correct?
It was so that it would stay and not slip all the way off, correct?
Okay, so again, you have no knowledge whether there was a knot in a similar or same place in our facts and circumstances, correct? Being the case.
Correct.
Okay. Now, we watched a little bit of the video, and at some point, it's fair to say that knot slips up to the tree branch, right?
Correct.
It almost takes you out along with it. How much weight was in the basket, or how much weight did you put in the basket before that knot slipped?
It slipped at the very first weight, 33 pounds.
Okay, so 33 pounds of weight caused the knot up top there to slip at least what looks like at least 6 inches up to the top of the tree.
It slipped up. I don't know the length, but yes, it slipped up, adding weight.
Okay. And again, looking at the dynamic test, there appear to be there appears to be another knot right there at the top of the basket.
Correct.
And how is the basket being held by that apparatus, we'll call it?
So as you can see on the front of the basket here, you can see a handle. There's also a handles, the same cutouts on the sides, and we just tried to route them through there and up. And to make it more difficult on ourselves, the wire actually runs through, and the wire is actually running across in the middle in here as well. Again, my degree is not in hanging a milk carton, and so it was just trying to figure out a way to suspend this and then add mass to it.
And during this test, again, we're just testing to see if the branch would hold the weight.
Correct.
So it's free hanging as opposed to being on the ground at some point.
Correct.
Except for the part where the tree branch goes down a little bit and then the whole thing kind of collapses.
Yeah, and it's because the cables slipped, the knots continued to slip, and so it ends up on the ground before we add the last weight. Correct.
Okay, so the knot continued to slip as you added just about 100 pounds of weight?
Correct.
Okay. Now, let's move then to the dynamic ATD test. Is that correct?
Correct.
And what's ATD stand for?
Anthropomorphic test device.
Okay. I'm not going to ask you what that means, but we'll call it the dynamic test, all right?
Or crash test dummy.
Okay. Now, again, let me ask you this. Did you use the same two 10-foot cords, or did you use something different when trying to test it dynamically?
In this case, we used one of those same 10-foot cables.
Okay. So again, not one 20-foot cable, but now one 10-foot
It's
cable?
one 10-foot cable, correct.
Okay. So if there is evidence in this case that there's a 20-foot cable, that would be different than the test you performed?
I only know what I did with the 10-foot cable.
That's fair. Thank you. How about, I guess, in a similar way to the static test, were there any knots in the cable as you were trying to try to do your dynamic test?
There were not any knots in the cable when we did the dynamic test. I wish I had more of this for you maybe I can show. Basically, this had a hook on the top, and we just doubled the USB cable over and then hooked this. I apologize, it's so tiny, but hooked that through the hook and then ran the two wires up and around, and then the one end hooked back in, as you see, correct, right here. So there were no knots in the test with the crash test dummy.
Okay. And I like where you just circled there. That's a metal hook.
That is a metal hook holding the plastic aspect of the end of the USB cable.
Okay. You'd agree with me that's not a plastic cylinder or tiny plastic cylinder?
On which part?
This part here, the hook part.
No, that's a metal hook.
Okay. And you would agree with me that this is a USB sort of end?
Yeah, I cannot tell from the picture. I don't remember if that's the printer end or the regular USB end, but that is one of the ends.
Okay. And again, even when doing this dynamic test, you're not trying to recreate the scene after looking at that one picture, correct?
We were trying to suspend the dummy in a similar fashion to the one picture that I was given.
And you'd agree with me that based on the one picture you saw, the person wasn't being suspended, correct?
The view of the picture, I could not tell that.
Okay. So again, you're just trying to determine whether even this dynamic test, the tree would hold 100 pounds.
Correct.
Just one moment. You obviously you used a crash test dummy that you've talked about on direct, correct?
Correct.
You didn't have anybody willing to be a human experiment in this case, right?
Correct.
And you described this crash test dummy and the neck. Can you describe that again for me?
Yeah, so the dummy has underneath that rubber type skin, and you can see here there's the back of the, I guess you would call it the skull, is a skull cap. You can pop that off to put instrumentation in the head. So beneath the rubber is a metal skull that is a certain mass to match anthropometry of occupants and vehicles. And then that attaches a metal interface in the bottom of the skull, attaches to the top of the neck. And as I mentioned, the neck is basically a layer of metal, a layer of rubber, metal, rubber that allows for a little bit of flexion, extension. If you can imagine you're in a forward-facing car crash, your head will come down and come back up. So this dummy's neck allows for front to back. But what happens is, as you can see, I apologize, there's going to be a lot of lines on this, but right in here, you can see that wire pulling up on the edge of the rubber that's covering the head. That's not realistic in a human, and that interaction is going to be slightly different in a human than it would be in this crash test dummy.
Including if a human was alive and tried to move while this was happening, correct? The dummy is not moving in any way unless you're actually implementing it or doing something to make it move, correct?
I will say that correct, the dummy's not going to move. I don't have knowledge of the human aspect of that.
Okay, that's fair. You would agree with me that the crash test dummy's head kind of makes a angle there that I guess you described allows that to sort of hook under?
Correct. The head and the neck angle is specific as if the typical angle of when you're sitting in your vehicle for your eyes to be forward with your seat at 20 degrees. So.
Okay. I think you testified to this, but you'd agree with me that's not realistic to a normal human being when you're trying to run like this type of test.
I've never ran this test on a human, so I probably cannot answer that.
Okay. You'd agree with me though, just in looking at that angle, you looking at me looking at you, that's not something that looks like a normal person, correct?
I will say the lack of skin going from the mandible down to the neck would change that interaction.
Okay. And so the connection there would be a cord up against metal as opposed to a cord up against skin.
Skin, soft tissue, correct.
Okay. Just one moment, Your Honor. I have no further questions. Thank you, sir.
No. Tell the jurors why you used a 10-foot USB cord if you could.
I believe, I'm trying to recall, either in an email or a conversation perhaps on November 6th that I was told by someone a 10-foot cable, but I cannot tell you who that was because I know I specifically was searching for a 10-foot cable.
And while you don't know the name of the person, do you know like for whom they worked?
Objection. Witness doesn't remember who he talked to, so
Well, it's
I
a
was
different
going to say who
question.
he works for.
He doesn't know the name of the person, but he may know, and we don't know what the answer will be. He may know who the person if he doesn't know where they were. If you can answer.
It would have been from when I was meeting with the detectives.
One other question about, you were asked if this was the first time that you had run this particular test. Does the fact that it's the first time that you've run this test impact your findings at all?
The fact that we've never ran this test does not impact the science and the outcome. The results are measured, the real outcomes. No, it wouldn't change that.
Thank you. Nothing further.
And so when you say the science, the outcome, you're talking about just that tree branch can hold roughly 100 pounds without failing?
That specific test that we ran, those results are solid for that test, which was to see if the branch could suspend the weight.
Certainly not anything specific to the facts and circumstances of this case, just the weight itself in the tree branch.
Correct.
Any questions Alan has for this witness?
Yeah, this guy reacted to all the information the police gave him, so no wonder some of it was bad. You know, the state's like, "Oh, you fucked it up." It's like, well, you gave me bad info, bro. I love how the prosecution tried to make it sound like a retard, and it's like, I did what you told me to do. But anyways, guys, after they're done with the questions, I'll answer some of your questions and points you brought up, especially the one about the ballistic dummy, because I think that's a good one worth answering.
few questions for you, sir. The first question is, for the dynamic test with the crash dummy, to get the correct force or weight measurement, should the force or weight value be multiplied by 2 due to only measuring force only on one side of the USB?
It's a good question. That load cell measures the amount of force that's going between the wires. And so it does not have to be multiplied by 2, I do not believe. It is fine the way it is. So.
Okay. When the knot slipped during the static test, the USB cord above the tree slipped closer together. Would this have an impact on the branch deflection?
Can you repeat the question?
Sure, absolutely. When the knot slipped during the static test, the USB cord above the tree appeared to slip closer together. Would this have an impact on the branch deflection?
So I believe the question is the 2 wires came closer together and then were touching on the tree. So we measured the motion of the tree. And so we had the initial level of the tree from the camera without any weight. And then we calculated the total deflection after all the weight was added. We didn't calculate the deflection of each part. So the deflection of the tree branch would not have been altered by that motion of those 2 cables coming together.
Do you know how much weight would have been supported by the USB cord and branch given the remains were found kneeling on the ground?
No, repeat that one more time. I apologize.
No. As many times you want me to repeat the question, you got it. Do you know how much weight would have been supported by the USB cord and the branch given that the remains were discovered in a kneeling position on the ground?
No, I do not know enough data to be able to calculate that out. And we had a limit of only being able to know what load we added to the tree during our test, so I cannot answer that question.
Would body movement possibly add more weight or pull on the branch?
So body weight, body movements, motion could cause a difference in kinetic energy, perhaps, but mass overall would not have changed. So I don't think it would have changed whether the tree would have failed or not or deflected much more, because the force, mass times acceleration would be same of the core because the acceleration is just gravity pulling down. So I do not believe that's the case.
Final question. In your experience, would a shorter cable have more or less strength than a longer cable?
I have not tested cables for strength of length, so I cannot answer that question.
Consistent with hanging milk cartons.
Yes.
All right, fair enough. Questions from the, I'm sorry, from the defense?
No, you're, thank you.
All right, from the state?
No additional, thank you.
Thank you, sir. You are excused. Thank you.
Surprised you're not gonna take a break. Brittany, you mentioned this a couple of times about the ballistic dummy. Ballistic dummies are good for ballistic purposes. I don't know if a ballistic dummy would be able to.
Your Honor, at this point, the defense rests subject to what I put on the record earlier.
All right. Ladies and gentlemen, again, we are at a point where there are some required legal matters for the court and counsel to do, which does not require your assistance. So we will take a break. I'd like to give you the timing on this. Don't think it'll be too long, but we'll bring you back in just as soon as we've concluded our work. So please remember the court's admonition, and this is your break.
Okay, so Brittany, I don't think, like, if you use the ballistic dummy, it's made out of gel, and you can put bones in it. But I don't know if it could sustain that kind of strength at a normal body. Like, it's the density of human bodies, but it's not the strength of a human body. So I don't know if you put a cord around its neck, if it would just, the gel would eat the cord and the head would pop off. I don't know how it would work. You have to do a lot of temperature controls to make sure it's accurate for ballistic testing. I don't know if there's even testing ever been done to demonstrate a ballistic dummy in that situation. I don't know if there's ever been a ballistic dummy in that situation where they've used all that stuff. So, also let me know if you guys can hear me.
On the record, outside the presence of the jury, all parties, including the defendant, are present. The defense has indicated a desire to rest. I note that there are 3 exhibits, double S.
Can you guys hear me?
Do you wish to offer those?
I do, Your Honor. I'd move to admit those two, assuming there is no objection. The videos, the CV, and the report.
All right, double S, double V, and W will be admitted into evidence. One of the things I didn't chat with you folks about was I noticed some of the evidence was presented on a computer. How do you wish to have that handled? I presume you've come to a conclusion. How do you wish to have that for jury?
I placed those exhibits on a thumb drive that's marked with a sticker just saying State's Exhibit. We can review those prior to, but it's my understanding that the jury does have a computer available to them in the jury deliberation room, and they would be able to review the exhibits in that.
All right. And I guess that would be also with W. UU.
Yes, sir.
Okay.
I thought they did screenshots of it.
Makes sense. We did the screenshots of the,
Okay.
Yep.
Just for the record, there was one video that was played by the defense. It was like a 10-second clip and it was played without sound. We had concerns that some of the sound might not have been admissible. So what the defense did was take a couple of screenshots of that section of the video and admitting those in lieu of the actual video clip itself.
Okay. That makes sense to the defense
yeah, we
in
did
terms
that.
of how you're going to handle that?
Yes, there's 4 screenshots. 5. We have them marked.
Okay. Anything further from the defense?
No, Your Honor, thank you.
Colloquy with your client.
I think we need to do the colloquy with my client, but also I just want to make sure that I reserve or re-renew the Rule 29 before I rest it. Also, I don't think it's formally been done, but I know for the record that the sides went over the exhibits together. In terms of moving all exhibits into evidence, I don't think that's formally been done, but I know that the exhibits as they now exist, there seems to be no objection from either side as to the exhibits that are now next to the court reporter that is really nice, as they say on the line.
Okay. As long as you're satisfied and the court reporter is satisfied, I won't get involved with those exhibits. I know which ones have been admitted, which are not, and we've made the record on that. Hopefully, there will be a consensus to make sure that those are correctly presented to the jury. All right, wish me to go.
Yes, please.
Mr. Moore, you can stand up or sit down, whatever you want to do. It's up to you. As you heard, the defense has rested, which means there'll be no more witness testimony in your case. What that means is you will not be testifying. And the most important aspect of what I'm sharing with you is this is a decision that you make, not necessarily your attorney. You make this decision in consultation with your counsel, but this is solely your decision whether to testify or not. I will tell you, you have a right to testify. You have a right, a constitutional right, not to testify. And the court will be instructing the jury that they may not take the fact you chose to testify against you in any way whatsoever. And I want you to be aware of these choices you have. So I would like to ask you, have you had an opportunity to discuss with your counsel privately whether or not you would be testifying?
I did.
And have you made a decision in your own mind as to which decision you'd like to make?
I have.
And that decision is that you will not be testifying in this case.
Correct.
And the court, with the understanding the court will be rendering that instruction to the jury.
Yes.
All right. Counsel satisfied with that?
No, just for the record, the instruction is the fact that the defendant has not testified cannot be used.
Did I say he did testify?
Yes.
Oh, I'm sorry. Yeah, the fact that the defendant has not testified cannot be used against him in any way. I think you and I are on the same page.
That's right.
You corrected that. Okay. All right.
Thank you.
And the court will take under advisement your request for Rule 29 motion. Does the state have any rebuttal evidence you wish to present?
No, Your Honor, we will not be calling any rebuttal witnesses.
Okay. So we're, I guess, at the point where ultimately when the jury comes back, we will be going into closing arguments. Now, I had mentioned to you on the phone, and this will be a decision you make, not me. I offered, if you wanted, to read the substantive portion of the instructions prior to closing. I have done that before. I don't know if that's the culture you folks do. So I am wide open. I offer that if you wish. Otherwise, we'll just do the traditional closing arguments, and then I read the instructions in total. Do you have any thoughts one way or the other about that?
I do, Your Honor. I like the suggestion. Is that for something new? I think it's, I like the court to give some preliminary instructions before we do a closing.
And just to make sure everyone understands what I'm saying, I will do all the instructions as you have, all the way up to the point where it says to read the verdict forms and go over those with them. I will not be doing that. That will be after I have concluded. And then what I call the boilerplate about their behavior and conduct in the jury room, that will also be done at the conclusions of all the arguments.
Does the court also send back a copy of the jury report?
Every single one of them are going to have a copy. That's the practice in this court.
Judge, the state would have no objection to that procedure either, although I would suggest, obviously, if we take a little time to have a quick break here. By the time we get them back in and we read the instructions, we're going to be very close to the lunch hour. I expect closings to go on for a good chunk of time. It would be my preference to send them to an early lunch or send them to lunch prior to closing, so they're not sitting there.
I think that's a wise decision.
Before we do that, so. My suggestion, we bring them back in, read them those preliminary instructions up to, the part about the verdict forms, send them to lunch, come back, do closings, and then start deliberating the set.
Your Honor, do you have an updated, or did you make any changes to the jury instructions after?
I'll tell you what I have done. I was not paying close attention to it as I was working on this a little bit, but nonetheless, what I have, well, first off, let me address the question on the state's first position regarding the requested instruction by the defense as it addresses the question of the defense. Now, why am I missing this here? Page 3. Okay. The requested instruction as encapsulated in here is the defendant's attorneys contend in this case that Emily Noble committed suicide. The fact those attorneys presented some evidence to you on that issue does not change the principle that the defendant has no burden of proof in this case. The burden of proving the defendant's guilt remains, as I have explained to you, on the state of Ohio. This language actually was provided to me by Judge Gormley, who is a member of the editorial board of the Jury Instruction Committee's criminal subdivision of that committee. And it's the court's belief that, generally speaking, most instructions that are supported by law or are factually appropriate, if requested, probably should be admitted. Breaking this down, it is clear that the defense attorneys have contended that Emily Noble committed suicide. That has been clearly presented in this case. The fact the attorneys presented some evidence. Now, this is not an indication as to the credibility of the evidence, but I heard a witness yesterday say you can't rule suicide out. And the testimony today from this witness, impacts the question of, was the branch of such a tensile strength that a body could be hung there if they chose to do that on their own. Nonetheless, I believe some evidence has been presented on that issue. I guess the significant point of this particular instruction is the fact that even though this has been raised by the defense has no burden. In other words, it's clearly is not an affirmative defense. So I believe it is a correct statement of the law, and the essence of it is to identify the jury that, I suppose what I just said, is not an affirmative defense, and the defense has no obligation to prove this. So it'll be a function of argument. So I'm going to allow that to stay in. The state had mentioned something about evidence does not include the indictment, opening statements, closing arguments. They are not evidence. I am proposing this following addition in light of what the state said. Questions of attorneys are not evidence, but the answers of witnesses are evidence unless the witness agrees with the facts stated by the attorney or adopts as an answer the fact or facts asked by counsel. I think that's probably a fair statement of the law as well. There was a sentence beginning on bottom of page 5, going on to page 6. I think it says, its purpose is not to supplant, but instead to supplement your judgment. I think the state requested that be removed, and I will grant that request. I am putting in the testimony, I believe this was requested, correct me if I'm wrong, the testimony of the testimony of an expert witness should be given whatever weight, if any, you feel it deserves. And I'm going to add that. Now, I'm not sure about this. I'm going to ask the state again. You gave me a copy of an instruction. And I've kind of cobbled that a bit because I don't believe there are any hypothetical questions asked in this case. So I don't need to pose that. But below that, I have added this. So it says, as trial jurors, you must determine the character, knowledge, learning, and experience of an expert witness, and you must also consider whether the force of the opinion is weakened by cross-examination. And the next paragraph is, you must determine whether the facts upon which the experts base their opinion are true. If any fact was not established, you will determine its effect upon the opinion of the experts. And I believe that's what the state was requesting. Is that fair?
I was requesting the weight instruction on that piece of paper to make sure.
Oh, you don't want that. You want the one, well, it says with other witnesses, you alone rest the duty of deciding what weight should be given to the testimony of the expert. Determining its weight, you may take into consideration their skill, experience, knowledge, veracity, familiarity with your facts, and usual rules for testing.
Your Honor, if I may, I provided that to you because defense counsel wanted the word any added to the expert witness language regarding weight.
Okay.
And I do not see that in OJI. That was the purpose. And you indicated.
Oh, you mean what I said earlier about the weight, if any? That's not going to decide the outcome of this case. I mean, the jury decides what weight, if any, to
Your
give
Honor, I'm
to
just
everybody.
making a record. Thank you.
Thank you. As to the weight, I think it's basically in here at the top of the page with this paragraph. The testimony of an expert witness should be given whatever weight, if any, you feel it deserves after you've considered the expert's skill, training, knowledge, and veracity. The degree of credit or weight to be given to the testimony of every witness, including one referred to as an expert, is a question for the jury to decide. I think that's substantially what that already says, so I think it's in there. So in spirit and an argument on your behalf, you can make the argument of what that says there. And I presume you already know this. In your arguments, you certainly have the right to quote these jury instructions, because once we've agreed to them, I will provide them as we have agreed. So if you want to quote them or use them, certainly you can. I agree with counsel's idea that we should probably break for lunch. That'll also give you all an opportunity to collect your thoughts regarding your closings. I'm not holding you to this, but I'm just asking the question, how long do you think your opening would be? And I'm not putting a time limit. This is just for thought.
I guess that depends on how much I get going. I mean, I know they don't want to listen to me any longer than they need to. I'd be shocked if I was more than an hour, maybe significantly less than that. Or just, it's hard to say. You know, obviously we've got 7 days of testimony we kind of talk about. Right?
You've answered my question. Thank you. What do you say? Again, no restrictions.
And if I understand the court's rule, the duration of my close is the duration of the state's.
I was about to go there, so.
Yes. 30 to 40 minutes.
Okay. My only restriction on time, and I don't know who is going to be doing the rebuttal, but I say to whoever it is, your rebuttal will be limited to the duration of the time of the defense closing. And I'll keep the clock on that, so you don't have to worry about it. And I'll give you a 5-minute warning if you're pushing to the end. So, okay, that's fine. So what, if you all agree, we have our instructions, as I have indicated, I will present. I'll bring the jury in, tell them that we're going to break for a lunch, tell them to come back in an hour, and I will also tell them, they'll probably like to hear this. They've heard all of the evidence in this case, and the next step in the case will be instructions of law and closing arguments. And what we'll do when they do get back is I will tell them that I'm going to provide some instructions to help provide some context to the closing arguments the counsel will provide. I will read, as I indicated. I'm not exactly sure where it ends here. There's not a whole lot left. I guess at the top of page 12, where it says discuss verdict forms. Before I get to that, I'll stop. And then, of course, obviously, when they have heard all the arguments, I will say, okay, now you've heard the initial instructions, the arguments of counsel. I want to now show you the verdict forms and tell you how those should be completed. I guess I'm going to ask you folks if you can put them up on the screen, and we'll go over those. You've all seen the verdict forms as well, right?
Yes, sir.
Okay. Okay. Everybody good with that process at this point?
Yes, sir.
Yes, sir.
And, all right. Let's bring them in.
So you don't need the instructions on the screen, just the verdict forms when we get to those later. Is that what you meant? We don't need the instructions on the screen, just the verdict forms later.
All right, so here we go. I'll leave it on for jury watch, yes. Does the jury determine how long to deliberate? That's going to be up to the judge. Some judges let them go, some
Ladies
don't.
and gentlemen, I am going to announce to you that you have now heard all of the
They might get to set their
presented in this
thing every day.
The next step in the case is for the court to provide you the instructions of the law and counsel to provide you their closing arguments. What we were going to do is to provide some context to the closing arguments. I am going to read to you a portion of the jury instructions, including the definitions of the three offenses that are alleged in this case. I want you to listen to those. You're going to get copies of these, so you don't have to take notes on what I'll be reading to you. I will do so. When I've concluded that, counsel will then give their closing arguments to you. And then when they have concluded, I will finish with the instructions that are remaining. I think all of that is going to take a significant period of time, the instructions as well as the arguments. So I think it might be appropriate before we get into that to take our noon break. So we will do this now. It'll give counsel an opportunity to put their thoughts together, give you a chance to take a nice lengthy break, understanding that we want you fresh and ready to proceed with the final portions of this trial. And then, of course, obviously, once we have concluded the closing arguments and the instructions of the law, you will then retire to begin your deliberations. So that's where we are in this case. So at this point, let's come back, get back in about an hour, about 12:20, and to the usual spot. Remember the court's admonition during your break, and we will proceed as I have just indicated. So thank you very much.
Okay, so my camera is all fucked up, so I can't do anything about that, guys. I'm sorry. So it's just gonna be we're just gonna
6 in and ask him not to discuss this. That's all we're going to do, and then we'll break. Sir, you can just stand right there. You don't need to go very far here. Juror number 6, we had discussion earlier about somebody who approached you, and we're fine with that. I just wanted to share with you that, and I didn't assume you'd do this, but we're going to make it for the record. Do not share with any other members that experience during the course of your deliberations.
Okay, that's fine.
Thank you very much. Have a good lunch, sir. All right, we're in recess.
Okay, so I hope that makes sense there. But yes, the prosecution wanted this test done to see if the cable of the branch would break so they could say, ha, it wasn't suicide. Obviously, it didn't come out that way. K. Drake 777 said the test doesn't seem precise enough, kind of amateurish. Well, it's probably the first time that test has ever been performed really in science. I mean, you also have to think about it this way. How else can you really test that out in a setting where you're actually using the actual tree and you're trying to do the actual similarities? There's only so much you can do. It's not like CSI where you've got a complete set. But even then, if this is the first time it's ever been done, it's going to be kind of ghetto. And when you think about most forensic investigation techniques, the way they started them out is pretty ghetto. So you got to start somewhere. And the prototype of anything does not usually look good. That's just kind of the nature of testing and what happens. At least that's what I would argue there. So I'd argue the test is valid for what it is. The knot was documented. Why wasn't it duplicated? I don't know, because it sounds like they didn't provide that information to the doctor when he was performing the test. They just said she was hung, and they didn't explain how she was hung. Hanged. They didn't explain how she was hanged. So, he was limited by the data they gave him, so that was kind of a garbage in, garbage out situation. Not to steal from Diana there on that, but they did not give him information he could use precisely. K. Drake, you also asked, all the prosecution would need to ask is, would you agree that testing this branch is not a precise recreation of an actual person hanging themselves? I mean, yes, and he had to admit that, but also there is no testing for that. And that wasn't what they were trying to demonstrate, was that this is the exact same reaction a person will when they hang themselves. It was, can the branch hold the weight? Could all of this even be possible? So that's where I would start with that, all that stuff. Jim, you were asking what the F kind of horse crap, pseudoscientific garbage is this? Well, this was the state trying to prove that this was a staged crime scene and that this thing really would not have held all the weight that they were asking for. So this was the prosecution trying to blow up the case early on, and it backfired. Miss Cabby, you're asking, could the branch have been weakened by the load of weight on it for 4 months? And does a change of season affect its tensile strength? Well, as far as its tensile strength, its shear factor, what kind of load bearing can that type of tree do in that diameter, in that situation, in that time of year? I don't know. I mean, remember, it's the fall in November, so that tree is pretty hard. It's gone through the growth of spring and summer, so it's harder wood now. It might be stronger, but that would be for an arborist and a tree expert to determine. As far as the weight being on the tree, remember, they did this test nearly a year after they found the body. So that tree has gone through a whole growth cycle. So that tree is nice and healthy still. Selena Lamal, you're asking perhaps the doctor should have collaborated with a tree expert. Yes, but even then, that tree expert's not necessarily going to have an idea of, what kind of forces you can apply to a branch from that particular tree, because that's not something I think any arborist or tree expert would know. Jim, one more time, you just caught up and you're disillusioned by the judge's leaps of stacking inferences to let the case continue. Remember, he can still take it away from the jury. And I think for right now, he's going to give the jury a chance. Because remember the rules, and I know we covered them yesterday, he has to look at this case and the facts in the light most favorable to the non-moving party. So he has to say, presuming all of this is true, presuming the prosecutor has made this work, could a jury make a decision? Yes. I am sorry about that, guys. Just trying to finish up. Actually, I have a kind of an emergency client meeting I have to take that something has popped up on, but I'm going to check what you guys have said in the meantime. I was muted that entire explanation. Oh, God, please don't tell me that. Oh, my God. Really? So that whole explanation about the ballistic dummies just got muted? Or are you guys just screwing with me? I think you guys are screwing with me. I could have sworn I saw my face moving. Please tell me it was a joke. Okay, good. Yeah, the test was just to show the load of the branch, and that's really what the prosecutor wanted, but then it blew up on him. Also, ghetto testing. It's not really even ghetto testing. It's just, how would you test this? There aren't dummies. There aren't cadavers. It's not like you could find a body to get a hold of. You can ligature it the exact same way. You would need to ligature her in a way that she's got the same bone density issues. I mean, you would need to do a 1-for-1 if you're grabbing a cadaver, and that doesn't work that way. So, yeah, it's go back through and learn about crash reconstruction or anything like that. It was all ghetto to start with. So, yes, they're going to do jury instructions. The judge is going to read through all the boring shit at first, and then the defense and the prosecutor are going to go. Guys, I will be back in probably about 25 minutes. So let me get back to you guys in a minute. Miss Cabby, yes, he can dismiss, and I covered this yesterday. He can dismiss it. He can acquit the guy he can acquit Matt after the jury returns a guilty verdict. He can acquit him while the jury's deliberating, or even after the case is done, he can come back and still dismiss the charges and acquit him. There's a bunch of different ways. So, anyway, guys, I have to take this meeting. I will be back in a couple of minutes. So, bye for right now.
Thank you. Have a seat. Ladies and gentlemen, we are at a very important stage of these proceedings. As I've indicated previously, you've heard all of the evidence that you will hear in this case, and many exhibits have been admitted into evidence, which you'll also have the opportunity to review in your role as the judges of the facts. We're at the stage of the proceedings, as I indicated, where you hear closing arguments of counsel and instructions of law from the court. Counsel have agreed and asked me to begin these proceedings with reading a portion of the instructions to you, definitions, as well as definitions of the 3 offenses that are alleged in this case. I'm doing this so that you can perhaps have a more contextual understanding of what the counsel will be arguing as to the nature of the charges and definitions of terms in that. So I am going to read part of your instructions, and when I've concluded that, then I will turn it over to counsel where they will give you their closing arguments. I want to share with you, if you don't know, in the back of your folders are, okay, you know this already, okay, good, are your jury instructions. So if you'd like to read along or just listen, you're always, obviously you're going to have copies of the instructions which you will take into the jury room with you to review as you feel appropriate. But this round, I just want to initially share with you verbally the instructions of the court that I think, again, will help you listening and provide some context to what counsel share with you. Members of the jury, you've heard the evidence, and it is now my duty to instruct you on the law that applies to this case. You and I have separate and distinct functions to perform in the trial of this or any other lawsuit. It is your function to decide the disputed questions of fact, and it is my function to provide you with the appropriate instructions of law. It is your sworn duty to accept these instructions on the law and to apply the law in the way that I will explain to you. You are not permitted to change the law or to apply your own conception of what you think the law ought to be. The grand jury of this county has issued an indictment against the defendant, Matheau Moore, charging him with 2 counts of murder and 1 count of felonious assault. As was mentioned to you during the course of jury selection process, a criminal case, at least here at this court, begins with the filing of an indictment. The function of an indictment is to inform any given defendant that he has been charged with the commission of crime or crimes. The fact that an indictment was filed against Mr. Moore must not and cannot be considered by you for any purpose whatsoever. No inference may be drawn by you from the fact that an indictment listing the criminal charges against this defendant has been filed. To the charges set forth in the indictment, the defendant has entered pleas of not guilty, which means he denies the charges set forth in the indictment as well as each and every essential element of those charges. By doing so, he has cast upon the state of Ohio the burden of proving beyond a reasonable doubt each and every essential element of the offenses charged in the indictment. I earlier explained to you the presumption of innocence and the standard of proof required in a criminal case. I will now review those 2 concepts with you. First of all, ladies and gentlemen, the defendant is presumed to be not guilty unless his guilt is established beyond a reasonable doubt. The defendant must be acquitted, that is, found not guilty, unless the state of Ohio has produced evidence that convinces all 12 members of the jury beyond a reasonable doubt of each and every essential element of each and every offense charged in the indictment. Reasonable doubt is present when, after you've carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based upon reason and common sense. It is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of their own affairs. The defendant's attorneys contend in this case that Emily Noble committed suicide. The fact that the attorneys presented some evidence to you on that issue does not change the principle that the defendant has no burden of proof in this case. The burden of proving the defendant's guilt as to each and every count remains, as I have previously explained to you, on the state of Ohio. Let us now consider the matter of evidence. Evidence is all of the testimony received from the witnesses, and it includes exhibits admitted during the course of the trial. Evidence may be direct, circumstantial, or both. Direct evidence includes testimony given by a witness who has seen or heard the facts to which that witness has testified. It includes all of the exhibits admitted into evidence. Circumstantial evidence, on the other hand, is the proof of facts or circumstances by direct evidence from which you, the members of the jury, may reasonably infer other related or connected facts that naturally and logically follow according to the common human experience. To infer or to make an inference is to reach a reasonable conclusion or deduction of fact, which you may, but are not required to make from other facts that you find have been established by direct evidence. You may infer a fact or facts or reach a reasonable conclusion about a fact or facts only from other facts or circumstances that have been proven by the greater weight of the evidence. But you may not actually proven beyond a reasonable doubt. But you may not infer a fact or facts or make inferences to reach a conclusion about a fact or facts from a speculative or remote basis that has not been established by the greater weight of the evidence. Nor may you build one inference upon another inference. You may, however, draw more than one inference from the same facts or circumstances. Whether an inference is made rests entirely with you, the members of the jury. Ladies and gentlemen, I advise you that direct evidence and circumstantial evidence are of equal weight and probative value. The evidence does not include the indictment, the opening statements, or the closing arguments of counsel. Opening statements and closing arguments are designed to assist you, but they are not in and of themselves evidence. Questions of attorneys are not evidence, but the answers of witnesses are evidence. Unless the witness agrees with the facts stated by the attorney or adopts an answer, the fact or facts asked by counsel. You must not speculate as to why the court sustained any objection to any question or what the answer to that question might have been. You may not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. Any statements or answers that were stricken by the court are not evidence and must be treated as though you never heard them. You, the members of the jury, are the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the evidence. To weigh the evidence, you must consider the credibility of each witness. You will use the tests of truthfulness, which you are accustomed to using in your daily lives. These tests include the appearance of the witness on the stand, their manner of testifying, the reasonableness of the witness testimony, the opportunity the witness had to see, hear, and know the things concerning which they testify, their accuracy of memory, their frankness or lack of it, their intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony of each witness. Using these tests, you will assign to the testimony of each witness whatever weight you deem proper. It is not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify. The fact that the defendant did not testify must not and cannot be considered by you for any purpose whatsoever, and you must not draw any inferences whatsoever from the fact he did not testify. You are not required to believe the testimony of any witness simply because that witness took an oath to tell the truth. You may believe or disbelieve all or any part of the testimony of any witness. It is your role to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of one witness, if believed by you, can be sufficient to prove any disputed fact. Allow me next to briefly comment upon certain expert testimony presented in this case. In the law, there are persons who are generally referred to as expert witnesses. Individuals who follow a profession or special line of work because of their training, knowledge, education, and experience in their profession are permitted to express opinions that the ordinary lay witness is not permitted to express. The purpose of expert testimony is to assist you in arriving at a just and correct verdict. If an expert's testimony has the effect of aiding you in your deliberations, it should be used. The testimony of an expert witness should be given whatever weight, if any, you feel it deserves after you've considered the expert's skill, training, knowledge, and veracity. The degree of credit or weight to be given to the testimony of every witness, including one referred to as an expert, is a question solely for you to decide. As trial jurors, you must determine the character, knowledge, learning, and experience of any expert witness, and you must also consider whether the force of the witness' opinion was weakened by cross-examination. The conclusions and opinions of an expert witness should be carefully weighed and scrutinized. You may, if the evidence in the case seems to justify it, accept and follow an expert's conclusions and opinions in whole or in part. Or if you deem otherwise, you may reject those conclusions and opinions entirely. Whatever course you follow should result from a careful and conscientious consideration of all the facts and circumstances in evidence, and not as a result of any arbitrary or capricious action on your part. Many exhibits and testimony relating to them have been introduced. You will determine what weight, if any, the exhibits should receive in light of the other evidence. The indictment in this case lists a particular pair of dates when the offenses are alleged to have occurred. It is not necessary for the state of Ohio to prove that the crimes were committed on the exact dates listed in the indictment. Rather, it is sufficient for the state of Ohio to prove that the crimes took place on a date or dates reasonably near the dates set forth in the indictment. Further, the indictment charges that the crimes took place in Delaware County, Ohio. Ohio law provides that the trial of a criminal case in the state must be held in the court having jurisdiction over the subject matter and in the territory where the offenses or any of the elements of the offenses are alleged to have been committed. Therefore, the right of this court to try the defendant depends on proof that the crime or any element of the crimes took place in Delaware County. Count 1, murder. Count 1 of the indictment charges this defendant, Matheau L. Moore, with the offense of murder. Before you can find the defendant guilty on this charge, the state of Ohio must prove to each member of this jury beyond a reasonable doubt that 1, during the period of May 24, 2020 through May 25, 2020, 2, in Delaware County, Ohio, 3, the defendant, Matheau L. Moore, 4, purposely caused the death of Emily Noble. In stating to you those essential elements of the crime of murder, I have just used some specific terms, and I will now explain these terms further for you. A person acts purposely when it is his specific intention to cause a certain result. Purpose is a decision of the mind due to an act with a conscious intent to produce a particular result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to him unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means used, and all the other facts and circumstances in evidence. Cause is an act or failure to act that in a natural and continuous sequence directly produces a particular outcome and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of his actions or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from his actions or his failure to act. If after considering all of the evidence, you find that the state of Ohio has proven beyond a reasonable doubt each and every essential element of the crime of murder as charged in count 1, then it is your duty to find the defendant guilty on that charge. If, after considering all the evidence, you find the state of Ohio did not prove beyond a reasonable doubt any one of the essential elements of the crime of murder as charged in count 1, then it will be your duty of this jury to find the defendant not guilty of this charge. Count 2, murder. Count 2 of the indictment charges this defendant, Matheau L. Moore, with the offense of murder. Before you can find the defendant guilty on this charge, the state of Ohio must prove to each member of this jury beyond a reasonable doubt that, 1, during the period of May 24, 2020 through May 25, 2020, and in Delaware County, Ohio, the defendant, Matheau L. Moore, caused the death of Emily Noble as a proximate result of the defendant's having committed the offense of felonious assault. I have already provided you the definition of the term cause, and you should rely on that earlier explanation and utilize that when deliberating on count 2. A proximate result is an outcome that is a natural, logical, and reasonably foreseeable, rather than one that is surprising or extraordinary. A proximate result is one that could, in light of ordinary experience, reasonably be anticipated by an ordinarily prudent person, meaning a sensible person or a person of sound judgment under the circumstances. To commit the offense of felonious assault means to knowingly cause serious physical harm to another person. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably be of a certain nature or will probably cause a certain result. A person has knowledge of circumstances when he is aware those circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. Serious physical harm means any of the following. A, any physical harm that carries a substantial risk of death. B, any physical harm that involves some permanent incapacity, whether partial or total, that involves some temporary, substantial incapacity. C, any physical harm that involves some permanent disfigurement or that involves some temporary, serious disfigurement. D, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Physical harm means any injury, illness, or other physiological impairment, regardless of its gravity or duration. A substantial risk means a strong possibility, as contrasted with a remote or even a significant possibility, that a particular result may occur or that particular circumstances may exist. If after considering all the evidence, you find the state of Ohio has proven beyond a reasonable doubt each and every essential element of the crime of murder is charged in count 2, then it will be your duty to find the defendant guilty on that charge. If after considering all the evidence, you find the state of Ohio did not prove by a reasonable doubt any one of the essential elements of the crime of murder is charged in count 2, then it will be your duty by this jury to find the defendant not guilty of that charge. Count 3, felonious assault. Count 3 of the indictment charges this defendant, Matheau Moore, with the offense of felonious assault. Before you can find the defendant guilty on this charge, the state of Ohio must prove to each member of the jury beyond a reasonable doubt that during the period of May 24, 2020 through May 25, 2020, and in Delaware County, Ohio, the defendant Matheau L. Moore knowingly caused serious physical harm to Emily Noble. I have already provided you the definitions of the terms knowingly, cause, and serious physical harm, as well as the terms physical harm, substantial risk, and the definition of serious physical harm. You should rely on those earlier explanations and utilize them as you deliberate on count 3. Again, if after considering all the evidence, you find the state of Ohio has proved beyond a reasonable doubt each and every essential element of the crime of felonious assault is charged in count 3, then it will be your duty of this jury to find the defendant guilty on that charge. If after considering all the evidence, you find the state of Ohio did not prove beyond a reasonable doubt any one of the essential elements of the crime of felonious assault as charged in count 3, then it will be your duty it'll be the duty of this jury to find the defendant not guilty of that charge. As to each of these charges, proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. The charges set forth in this indictment are separate and distinct. You must consider each of the charges and the evidence applicable to them separately, and you must state your findings as to each charge without being influenced by your verdict on the other 2 charges. The defendant may be found guilty or not guilty of none, one, or more than one, or all of the charges in the indictment. Now that completes the preliminary instructions I'm going to share with you before closing arguments, and as you see, I will give you further instructions at the close of all the closing. Now, in regard to closing arguments, because the state has the burden of proof, they will have the opportunity to speak to you first. And at the conclusion of the arguments presented by the state, the defense will then have an opportunity to provide their closing argument to you. And likewise, because the state has the burden of proof, the law of Ohio permits the state to provide what's known as a rebuttal closing argument. I want you to listen carefully to what all counsel say, utilize it as you feel appropriate, but again, as you well know, I caution you that closing arguments as opening statements are not evidence, and you may not use what is said in closing argument by itself unless connected to a fact found by you to have been presented during this trial in the course of your deliberations. This time, please give your attention to counsel for the state, Mr. Sleeper.
Ladies and gentlemen, my colleague started this trial all the way back with the opening statement, talking about a book and skipping to the end and looking at things. I'd like to talk about something a little different. I'd like to talk to you about a movie. There's a movie called The Usual Suspects. Came out in the mid-90s, where Kevin Spacey is the main character, and the point of the story is he's narrating or discussing events while he's sitting in a police station. Now, spoiler alert on this 30-year-old movie is that at the end of the day, it turns out that Kevin Spacey's character was the main criminal mastermind the entire time. It only becomes clear as he walks out of the police station at the end of the movie that the detective then looks and realizes that Kevin Spacey was weaving together a story based on a word that was on the bottom of a coffee cup and some things that were posted on a bulletin board. Only at the very end of the movie then do you see the revelation. And then you can go back and look at the things that happened early on. And suddenly it all starts to make sense. And you see how those pieces fit together that you missed the first time. Now, ladies and gentlemen, in presenting a criminal case, we, as a state, have the burden of proof, and we have to call witnesses to bring to you the evidence in the case. Each witness brings their own piece or pieces of the puzzle. Now, you'd be forgiven for the first week of this case, wondering what was going on. These witnesses seemingly coming in and just throwing random pieces of a puzzle onto a table. What's it leading to? What's the point? I submit to you that when you get to the end, it all starts to make sense. And so what's the first thing you have to do when you're putting together a puzzle? You got to put together the border. You got to understand what you're working with. What are you looking at? Ladies and gentlemen, there's only two possible borders here to this puzzle. One is Emily Noble committed suicide. The other is Emily Noble died of a homicide. Let's talk about that. Emily Noble died of multiple injuries to her face and neck. That's uncontroverted testimony. Nothing to dispute the cause of death. This isn't a situation where she walked into the woods, had a heart attack, and fell into a cable that happened to be strung up from a tree branch. She's dead because of the injuries she sustained to her neck. And there's no accidental explanation for how they occurred. So there's two options, and only two options. She sustained those injuries to her neck because of suicide, or she sustained those injuries to her neck because of homicide. That's it, period. Those are the two choices. Now, the state of Ohio has the burden of proof. It's beyond a reasonable doubt. And we don't shy away from that burden. And the judge has instructed you, and it's absolutely correct. Just because the defense put on some evidence, and just because they raise this argument of suicide, doesn't shift the burden to them in any way. It's our job to disprove suicide beyond a reasonable doubt. But when you listen to their arguments, when you listen to the testimony they did present, you have to ask yourself, was it reasonable? Does it make any sense in light of the other testimony? Ladies and gentlemen, I submit to you that the evidence is clear and that it proves beyond a reasonable doubt that Emily Noble did not die of suicide. And let's talk about how you know that. First of all, there's no note. No communication of any kind with anyone. Hey, I'm really struggling. Hey, I'm having bad days. Hey, I just don't know if I can go on anymore. No goodbyes to loved ones. No explanation. Nothing. Nothing whatsoever. You'll have search history on her phone for 6 months, roughly. What's on there? Not a single thing about suicide. Nothing. It's about plants and weeds and foraging. Well, wait a second. There is that T-shirt with a quote on it about going into the woods. That's it? That's the evidence of suicide? That she was thinking of suicide? That she looked at a T-shirt with a quote about the woods sometime in February? That's ridiculous. Nothing on that phone whatsoever to suggest that she's suicidal. Who else tells you that? Her friends. Now, guess what? The only person who could come in and talk about how she was doing the entire time is dead. Emily Noble's dead. She can't come talk to you about everything. So we have to bring in people that know snapshots, pieces, that see her at various times throughout the years. And what they all tell you. Did any one of them come in and tell you that they had concerns that she was suicidal? Concerns that she was going to harm herself? No. And you know who else tells you that? You know who else tells you that? The defendant. You know when he tells you? The 911 call. He calls right away and he's talking to the dispatcher and they say, did you guys have an argument? No. Well, no. Oh, was she depressed? No. He tells the dispatcher right away when he calls law enforcement that his wife was not depressed. When Officer Hollis responds to the scene, he tells him that She was the squarest, straightest person he knows. Now, later on when he's talking about it, he's asked, well, she's an emotional person, but no more than any other woman. Even the defendant doesn't bring forth right away talking about her being depressed or being suicidal. Nothing. Nothing. Now, Emily Noble had been through a lot of trauma. No dispute about that. Awful, awful things. Starting from friends dying of AIDS in the 90s, her first husband killing himself, her dad slipping and falling and hitting his head and never recovering, her mom dying in a car wreck less than a year later. Terrible things. But what do you hear about that? That each time Emily Noble overcame that tragedy, overcame that trauma, and continued on to see the joy in life and the bright things in the world. She got through it every single time, until she married that man. And now suddenly she doesn't survive the trauma. Who was the first witness you heard from? Amy Thomas, Emily's sister. And she told you about their relationship, about they've been around. And she told you that Emily had seen what happens to the people who are left behind when someone commits suicide. You know that. Her first husband committed suicide. Her stepson committed suicide. She knows what happens. And she had conversations on multiple occasions with Amy where she promised that she would never harm herself, that she would never commit suicide.
But did she?
So what is it that would allegedly lead her to commit suicide in this instance? Well, it's Joey, the stepson she lived with for a little over a year. That's the one she can't overcome? Now, the defendant, in what I would submit to you is one of the biggest understatements I've ever heard, says in his interview, after my son died, there was some tension and stress. She dealt with it differently than I did.
This is why you don't make statements.
Yeah. How did Emily deal with it? Emily took time off work. Emily went to counseling. Emily told the counselor repeatedly that she was concerned for her husband's well-being. Now, you're going to have some records of some of these counseling records presented to you with no context, no testimony, but they contain in there statements that Emily made to her therapist. Look at them. There's not a single mention anywhere in there of suicidal thoughts or suicidal ideation. Not a single one. In fact, what they submit to you show is somebody who was going there, working through the issues, and reported getting better, who went back to work part-time and then says that she's ready to go back to work full-time. They reflect that she's trying to eat healthy, that she's doing yoga, that she's going out into nature, that she's doing the things that she needs to do to put herself on the right path. And what's the defendant's dealing with it differently? He's unemployed, sitting at home, getting drunk. Just ask yourself for a second. We told you that somebody in that house, that one of these two adults committed suicide? Isn't it more likely to be the defendant? The one whose own son committed suicide, who never sought counseling, who never did anything to address the issues, would sit at home and drink. But instead, they want you to believe that the individual who confronted those issues, who sought therapy, who was doing things to get better, is the one who just couldn't take it. That's not reasonable. That's ridiculous. You heard repeatedly that Emily was healthy, was working out, was taking walks. She's eating dandelions and weeds and other things, which is apparently healthy for you. Probably better than I've been eating in the last 2 weeks. But you heard testimony that she said she was in the best shape of her life. And what'd you hear? Celeste said that Emily had a pin taken out of her ankle. That she finally didn't have that pain anymore. You can see on the body cam when they discuss that, the defendant doesn't even really know if his wife has a doctor. Doesn't seem to really know or care where she works or know any of her coworkers or any of that. But Celeste does. And wouldn't you know it? Wouldn't you know it? The forensic anthropologist at Ohio State, Dr. Agnew, looks at those remains and says, there's evidence of previous hardware in the ankle that's no longer there. Emily was in a great place. What about any of this would lead you for a second to think that she was going to commit suicide? She was going to kill herself. And what about the timing? What about the timing? May 24th, Emily's birthday. May 25th, the other day that she and her sister Amy are the same age. May 26th, Amy's birthday. You heard testimony that this was a special time for them every year of their lives, from the very beginning when Emily was brought home from the hospital on Amy's birthday. That they would call and talk and have a special conversation, that they're the same age in those days. This wasn't a random day or a random time for Emily Noble. These dates were important to her, meaningful to her. So remember that sister that she promised that she would never commit suicide to? Now Emily, without warning, without speaking to anyone, without a note, goes off and hangs herself during that special time? To do what? Inflict maximum pain on her sister? Why in the world, if she was going to commit suicide, would she do it then? That's a special and happy time for her. Not a time when she would harm herself. Let's talk briefly right now about the defendant's version of events, and as you might imagine, we'll come back to this again later. But what's the defendant say? You gotta love the body cam. Gotta love the body cam because it shows you what the defendant's saying, how he's acting, and you can see those interactions inside the house. And I'll tell you what, I want you to go back and watch this. Officer Hollis is inside the house. And he looks in to the master bedroom and he says, the bed's made. I submit to you the defendant, before he even walks around to where he can see, before he even looks in there, he goes, oh yeah, I just noticed that. I just noticed that. And then he says, she must have made the bed. Because remember, his version of events is they come home from uptown, they have sex, they go to bed, he wakes up in the middle of the night, has to go pee, goes out in the other room, right? So his version of events is his wife, Emily Noble, was in that bed sleeping around 1:30 in the morning. But that bed is made. So, oh yeah, she must have made the bed. So, ladies and gentlemen, the person who has repeatedly triumphed over trauma in her life, the person who has sought treatment, the person who is, by the defendant's own words, is not depressed or had never said anything that would have caused him to call law enforcement to try to get his wife help that she was going to harm herself, the person who's healthy and in the best shape of her life, the person who just went out to celebrate her birthday, who's celebrating a special time of year in her life. She wakes up randomly in the morning, never touches her phone to respond to any other questions or comment or texts that she'd received, makes herself a drink, makes the bed, and wanders off into the woods to hang herself. Really? What part of that is a reasonable explanation of what happened? What part of that is reasonable? I submit to you it's not reasonable. It's ridiculous. But guess what, ladies and gentlemen? You don't even have to stop there. You heard from a man named Dr. Smock. Let me briefly summarize his testimony. That cord, that ligature, it is impossible for it to cause the injuries to Emily Noble's neck. He says the quadruple fracture pattern, the fracture on both sides of the hyoid and both sides of the thyroid cartilage, has never been documented in somebody under 100 pounds in an incomplete hanging. In fact, he tells you in one study, they didn't even document a single fracture of any kind in the neck for any hanging of an individual under 110 pounds. Even complete hangings where the full body weight is being put on that ligature in the neck. Not a single one. Allow me to briefly summarize the cross-examination of Dr. Smock. He spelled Dr. Harden's name wrong. All of the bluster, all of the theatrics, it all crumbled when confronted with the testimony of Dr. Smock, who I'd submit to you is the single most qualified person that you heard from in this entire trial. He is the expert on these things. On strangulation, on staged crime scenes. And he tells you, based on his training and experience from all over the world, that this is a staged suicide. And what's the response to that? Dr. Garvin, I'd submit to you she's board certified in garbage in, garbage out. She didn't do a full analysis. She did what she termed a case review and spent a lot of time on the witness stand talking about that case review. It contained earth-shattering revelations that Dr. Agnew didn't use 2 standard deviations when determining the age of the remains, or that she only used one method in determining the ancestry. Who cares? On cross-examination, Dr. Garvin admitted that none of that impacted her ability to review the trauma in the case. Well, the pictures of the trauma anyway, of course, because she didn't bother to look at the actual bones, but the pictures. For all the talk that she had about best practices of not using hydrogen peroxide, and if you read that, it actually talks about not using hydrogen peroxide because you want to consider the possible hazards to the user of the substance, not of the bones. But for all that talk of best practices, she didn't follow the simplest, most straightforward best practice in forensic anthropology. Look at the bones. Look at the bones. So she looks at 2D pictures of this. And what'd she say? Well, she assumed that they were gone. She testified that she has spent 50 hours researching and looking at things here and talking to colleagues and all that, but never once at any point thought, man, I've looked at these pictures and I don't see the same thing as the person who actually looked at the bones. Maybe I should ask to look at the bones. No. Let's talk about two parts of her report that matter. The facial fractures, the nose. One person came in and told you they examined the bones under a microscope. They told you that, as you can imagine, sometimes you have to turn things, look, get it in a different light, look at it from a different angle to be able to see all the detail. That's what Dr. Agnew did. Dr. Garvin took a piece of paper and looked at it and said, I don't see the same thing that person did who was actually looking at the bones, following the best practices. It's one thing to look at a photograph and say, you know what? I see the same thing that person did that looked at the actual bones. And spoiler alert, that's what Dr. Garvin says with regard to the injuries of the neck. It's something entirely different to say, I'm looking at this photograph and I don't see it. And then look at the way that she wrote it in her report. No evidence of perimortem trauma to the craniofacial region. But in all the rest of the report, it's no definitive evidence. No definitive evidence. Not the same thing as saying no evidence whatsoever. Now, ladies and gentlemen, obviously, the facial trauma would be a good fact for the state because you don't get a fracture in your nose from putting a cord around your neck in a suicidal hang. But don't for a second think that that's the linchpin of this entire case. The nose fractures aren't what caused the death. That's what happened in the neck. Now, I want you to see if you can spot the difference in these two sentences. One, I did not see anything inconsistent with perimortem trauma to the thyroid cartilage and the hyaloid. Or, I agree that the thyroid cartilage and hyaloid fractures are perimortem. The first one was Dr. Garvin's testimony on direct examination. Made it sound like she just didn't see anything to dispute Dr. Agnew's qualifications. But in her report, she literally wrote that she agrees that those are perimortem. So what does she attempt to tell you then about those perimortem fractures? That you can't rule out hanging as the cause. Why? Because somewhere a 240-pound man had those fractures in a hanging? Dr. Garvin can write, she can choose any study she wants. and writing her report, she's under no obligation to spell out everything she's ever read or where she's ever gone or anything she's ever learned. She's not to type it all out. But she chose to type out something in support of her conclusion. She picked one study that she says supports what she's talking about. And ladies and gentlemen, that study says nothing of the sort. The Zetepkova study, in reviewing 178 cases of hanging, found the quadruple fracture pattern in 3.4% of cases. So already we're talking about in the study that she cited, 96% of hangings did not have those fractures. 96%.
Probably should let them do that.
It was important to determine how many of those were incomplete and how many of them were complete hangings. So she emailed the study author. And they wrote back. 3 out of the 6. 3 were incomplete. But that's not all they wrote. Ladies and gentlemen, I submit to you there's a thing that's called a lie of omission. It's when you give a statement that's true, but you admit the other important facts. You're not outright saying something that's not true. When Dr. Garvin wrote in her report 3 out of the 6 were incomplete hangings, that is true. But what'd she leave out? The next part, that the author of the study in his one sentence reply said, by the way, 2 of them are overweight. She leaves that out of her report, but admits that age-adjusted weight is a statistically significant factor in determining whether or not you're going to see fractures. Even worse, that study cites another study that says in cases of individuals under 110 pounds, they didn't find a single fracture. Not a one. When you look at the underlying data of the study she cites, it's clear it doesn't support the conclusion. Even within that study, there's something that directly contradicts what Dr. Garvin ends up telling. Because again, we don't care if somebody somewhere in a hanging had that quadruple fracture pattern. Who cares if it's happened ever? What's important is, did it happen to Emily Noble? Did it happen to this 100-pound female who is in an incomplete hanging? And you'll recall Dr. Smock testified, and he said, there is no such case documented anywhere. There is no such case. And who agreed with him? Dr. Garvin. I asked her on cross-examination if in the 50 hours of searching and the talking to colleagues, if you'd found a single study that ever had an individual under 100 pounds with this quadruple fracture pattern, you would have brought it with you to court. She said yes. The fact you don't have that tells you all you need to know. Even more evidence that this isn't suicide. That proves beyond a reasonable doubt that it's not suicide. Dr. Hickman, the Delaware County coroner. Now, you've heard some questions that seem to give the implication that somehow the state paid for an expert report, and after that, then Dr. Hickman issues a death certificate. But that's not what Dr. Hickman tells you. Dr. Hickman tells you that when he got the report initially talking about the quadruple fractures, he already in mind was saying, this is not suicide. Dr. Hickman might have been the only witness in this trial that really did a good job explaining what this hanging would have looked like. For as many times as defense counsel was down on the ground demonstrating the position of Emily's body, I didn't see her a single time show what would have had to happen to put the weight on the neck, to constrict that ligature. Because it isn't enough to say, I've got a cord tied around the tree and I just rest my head in it. I'm going to do something to put pressure on the neck. And how did Dr. Hickman describe that? That it's a lean into, that you have to lean into the cord, into the ligature. In a complete hanging, you're on a chair or a stool or something gets kicked out from under you and you can't touch the ground, all of your body weight is in the neck. In an incomplete hanging, not all of your body weight is there. And just having a cord around your neck and staying on the ground doesn't do anything. You got to lean into it. You got to do something to make that pressure. And ladies and gentlemen, look at the photos. No end of the cord is tied around the tree. One, what I call the traditional USB is down on Lee Noble's back. The other end of the cord, what I call a micro USB, the Detective Grubb said fit into some of the old cell phone devices in the house, has this fat plastic piece on it. And you'll have the real cord. Get it out and look at it. The only thing holding that entire contraption together, loop tied.
She should be objecting.
Hanging down from the tree.
That is not the same cord. She should object.
That plastic piece caught, just like that. Not tied, not knotted, just that. This fat plastic piece caught on the loop. Ladies and gentlemen, you don't need to be a doctor. You don't need to have any specialized knowledge to look at that and say, that's ridiculous. That's not a manner in which anyone would hang themselves. It's not a way that somebody would commit suicide. Emily Noble's death was not suicide. Would submit to you that that's what the evidence proves beyond reasonable doubt. It was not suicide. Dr. Smock tells you that. He says this was a staged suicide. No one else. Dr. Hickman tells you this is a homicide. This is manual strangulation. The defense witness isn't in a position to opine on that. A forensic anthropologist doesn't tell you cause or manner of death. The only thing that Dr. Garvin is saying is that you can't rule out hanging as a mechanism. Not suicidal hanging, not anything else, just saying a hanging can't be ruled out. And again, I'd submit to you that her opinion is not supported by anything that you've heard of any of the literature, and it's not supported by the only thing that she cited in her own study. So, ladies and gentlemen, if this is not suicide, what is it? It's a homicide. In order for someone to be held criminally liable in the state of Ohio for a homicide, we have some statutes. And the ones we're talking about here are murder. And I wanted to give you a little piece of it just to help orient and understand what we're talking about. Count 1, murder. Count 2, murder. They are both called murder, but they have different elements, different things to look at. Count 1 of murder is for purposely causing the death of Emily Noble. And you heard the definition of purpose. Purposely is when it's your specific intention to cause a certain result. Now, what do you have that reflects on purpose? Dr. Smock tells you what it takes to strangle someone to death. It's not an accident. It's not a brief process. In order to strangle someone to death, you must maintain continuous pressure for somewhere between a minute and 2 minutes to cause death. That's purpose, ladies and gentlemen. It says, the purpose with which a person does an act is known only to him unless he expresses it to others or indicates it by his conduct. Anyone who is causing a death by manual strangulation must maintain that pressure for more than a minute. That's done purposely. Count 2, the other murder statute, doesn't require that proof of purpose. It requires proof that the death was the proximate cause of a felonious assault that you'll see in count 3. So 2 and 3 go together. If you find the defendant is guilty of felonious assault for knowingly causing serious physical harm, then you have to look and see if that serious physical harm led to the death. That's what the difference is between count 1 murder and count 2 murder. And again, you heard the testimony of Dr. Smock about the dangers of strangulation, about what happens as you put your hands or arm around someone's neck and squeeze. What happens to blood flow? What happens to oxygen flow? What happens with risks of hospitalization and death? That's serious physical harm. So even if you weren't convinced that this is a purposeful murder, if you're convinced that the defendant knowingly caused serious physical harm to Emily Noble, and that as a result of that offense, as a proximate result, she died, that's still murder in count 2. Now, ladies and gentlemen, we put together the board. We put together the outside of the pieces of the puzzle. This is not suicide. And now I ask you to look at the other pieces. Look at the other evidence now through that lens. Now that you know this is not suicide, let's look at the other pieces. This is a staged suicide scene. Who on planet Earth would have an incentive to stage a suicide other than the defendant? Random, unknown suspect, the Westerville strangler who's manually strangling women in the woods, wouldn't take the time, the effort, the care to stage a suicide. What would be the point? Who else, a random other individual, would have the tools and the items nearby or ready at hand in order to stage a suicide? The only person The only person that would have any incentive to do that is the defendant. But it's not just staging the scene in the woods. I'd submit to you the evidence shows he was staging the scene the whole time. What do I mean? The defense version of events is that his wife, sometime after 1:30 in the morning, because that's when he saw her when he went to the other room, had to get up and go hang herself. Now, what do you need first? You need an opportunity for your wife to get up and leave the house without you knowing about it. Right? If you're awake, she couldn't have left without you knowing. So what's he say? Well, I went to sleep in the other room. What's he say? I took a sleeping pill. And he texts that even to a friend of his. Oh, I'm about to be out. I took my pill. And then he says he slept in unusually or abnormally late. How convenient. How convenient that the one day you sleep in is the day that your wife decides to get up in the morning and wander off into the woods and hang herself. So he's staging that scene with the text message that he sends to his friend, and he's staging that scene with his story about, I can't possibly know what happened early in the morning with my wife because I was sleeping later than I normally do. What else do you need? You can't know where your wife is when you wake up. They live in an 800 or 900 square foot condo. You saw how small it is. You wake up in the morning, you go to the bathroom and look out the door. Oh, hey, my wife's not here. But no, that's not the testimony. What's he tell you that he did? What's he tell you? I woke up and I was laying in bed, and instead of getting off the couch and talking to my wife about our plans for the day, I texted her, are we going to this party or what? In an 800 square foot condo? Hey, are we going to this party or what? And then what's he do? Hits that Find My iPhone app, right? Because it'll give you, look, now when I pull out my phone records, if anybody ever looks at it, see, I sent her this text. I didn't know where she was, and I did Find My iPhone. But then he still never gets up? He still doesn't walk around? 3 hours later, he texts to this phone that he knows he's got no response on, that he knows is sitting in the house. I guess we aren't going? And what's he say about that in his interview? He says, oh, I guess we aren't going. Where are you? Oh, well, I didn't say the where are you part. Yeah, he forgot that. But again, it tries to leave a record, a stage scene to say, look, hey, I was in this other room. I woke up at 11 something. I sent a text. I had to do Find My iPhone. I had no idea where my wife was. What else do you need? You know that you've staged a scene to look like suicide. You know that there's a cord. So Emily Noble, if she was going to go kill herself, what does she need to be looking for? Something to hang herself with. Right? My wife got up, wandered off in the woods. I know that I've staged it to look like a suicide. I know that she's hanging by a cord. What does she need? She needs to have found a cord. What's the defendant draw Officer Hollis's attention to? Where does he take him? Right into the garage. And what's he point out? An orange extension cord. And he says, this is out of place. This isn't where it's supposed to be. This used to be here. Watch it again in the body cam. Officer Hollis immediately says, can she even reach that? Watch the defendant as how he has to reach to get that cord even off that hook. And he says, I didn't do it. I didn't move this. But you know what we do know? He was moving things right in that area, even while law enforcement was at the scene. Even after they'd already responded, even after he's already trying to talk to them about what happened, supposedly to his wife. That cooler is moved. There is now a flashlight there. And it isn't just that he moved it. It's that he, at the end, Officer Hollis and the defendant are standing out in the driveway. And he says, maybe I'm crazy, but you just got to come look at this. He leads him right there. He wants Officer Hollis to see it. And look, here's this orange cord. My wife must have been looking for something to hang herself. But we know he's the one moving things around in that area. And it's not just the cooler. He even says, watch it. He even says, he shakes it, wobbles the cooler a little bit. He says, oh, even this isn't where it should be. Or she wouldn't like that. And he's the one that moved it. So, ladies and gentlemen, he keeps staging the scene throughout. What else is important? When was the last time Emily Noble was seen? Here's the testimony of John Kramer. John Kramer said that when he first saw law enforcement, after he brought his dad home that he was taking care of, he sees the officer there, and he says, I saw Emily Noble on the morning of May 25th. And he tells you he goes inside, gets his dad situated, and immediately comes back out and says he's not sure. You heard that he told that to law enforcement right away, that he told that to law enforcement later, and he told you that from the witness stand. And this isn't a situation that a year and a half or 2 years later, he's changed his mind about what he saw. He told them that immediately, that he wasn't certain. And how do you know that? How do you know that John Kramer had already said that right away? Because it's in the interview with the defendant. In the interview with the defendant, the detective says that no, the neighbor's not sure he saw her that morning. And what is the defendant's immediate response? Not concerned for his wife. Not wondering what that might mean for where she is. So that makes it look bad for me, I guess. So that makes it look bad for me, I guess. Right. Because he was hoping to hang his hat on the fact that somebody saw Emily or thinks they saw Emily after he'd killed her. Ladies and gentlemen, you look at the timelines on the phones. I would submit to you that timelines of the phones conclusively prove that the defendant lied repeatedly to law enforcement about what happened. Repeatedly. Emily receives messages at 6:30 in the evening on the 24th that are not read until 4:40 p.m. the next day. There's nothing on Emily's phone to show any user-initiated activity after 7 p.m. on the 24th. Nothing. Until the defendant's on. The defendant's phone shows that after they came back from Uptown, out celebrating his wife's birthday, that he has a 34-minute phone conversation with a friend of his. A conversation that is never mentioned a single time in all of the different versions of events that he talks about. We're told that, although the defendant says initially, I told Officer Hollis she wouldn't go out by herself at night. But then he thinks about it, and in his interview, he says, well,
And he was like, does she ever go out at night, by herself? And I'm like, no, she doesn't. That's something but she does. At times now that I think about it, especially if she's got a little buzz and she's drinking, she'll get that and she'll grab a flashlight and she'll go on this walk and come back with the forage. Who told you that Emily Noble went for a walk that evening? That he was sure about? John Kramer. Emily Noble comes home, goes on a walk, while the defendant's on a long phone call and playing around on his phone. After he gets off that, there's a 40-minute gap of time where there's no activity on his phone. Between 8:42 p.m. and 9:23 p.m. 40-minute gap. Defendant knows the place where Emily goes to forage, knows where he could find her. Ladies and gentlemen, I submit to you that's an opportunity at that time for him to go leave the house and to go confront her in the woods. And where the physical evidence shows she was struck in the face, causing fractures to her nose, and she was manually strangled, causing 4 fractures to her neck. After that time at 9:23, the defendant's phone screen turns on once or twice, and then between 9:45 p.m. and 1:11 in the morning, there's a 3-hour and 25-minute gap of time when there is no activity on his phone. Time to stage the scene. And then the uncontroverted evidence. The uncontroverted evidence is that he is on his phone pretty much the entirety of the night. You'll have the timeline, look at it. And it's not just loading apps or doing other things, it's sending messages, orientation changes on the phone, plugging in the phone. He's on his phone all night. Until when? 5:52 in the morning, he starts the YouTube app. And you'll see on the timeline that runs until 8:40 in the morning. 5:52, he's still awake, activating something on his phone. What happens 8 minutes later? Emily's alarm goes off. Do you think it's reasonable that the defendant, after being awake the entire night, loaded up YouTube at 5:52 and was totally asleep by 6? Remember, if Emily got up and she made the bed and made herself a drink and went off to commit suicide, she's got to be moving around sometime in that morning. And the defendant's awake right up until that time. What else is there, though? At 8:40 in the morning, the defendant's back on his phone. And what happened at 8:41? Amy Thomas sent a Facebook message and a chat that included both the defendant and Emily. I want you to think about that. Come back to that in a minute. Emily's device shows no user-initiated activity until 4:40 in the afternoon. None. The health data shows no movement. The phone doesn't go anywhere from the time when they get back from uptown in the night until 4:40 in the afternoon. And what do you remember happens at 4:40? How do you know that all this stuff in the timeline is what it says it is? Messages that Emily Noble received in the evening of May 24th were not read, did not show up as read on the phone until 4:40 in the afternoon the next day. What happens at that time? We know the defendant says that phone has been there. His wife has not been there. At this point, he's allegedly searched around. At this point, he's the one on her phone. And if you go into the timeline and look at 4:41 in the afternoon on the 25th, the SMS app, the text messaging app, is activated on Emily's phone. That's how those messages show up red. It wasn't because of anything that Emily Noble did. It's because of the defendant. And what else is important about that? This Facebook message. Remember, the defendant, here's another thing he tries to latch onto. Oh, Amy Thomas says the Facebook message that I sent shows that it was viewed by both of you. It was viewed by Emily and the defendant. Right? And the defendant says, well, then she must have been alive 8:40 in the morning. Now remember, to be on her phone that doesn't move, that doesn't leave the house, that would mean Emily Noble would have to be at home at 8:40 in the morning. And because there's a bunch of user activity again starting at 8:40 on the defendant's phone, the defendant would have to be awake too. So there goes I was sleeping in the other room and don't know anything about my wife getting up and leaving the house. But more importantly than that, look at the timeline. That Facebook Messenger app on Emily's phone is not activated until late in the afternoon when the defendant gets on the phone, goes into Facebook Messenger, and sends a message to the guy whose house they were supposed to be at on Memorial Day. That's when that message shows up red. Not because of anything Emily Noble did. Look at the phone. The Facebook app flicks on when you receive a message, but it doesn't show any other user-initiated activity. And you heard that testimony from the cell phone forensic specialist. The only time that app is opened and manipulated and a message is sent is when the defendant's on the phone. That's not evidence that Emily was alive that morning. Ladies and gentlemen, look at the other statements of the defendant. Again, I would submit to you, know that he's lying to law enforcement based on what is on the phones, because it does not match his story. Defendant tells you they were in Uptown, they came home, and they made love. So he tells the officer. That's what he wants people to believe. What's he saying on that Signal app? What's he saying in that chat to his buddy? 2 weeks before this. 2 weeks. My marriage is over. We don't fuck anymore. 2 weeks prior, he's saying his marriage is over. That they don't have sex. And then he wants the officer to believe, well, no, we went uptown, we had a good time, came back, had sex. What's he say to Officer Hollis? Again, love the body cam. We came back, went to sleep in our bed. Our bed. Really? You ever called the bed that you sleep in with your spouse somebody else's? Not yours, not ours? I'll tell you, how else do you know he's sleeping in that other room? How do you know? He's got a blanket in there. The hamper for his dirty clothes are in that bathroom, not over in the master bedroom. In fact, go back when you listen to his interview. He refers to that as the master bedroom, her bedroom. Ladies and gentlemen, let's submit to you the evidence is clear. Neither one of them was ever in that bed on the evening of May 24th. When Officer Hollis looks in there and he sees that the bed is made, that stands out to the officer. It ought to stand out to you too. Because either that bed is made because it was made in the morning of the 24th and nobody ever got back into it, or that bed is made because on the morning of May 25th, right before she decides to commit suicide, Emily Noble made the bed. That's ridiculous. No one ever got into that bed that evening. Ladies and gentlemen, what else do I want you to focus on and think about? The defendant's behavior shows that he knows she's dead. He knows Emily's dead. What's he do? First of all, you hear testimony from John Kramer that he's smoking in the house. He's smoking in the house. That Emily would never allow that. Now, you heard a lot of questions about, can you see ashtrays on these different photos or anything else? You know what I'd submit to you that shows? The lack of those formal ashtrays is that people didn't smoke in that condo. They did not. That was routine. It was not a routine practice to smoke in that house. Well, there's no ashtray in this picture, no ashtray in this picture. Well, guess what? There's a bunch of empty beer cans. There's a sink, a trash can. I mean, let's not pretend that the only thing you could possibly ash a cigarette into is a real ashtray. What else does he do that he tells you that he knows she's dead? Ladies and gentlemen, he's asked to rate his marriage on a scale of 1 to 10 over the last 6 months. And he says it's an 8. And he says, well, there's some old texts or maybe we're about whatever, but, you know, this whole Corona thing really brought us closer together. And without any other question, the question was, rate your marriage on a 1 to 10. I did not hurt my wife. I did not hurt my wife. I loved her. May 27th. May 27th. Speaking about his wife in past tense. If your loved one is missing, if you don't know where they are, if you're trying to find them, how would you ever be referring to them in the past tense after such a short period of time? And he does it in other places too. Oh, she loved me. He talks about her in the past tense because he knows she's dead. And one other thing about his behavior on the 24th. Ladies and gentlemen, I ask you to put yourself in these shoes for a minute. You wake up, and your spouse is gone. You don't know where they are. Maybe you remain calm for a while. You see what's going on. You don't know. You wait. And the minutes and the hours pass by, and you don't hear from them or see them. And you know a place, a short walk from your residence, where they like to go. And you don't ever walk it? You don't ever go out there yourself? The defendant wants you to believe that he checked to see if his guns were there, that he checked up into the attic, that he's looking all over the house, trying to see where his wife could be. He knows right when Officer Hall shows up. He talks about this walking path that they go on. And yet at no point in the 6 hours, even by his own version of events, he's awake before he calls law enforcement or before he calls Celeste. He never goes and looks at the place where he thinks his wife might be? There's only one explanation for that. One. That he can't be the one to find her. There is no other reason why you wouldn't go looking in a place where you think your loved one is after they've been missing all day. It's that close to your house. And then, ladies and gentlemen, I'd submit to you, he pretty much tells Westerville Police Department where she is. Let's be blunt. Makes the Westerville Police Department look pretty bad those initial days of searching. Nobody got in that part of the woods where Emily Noble's remains were eventually found. It does. It looks pretty bad. But you know who it looks worse for? The defendant. The defendant, even on the knock and talk, when he goes out for a walk with the detectives and he says, I don't know, you'd have to go in there to look. Not that I'm thinking she's in there. When he talks in his interview, what would Emily do? Well, she'd go into the woods and hang herself. What a lucky guess. What a lucky guess. He gets where she'd be and how she'd do it. And remember, this isn't a suicide. This is a staged suicide. So how much even luckier would he have had to have guessed where she was and how she'd look if it was some other random stranger who had committed the murder? Ladies and gentlemen, the defendant in his message said that his marriage is over. His son committed suicide. If Emily's leaving him, if he's getting kicked out, he's got nothing left. Nowhere else to go. Ladies and gentlemen, there's one last thing I want you to think about. And that's the defendant's words in the last part of the interview with Westerville Police Department. What's he say? I know I did not hurt her. I didn't do anything to her. So the other thing that I can think of is that she did something to herself. I know I did not hurt her. I didn't do anything to her. So the only thing I think of is she did something to herself. Ladies and gentlemen, I want you to consider that statement in reverse. Because I submit to you that the evidence shows, beyond a reasonable doubt, she didn't do anything to herself. Now, I submit to you the evidence shows that the defendant did hurt her. That Emily Noble died of a manual strangulation. That her death was staged to look like a suicide. And the only person who would have done that is the defendant. And we respectfully ask you to return verdicts of guilty on all three counts.
Thank you, counsel. Please give your attention to counsel for the defense.
Your Honor, thank you.
I want to be really clear about something. Really clear, because nothing can be more important. And what I'm about to say in the next 45 minutes or an hour is what I'm about to say right now. The state of Ohio started
their closing argument saying there's two options, suicide and homicide. They just sat down and said that they've shown by a reasonable doubt that this was not a suicide. That is not what this case is about. This case is about whether Matt Moore killed that woman. The state of Ohio wants you, and you know what? We picked you because you are the right jury for this case, and you are smarter than this. They want you to go into that deliberation room and treat it like a movie or a puzzle, or I guess we're talking Unusual Suspects and books now. They want you to go into that jury room and talk about, did she kill herself or did somebody kill her? That's not what this case is. What you have to go into the deliberation room and discuss is the charges against Matt Moore, the elements of the offenses, and whether or not they have proved beyond a reasonable doubt, not suicide or homicide, that he killed her. The judge has read you the instructions, and there is an incredibly important instruction that reads, you cannot stack an inference upon an inference. You can draw from one set of facts an inference. From the same set of facts, you could draw another inference. But you cannot draw an inference and an inference. And so what does it mean? Literally, 6 days of testimony, 7 today. It is, did she commit suicide? No, she didn't commit suicide. So she must have been killed. Well, if she was killed, it's Matt Moore. That's inference stacking, not supported by the evidence. I literally, as I sat there listening to the closing, and I recognize that these arguments are arguments, and so I'm going to say this. 24 years, over 150 jury trials, I've never had a harder closing argument than this, because honestly, in most, I've got evidence to attack. This case is totally speculation. I watched that clock at 1:50 p.m. on August 25th, 2022. I remember telling you, jurors, that times were important in this case. And when I said that in voir dire, I had no idea how important. At 1:50 on August 25th, 2022, I heard, no, you heard for the first time that the state thinks Emily was killed in the woods. And if any one of you thought when they heard that now he followed her on the walk, and you said to yourself, oh, so that's their theory? That's reasonable doubt. At 1:50 p.m., we heard that for the first time. Our justice system has to be better than this. And you know why? Let's go through it. And before, and you've come to know me, I am passionate, but I am not passionate without a purpose. This inference stacking that I just talked about, it's speculation. And there is no question that the law says circumstantial and direct evidence are of equal weight. There is no question about that. But here is what is not evidence: speculation. We think he did this. We think he did that. Now we think she went for a walk and mad because of a text he sent on May 7th to his friend, that on May 24th, after they've had a nice day together, that he now is lurking and going and following her and killing her in the woods. That's not just one inference and upon an inference. It's probably 8 or 9 or 10. But it's speculation. Members of the jury, I remember when we did that voir dire so well, we talked about why we had to do voir dire. It's because not every juror is perfect for every case. We went back and forth and we both asked you questions, and you saw us ask some people to leave because they weren't right for this case. But you were. You are smarter than to think a man could be convicted of murder based on speculation.
In fact, I think the only thing that has been proven beyond a reasonable doubt is that they think he did it. For sure. Now that, for sure, they've proven that. But let's talk about what else they haven't proven. I want to go, and trust me, I'm not going to show you Defendant's Exhibit D again. I won't show you the map. Okay, I know we've had enough of the map. But I do want to talk to you just about why it's so important. Is the judge is going to, of course, you've read the instructions and you have them. And he's going to tell you that the state of Ohio doesn't have to prove the exact date, but generally around the date and time. But you know from the way that Matt Moore has been charged, and more specifically, you now know from their closing argument that what they're telling you is that he was killed on the 24th. That's what they just told you in their closing argument. Now, I realize that their argument, but they have the burden. They just told you she went for that 8 p.m. walk with John Kramer and he kills her after that. Hold them to that. So the searches, why is it so important? Well, it's important because, well, first of all, if she's not in the woods on the 24th or 26th or 27th or 28th, first element of their case fails. And the judge is going to tell you, when you go back in the deliberation room, you look at each and every charge.
She's doing a good job right now.
By element. On or about May 25th and May 25th, did Defendant Matheau Moore in Delaware County purposely cause the death of Emily Noble? They're numbered 1, 2, 3, 4, 5. If one of them fails, you're done. You don't even have to talk about it. So if the date fails, you're done. If identity fails, you're done. Identity being Matt Moore, you're done. If purpose fails, and I'm going to talk a lot about purpose, you're done. It's not that they have to prove all of them. Any of the elements fail, they're done. That's the law. So here's why the searches matter. If she's not in those woods on the 24th or 25th or 26th or 27th, you're done. 27th, there's a GPS on his car. And, I always want to talk about the transparency of things or lack thereof. I know you noticed it. It's like I have to bring up GPS with Detective Grubbs. Like, here's an investigative tool that you use to track my guy, and you don't even want to bring it up. You witnessed how many instances in this trial did the state of Ohio wait to see if I did my job? Not just the GPS, the counseling records, the osteopenia, the list goes on. Never bring up any of these things. They wait to see. What can we get away with? Is defense counsel good enough? So back to the searches. She's not there, the 24th, 25th, and let's talk about it. It's not just humans and dogs. No one sees her, no one smells her, but I want to just talk about this whole theory that they've put forth that it's just bad police work, that they didn't go into the woods. Members of the jury, you are smarter than that. And I remember I was talking to Sergeant Alloway. Do you remember the press conference? And he refreshed his recollection and came back and told you all that
please like and subscribe.
Told Westerville community and the public at large, we searched that area 3 times with law enforcement and once with dogs. Nobody said the perimeter. And here's what else we know. If I'm Matt Moore, and I think what's the word? The main criminal mastermind? And I'm going to talk about whether Matt Moore is the main criminal mastermind in a second. He takes them to the exact area and says, this is where she forages. And then even the state of Ohio in their closing argument just now had to concede that, you know what he says? You might want to go in. Oh, that's a bad fact, right? And you know why he wouldn't want to go in? Is it because he doesn't want to find her? Actually, I agree with that. You know why he doesn't want to find her? Because 10 months earlier, his son was hanging from a tree in the woods. I wouldn't want to go in a wooded area either. Let's talk about motive. Judge, of course, has told you they don't need to prove motive. We talked about this in voir dire. Totally agree. That's the law.
New poll is
The
up.
law also says is that the absence of motive. That is, if you say, I just don't see a motive, is something you can consider when finding that he doesn't have the intent. So here's why it's important. Now, again, you notice, of course, that I had to bring up the other bank account, right? There was the one bank account, and then it's kind of like, let's see if Menashe can do her job. So now you know you've got the one bank account with 90 plus that was a joint, and then of course there's the other bank account that's 90 plus, and then of course I had to bring out that there was life insurance, which my client never filed a claim against. So let's get rid of any thought that there was a money motivator. And then with the bank accounts, they talk to you about those checks. Now, there's one person in this jury that thinks to themselves, what about those checks? What about those checks? The burden's here. So where's Arturo and where's Paul? But I also want to tell you about the checks. What's the expression? A slow walk?
She's talking about everything they didn't show her that she had to.
May 5th. So that's incredibly relevant. And the check to Arturo isn't dated June 6th. So that's incredibly relevant. You have them in the back. And if you wonder where they are, you clearly know that they have all the power in the world to issue subpoenas and get people in. And so just even by admitting those checks, it's like that expression that we all know when you just throw things up and you see what'll stick. So then back to the motive or lack thereof. They presented 3 family friends, Amy, Sue, and Brandy. And I guess this is what the state calls part of the edge of their puzzle. Well, the friends were so close that they hadn't had contact with Emily since 2019. In fact, Sue was last called by Emily when Joey died, and she never even called her afterwards to check in on her. So I'll leave it to you as to the extent of that friendship. And of course, her sister testified. And it's so funny, too, about Matt doesn't go into the woods and search for her. And so that inference should lead you to the fact that he didn't want to find her, and that should lead you to the fact that he killed her. I remember asking Amy about the fact that she didn't come to Ohio and search for her sister was no indication of whether she loved her sister or not. She said, that's right. Why is it okay for some and not for others? And the counseling records. They want to tell you that Emily was happy, she was foraging, eating plants, nettles, and so there's no way she could have committed suicide. This takes me back to my opening, when I told you that this is a case about common sense. When we talked about suicide in voir dire, and we talked about mental health. And I really mean this. We are all smarter, and I know each and every one of you, truly. If mental health were that simple, we would live in a much different world. It's not. It is not that simple to say, they seem happy. It's just not. And in fact, we know that just from history, right? We know that Emily's first husband, you heard her sister testify that they seemed like 2 peas in a pod and that he killed himself. And it was a surprise to her, Emily. And so I want to just go to the counseling records. And I don't do this in any way to disparage. I do it because it is an inaccurate statement to say that Emily was happy and eating plants and would never have killed herself. Because the truth is, and you'll see in the counseling records, that Emily had a history of depression and anxiety, that she had struggled with prior loss and trauma. Look through the records and see how many times you see the word trauma and loss and grief and sadness. Also, with respect to motive, flip through all the records, and these are Emily's statements made to a therapist in a safe space, right? They're not text messages sent quickly when you're maybe having a beer in the middle of the night or you're talking to a guy and you're doing bro talk. This is what you say to your therapist, right? This is a safe place. The only thing she ever says about Matt in these records is that she's worried about his well-being because Matt's so depressed too after Joey's suicide. She never says, Matt's mean to me, Matt hits me, I'm being abused, verbally, physically, nothing. And I ask you, these counseling records, you will have them back there. Defendants, notably, defendants exhibit S. Pass them around. Look at it. In fact, please, pass them around and look at them, because the narrative of suicide wouldn't happen, she had told her friend she wouldn't kill herself, well, that's a false narrative. And something else about that hit me, if suicide were that simple, right? If you knew when someone was going to commit suicide, by logic, wouldn't suicide?
Nobody
not
would
be
ever
a thing?
commit suicide.
Because if you knew
Mhm.
someone was going to hurt themselves, you'd
Good
stop
point.
them from hurting themselves. This is the thing about mental health. You don't see it coming, and nor does the person. And you know why these friends and family members had these conversations with Emily about whether she'd kill herself? Ask yourselves when you're back in that deliberation room, are these conversations you have with your friends? Or are these conversations friend checks that people were having with Emily because they thought she might kill herself? Because I can tell you, I don't ask my girlfriends at drinks, are you going to kill yourself? I would only ask that question to a girlfriend that I thought just might do that very thing. The text messages. I promise you that my closing will not be as long as a stack of paper. This is why I brought this stack up. 1 year of text messages between Matt and Emily Noble sits right here. This is what they give you. They give you this. They give you text messages from November of 21st. Hi, thank you. On the second page of that, he says, why does it bother you so much? Am I mean? Page 63, not mean, unintelligible. And read the rest of it, how they communicate with one another. Because I submit to you that when the state of Ohio tells you how couples act, right? Like how they told you how Matt should have acted when Emily went missing. We're smarter than that too. Every couple's different. Every couple's different. Every person's different. So to normalize certain behavior and to say, oh, well, if you woke up and you saw your spouse gone, the first thing you do would be to call 911. We're all different. And I bet if you look at these text messages, you might well think, I don't text like that with my spouse. Or you know what you might think is what I think is like, wow, is that enough? I better watch my texts, right? And then going to the next set of text messages from December, New Year's Eve, he says, I don't want to argue. if you don't have anything positive to say, keep it to yourself, please. And he's literally asking her, try and be positive. Read these text messages because they gave these to you. They gave these to you to prove motive. I submit that not only do they prove lack of motive, I want to go to this one, where he says the latest set of text messages, by the way, is from March. She kills herself in May. March. I'm not feeling very well today, Matt says. I'm just going to stay in here today. I don't feel like talking. Are we going to the party or what? That's the last set of text messages you have. Of all those, that's what you have. And with the fighting or the argument, I bet John Kramer was right. He heard a lot of voices 2 weeks prior. And if none of us have ever not raised our voices inside of our houses with our partners, bless you. But every couple's different. And you know what John Kramer said that he didn't hear? Was any arguing on the 24th or 25th. And there was even a jury question where I got the dates wrong initially. Like I think I said the 25th and 26th. And one of you asked a great question. John Kramer, is your testimony still the same about not hearing any argument on the 24th or 25th? And he said yes. He heard no argument. And we know he saw and heard everything because he's right there. And he was what we call a nosy neighbor. He's right there. He heard or saw nothing. 50%, and this is common sense, of relationships end in divorce. And those that stay together, well, I submit that some of them shouldn't, and those that do probably argue every once in a while. Here's my point. When you look through these text messages with respect to divorce or not wanting to be together or those kind of things, the only time divorce is mentioned is when Matt says, if you want to divorce me, leave me. Just tell me. Never in here, and you heard me ask the detective, does he say, I hate you? I want you dead. I'm going to kill you. I will hurt you. Nothing. Please read them. The absence of motive can be used by you in your consideration about whether he has purpose. The house. Well, I guess now that there was all that evidence about the house, now we know from the closing that the state believes she's killed in the woods. And so the attic and the cars and the no trace and the no fiber and the no DNA and the no blood, I guess all of those now aren't as relevant. Still, though, relevant seems to be the fact that Matt is being seemingly prosecuted because of all of the interpretations of the ways he behaved. But he let the officers in, he gave them consent, he gave them phones, he gave them DNA, access to the attic, access to the house, all the things that Matt did. And you heard those women talk about how to get from one side of the foraging section to the other, they either had to crawl or they all got burrs. Remember that? And then you guys asked questions about scratches. Okay, well, of course, we know that they have Matt's shirt from that night. And we now know that they believe that he killed her when she went for a walk. Okay, so I guess we're drawing inferences. They come home from the bar. Emily changes to get ready for her walk because she's wearing her walking clothes. And then Matt follows her for an unknown reason. And we don't know if he's, according to the state's theory, changed his clothes or not, but we certainly know what he was wearing at the bar. They have that shirt. No burrs, no scratches, no rips, no blood. Remember that question about might you have a fracture in the nose if you have blood from a fracture in the nose? Nothing. And the shirt from the criminal mastermind is in the hamper. The hamper and still not washed. want to just talk about the police work. It's one of those things that no matter how many times you say it, it doesn't make it true. No one else would do this. No one else would do this. Okay, well, no other suspects were ever developed. We know on the 25th, he's taken into the police station. He's asked to come down in the back of a cruiser. And you saw one of your exhibits is he was read his Miranda rights. Right? This is on the 27th of May. He's their guy. In fact, they continued to work from May 25th all the way to June 17th of the following year to charge him. Because they kept just looking until they finally found Dr. Smock. Right? And Dr. Smock arrives in May. Because if all this evidence that they've given you is actually evidence, they charged him in June 2021. So the police work. There's no other suspect developed. And if their theory is he's the only one, well, of course we know that actually, based on the evidence, the last person to see Emily was John Kramer. We also know what are the odds that two sets of dogs, almost 2 weeks apart, went to the same house after searching for scent. And I asked the detective, did you interview the man that lived in that house? Yes, we did. Where is he? What are the odds? And that was the purpose of my question about that was two different sets of dogs, one in May and one in June. And do you remember when Sergeant Alloway was up there? And I said, so the second set of dogs went up here? And Sergeant Alloway goes, actually, they went right back down to the house, the driveway where the first set of dogs went. Where is he? Where is that investigation? Well, we don't have it because of tunnel vision. Police officers ignored Emily's mental health history, her drinking. We know that she had the situation in 2017 where they found her in Westerville. They just ignore it. Just like they ignore, initially in this trial, they wanted to sell you on the narrative that Emily never left her house without the phone. How many times do we hear that? It's like, and then it takes me, Diane Menashe, like it's our burden. I have to bring the cell data out. And I have to show you as remarked as Defendant's Exhibit 3. She leaves the house all the time without the phone, particularly as of late. And let's just put aside the fact about the walk now that they say she took on the 24th. It seems like on the 24th she left without her phone too. And guess when else she left without her phone? The 22nd, because she went foraging with Celeste. And here's why I mentioned this and why I put together this demonstrative aid and cross Detective Grubbs on it. Because when you have tunnel vision and you literally get rid of things that don't fit with your narrative, right? That's not fairness. That's not proof beyond a reasonable doubt. Kind of another example of the tunnel vision was just today you hear Dr. Volte. He did that report. He went out to that scene twice with the Westerville Police Department. It was odd to me that the prosecutor was crossing him on using a 10-foot cord and was like, why didn't you use a 20-foot cord? Because your own police officers told them to use a 10-foot cord. And so they're crossing the expert that they got. And here's what's the whole value, if you will, of John Bolte, if nothing else. When was the next time you heard from anyone in this case after you wrote your report? It was me. Because they got the report.
That is damning.
Just like they got the report from University of Tennessee. Where's she? also about the cell data. And this is critical, and I know you didn't miss it, but I have to say it. John Kramer. It's an interesting thing, the phenomena of excusing some for inconsistencies, but never matter. Like, you know, their witnesses sit up here and say, I need my report to refresh my recollection about dates. And we say, of course, dates are hard to remember. Matt gets something slightly wrong, and he's a killer. John Kramer, for the record, did not retract his testimony or his statement to police. What he said is he can't be positive. He's not positive now that he saw her on the morning of the 25th. That's what he said. That's what he said. And so how do we know when John really did see her? Because if he didn't see her on the 25th, what he told you is he saw her the day before. So it takes me to get the location data up on the screen to show that Emily is in Butyl, Ohio, the day before at 9:39 a.m. Then I have to ask Detective Grubbs, how far is Butyl? Hour and a half each way. This is why it is dangerous for the state to have tunnel vision. I know they want John Kramer to see her on May 24th. I know they do. But guess what? John Kramer saw her on the 25th when she went for a walk. And he was the last person to see her. He was the last person to see her. And we know that from the cell data. We know that from the cell data, that he saw her on the 25th. And now they want to say that he retracted that. Members of the jury? You need to look no further than Defendant's Exhibit G to know that is absolutely not true. Another Defendant's Exhibit, Westerville press release, released on May 26th. May 26th, Emily Noble, 52, was last seen around 9 a.m., Monday, May 25th. They just told you in their closing argument that John Kramer right away withdrew his statement. That's not true. It's just not true. It's not true. And you're smarter than that. And you know what else? I wrote down in the sticky note, gotta love the body cam. Couldn't agree more, but isn't it interesting that in their burden of proof, they didn't actually follow and give you the Hollis interview with John Kramer outside on the body cam? I know you're smart enough to notice that. They cut that out. Because remember, Hollis goes outside and interviews Kramer, and he comes back inside and tells Matt, the neighbor says he saw her between 9 and 10. And I'm going to show you that clip. I'm going to show you that clip. If you gotta love the body cam, where is it? Show it to us, because it's your bird. All this stuff about staging. Staging, first of all, Dr. Smock. I think in closing they said that Dr. Smock is the most experienced or qualified expert that you heard from. I'm gonna let that sit there. Judge is going to tell you that reasonable doubt is doubt based on reason and common sense, and it's the kind of doubt that you would rely and act upon in the most important of your affairs. Heather Garvin, when I asked Dr. Heather Garvin, who is a board-certified forensic anthropologist, how many citations or articles or literature did Dr. Smock put in his report? She said none. So I just compare this as an analogy. If you go to a doctor and they say, you say, I got a pain in my knee. And they say, let's open you up, do surgery. Don't you say, maybe we should take x-rays? Maybe we should do a little investigation? Maybe we should get a second opinion. Not with Dr. Smock, because he says, they say, those studies are meaningless. And then they spent all this time talking to you about how there isn't a study of a 100-pound woman with the bilateral fractures from a hanging. I mean, how much do we hear about that? Well, if that's the case, when you go back in the deliberation room, look through all these exhibits and look your notes and check and see where is the article that a 100-pound woman with bilateral fractures died of manual strangulation? Where is that article? Or better yet, where is the article that says that I can have a USB cord wrapped around my throat in a way that we don't really know, and then as I collapse and I decompose and my head drops from the decompression, that the ligature doesn't move, or that the weight of my head, 10 to 12 pounds, is my skull. Remember how much pressure you needed, right, to kill yourself. Less than 10 pounds. The skull alone is 12 to 10, or 10 to 12. And then I guess in closing, Mr. Sleeper said, Miss Menashe got on the ground and she didn't even know how to show you. I completely agree, because I have no idea. Who knows? He said in his closing argument, you probably, during the beginning of this trial, sat there and thought, what was going on? I submit to you, you're still sitting here thinking, what is going on? Who knows? We don't even know how the ligature was around her neck because there are no photos. And they want to talk about this perimortem trauma. I'm going to go there for a second. We know that perimortem trauma is days, weeks, or months. Within that time frame is September. September is months. That's why it's so important. And here's what else you know. Pull that cord out. It's like this, 4 to 5 inches. It's like this long. Which means that when Chad Holcomb went to cut it, he cut one side first, real close. Because you never heard him say, I cut both sides at the same time, or 2 of us cut. And what happens when one side get cut, right? The weight of the branch deflects. And now we know 3 inches. Do you not think that the branch pulled her up? And then we had the man, Charlie Carlson, that said, I held on to her with, and that's why I said, put your hand up. And this isn't videoed or documented. We have nothing. We have nothing. And how many times do people say how fragile her bones were? Perimortem is within that month frame time. Now, again, I don't have a burden to prove that she killed herself. But that's the significance of the perimortem. And this is the staging. I'm just sorry, going back. Won't surprise you. Jumped around. Please. This picture is everything. It's everything because this has all been made out to be so horrific, right? What really happened is Emily went to nature to find her peace. And you'll see that in the counseling records. That's where she found peace. She went there and she grabbed her ankles. You know why she grabbed her ankles? So that she wouldn't stop herself from killing herself. And that's what you do. That's what you do because you know that when you kill yourself, your natural instinct is going to be to stop it. That ankle is grabbed. And here's what else we know in terms of the mastermind criminal mind over here. There's alcohol in the water bottle. Her vape pen is in her left pocket. And a vape pen on her left side within her reach. Do you know what we do? What's common sense when we're in moments of real stress? We turn to our vices. Right? We turn to our vices. And here's else what we do. So if we're going to kill ourselves, we don't want anyone to know. We don't take an orange cord in the garage because we know she's wearing leggings with pockets. We take something that fits in our pocket so that we can go on our walk with our water bottle and no one will think anything otherwise. And in fact, she was right because John Kramer saw her going for a walk and he didn't see anything abnormal. I want to talk about the science and then just about Matt. The credibility or lack thereof is for your determination. Again, I can't say it enough. I feel like this whole trial, 40-some minutes of the prosecutor's closing argument was about how this isn't a suicide. We don't have a burden. But with respect to your job as a juror, it's to determine the credibility of every witness. And the judge has already told you that you can believe, disbelieve any, all, or none of a witness's testimony. That's totally up to you as a jury. I submit to you why this is so important and why Dr. Garvin, not just because she was asked to do the work of reviewing Dr. Agnew's report, but why I went through the age and the ancestry and the other things, is because if someone isn't doing their work, best practices, according to what should be done in forensics, right, that goes to their credibility. That goes to the weight that you should give their testimony. And here's what we know about Dr. Agnew's report and the other experts in this case. We know that there's the Montgomery County Coroner's report, there's Dr. Agnew's report, there's Dr. Smock's report, and there's the death certificate. Every single one of these, Dr. Smock, Montgomery County, and the death certificate relied on Dr. Agnew. They told you that. Every single one of these. And members of the jury, I know how annoying it can be. Sometimes with my histrionics and my garbage in, garbage out, and my things. You know what? This is why I said it. This is why I said it in voir dire. This is garbage in, garbage out. You heard from a board certified forensic.
She's running it home,
pathologist
boys.
who said there are no perimortem fractures to the nose. None. With respect to the perimortem fracture to the hyoid and thyroid, she said that anthropologically they appear perimortem. We don't know when those breaks happened, though. We don't know. And if we don't know and you don't know, that's reasonable doubt. And so here's the thing about garbage in, garbage out. If Agnew goes, they all go. And the judge is going to give you an incredibly important instruction about that. He's going to tell you about experts. Give me 1 second because I don't want to misstate it.
I mean, you guys, like I said, she is doing a very good job of laying out here all the problems with the case. And yes, if the answer to one of the questions from the state is I don't know, that is reasonable doubt.
She's going to tell you, members of the jury, it's similar to the instruction that you can believe, disbelieve any, all, or part of a witness's testimony. Is that if you don't believe Agnew and the other experts relied upon that opinion, they all go. That you can believe, disbelieve any, all, or part of a witness's testimony is that if you don't believe Agnew and the other experts relied upon that opinion, they all go. And John Bolte and Heather Garvin, we have no burden to call them. And I do want to address, in case a member of the jury goes in the back and says, well, Ms. Menashe in opening said that she was going to call some other witnesses. I don't have a burden. And there is no question that I stood up here in opening and said I was going to call other witnesses. But here's the thing. I didn't need to. I just didn't need to. It's not my burden. I don't need to assume a burden. Heather Garvin directly refuted Dr. Agnew and is much more experienced and qualified than Dr. Agnew. And they want to kind of dismiss the peroxide issue. Well, the bones were soaked in bleach. And we know that bleach weakens and whitens bones. And we know that the bones had perimortem trauma. We also know that the bones were moved everywhere. They were moved to the morgue, to a cooler, to the slab, to a cooler, to OSU. And now they're apparently sitting at OSU. And I do want to say, because I just want to say this about how Dr. Garvin didn't view the bones. You never heard any testimony that the state offered my expert to see the bones or that they made the bones available to my expert. And if you're considering the fact that she didn't see the bones, I ask you to consider the absence of that evidence. Did they make them available? Let's talk lastly about Matt Moore. We heard a lot, I guess the usual suspects, he's a mastermind. He's the same guy, and we're all, if we're not parents, we're siblings and we're children. And he's the same guy that's writing out a statement and asks how you spell the word couch. He asks how you spell memorial. And Matt, I'm sorry, I don't mean to be disrespectful, but he's the same guy that reads while he's writing. When he's writing, he's reading what he's writing. And we all know, as people that have been around children, what that means. And he is clearly, right, not seemingly the most sophisticated person. You've heard him speak a number of times. He uses things like, well, I mean, she's okay for a crazy woman, right? Like, these are the kind of expressions that he uses. It's this same man, though, that would be able to stage a scene, figure out to put the alcohol in the water bottle, put the vape pen next to her because she's left-hand dominant, would tie her shoes so tight that they wouldn't come off, would put her hair tie around her wrist, would take off one of her necklaces, because there's two in the picture on the 24th. He's that same guy. I also just ask you to think about one of the other things that you heard today from Dr. John Bolte. Because remember in the video how he tied the knot close to the branch? And then the basket slipped and the knot actually went tight? Look at those photos, right? Look at those photos, because we know that the branch is taller than 6'3", 6'4". We know that. The cord is slung over the branch. It's not knotted at the top. And if you're going to actually stage a suicide and hang someone from a branch and you're 6 feet tall and the branch is like right here, you knot it to make sure it stays up, don't you? Look at that. She flung it over. With respect to his statements about I didn't do it, he was obviously in the back of the police cruiser being read as Miranda. I don't know if there's one of us that wouldn't say I didn't do it. The use of past tense and the word gone, I obviously cross-examined the detective on the word gone, and his apparent alleged inconsistencies. He's actually been completely consistent about the fact that they came home, during these hours when he's now at the park allegedly killing her, that he was sleeping, that he got up about 1:31 to go pee, to go to the bathroom, and that he was on his phone intermittently the rest of the night. The cell data shows all that. So the time period they're using against him is the time period when he said he was sleeping, when most of us would be. We know that they were out drinking. It was her birthday, and they'd had a long day because they had gone to Buchtel and then his father's house and then out to celebrate, and we're now home. It goes back to that kind of, when Matt is slightly inconsistent, we convict him, or rather we want to convict him. When John Kramer's inconsistent, absolutely not here, but here he's truth-telling. When the detectives are inconsistent, we excuse the behavior. It just can't have it both ways. So I want to play a couple snippets. Well, first of all, before I do, I want you to remember this. The mastermind, showing you what's been marked as Defendant's Exhibit X1. Remember when he did this? Remember when he did this? And this. And then in this one, when he turns his hands over. And then in this one, when he looks him straight on so he can see his face. As I close, I just want to say that there's a lot made of Matt's use of words or the controlling mastermind. But there's one thing that we all know, common sense tells us, is we can't control our spontaneous reactions to things. We see something, we react. Nobody's smart enough to be able to control that. So I want to play for you 2 clips. We're going to play the clip when Officer Hollis comes back in the house after having just interviewed John Kramer. Look at his reaction. Oops, we need volume.
All right. So we found a little bit of information. We still don't know where she is yet. Okay. Your neighbor saw her in the garage about between 9 and 10 a.m. this morning. Said she was just standing in the garage. When he was leaving, he saw her. She was just standing there. He said hello. She said hello. This morning. Yeah, around 9, 10 o'clock. He went about his business. 51. Okay.
He saw her. She's alive. I want to play a second clip. When Matt comes out of his house and he thinks he sees Emily. And this is, of course, on the 25th when he's called 911.
Hey, how you doing? This her? Yeah. That's your wife? Oh. Okay. You look just like her for like a second. Oh my God, there's you. Okay. And more. No, Officer Hollis.
Look at how he was just for a second. I thought it was you. And you remember asking me to ask Celeste, you look like Emily, don't you? And in that first video, he says, oh, thank you, right, with his hand. And in the second video, it's like the shock almost took him over and he put his hand on his stomach. Nobody's that smart. And not Matt. Nobody's that smart. Members of the jury, I just want to close. I know that the state will get up here and they'll have a significant amount of time to rebut what I've just said. And that's the way the process works. Nothing they can say, though, will change the fact that what they've given you is purely speculation. And I've honestly, in all these years, I've never done a trial where the judge has allowed jurors to ask questions before. But as I was thinking about my closing and how I wanted to end it, I thought about my ask of you as a jury. I ask you that when you go into that room, you ask yourselves, whomever you pick as your foreperson, write down all the questions you still have. Right? All the questions you still have. Put them on the piece of papers like you did so diligently over the last 7 days and put them all in the middle of the table. Because that stack of questions, those questions that are unanswered, those are reasonable doubt. Thank you.
You feel like you need a break right now before all right. We'll take a very short break and then you'll hear the rebuttal from the state. Remember to push admonitions this time. We'll be back in 10.
Well, that was some top tier shit. I mean, I wasn't expecting her to do that. That was really good. Whew. I mean, how you guys feeling? What you thinking so far? So it's just, yeah, she did a good job. Yeah, I don't know what to say about Diane. But you learned a few things here today, Sean. Jody mentioned, I do. I mean, every time I watch, last week, I watched a bench trial over a person who violated a protection order, a restraining order, and it's a misdemeanor offense. I watched a bench trial for that in a courthouse in one of the suburbs of Cleveland. It was only 25 minutes long, but I still watched it. You learn a lot from watching other attorneys. You learn a lot from how they present, what they deal with, how witnesses react. And there were a couple, I learned a thing I kept in the back of my mind. And these trials that we watch together, guys, yeah, I take notes. This time I took a couple of notes. I've got a couple of notes. I've got a file, and I put some notes down. I'm not going to lie. That last part where Diane says, write out all your questions. Those questions are your reasonable doubt. I'm keeping that one in my back pocket. That was a good one. That was phenomenal. And then her showing the video of Mathew saying, oh my God, it's her, and then realizing it's not. And then, that doesn't show a guy who's like, oh, I hope she's fucking dead. No, this is a phenomenal defense. Diane has kicked ass. Lee, how you doing? Sorry, I am sorry I am not closed captioned. Yeah, Jim, that's something they don't. Jim says, how did they get to the body of the woods without anyone seeing him? That's something they don't have an answer for. That is a big issue. JC, you asked, is a bench trial would have been a better choice? I don't know if that choice is available in every instance. Okay, unlike other states, Ohio, the defendant has the sole right to determine if he wants a bench trial or a jury trial. It's not conditioned upon the state. If you're a defendant, you can walk in, set for a jury trial that morning, and change your mind and say, I want a bench trial. And immediately they verify you want to do that, and they kick the jury out. You can't change in the middle, but it is solely in Ohio the defendant's decision what happens in the case. We're kind of hardcore like that. We don't make other people. We don't want other people make that decision for you. And somebody did mention this, and I mentioned it myself. This is apparently one of the few times there's a murder scene, and this guy didn't leave any physical evidence, like he's a fucking magician. And I think that they have to explain that. They can't. JC says great lawyering. Well, we'll find out how good it is at the end of the day. Eric Fulham said, let's come down to brass tacks here. Where them toes at? I know. That's, yes. If the toe don't fit, if the shoes don't fit, the toes don't fit, you must have quit. Yeah, Chaucerian Fraud said that beard was very Gandalf. Like, yeah, I know. He had a Taliban beard when all this happened. It looked like he was in the Taliban. I've been wondering, Shizzle says, I've been wondering this whole trial when no one came and saw him at the scene of the death or in the woods. Yeah. Yep. And Andrew, you brought up a point, and the defense hammered on this. Now they're saying he didn't move the body to the woods. Yeah. Now they're saying he went there and killed her and then did it all right there. That changes their story because now they're telling you the theory and they're kind of stuck with that. They aren't offering you alternatives. They're saying that's when it happened. But remember, they have the other witness who said, I saw her on the 25th. So did he kill her? It doesn't sound like it. Yes, and I've made this argument before, Jackie, where you said he's a mastermind, quotation marks. Yeah, I've had to make that argument before. That, look, my guy's too stupid to do this. That's just the nature of it. If your guy's a dope, you point it out if it can help you. How long will the jury deliberate? Should be a new poll. I'll bring that up in a second here. Let me see. What's the poll look like right now? Dispatch and Direct gifted 5 memberships. Thank you so much. I know everybody who got one appreciates it. Thank you so very much. Make sure you guys allow gifts if you want one of those memberships. If you haven't got one. Okay, so end of the poll. Yeah. So the final poll is 55% not guilty. 16%, second place, no toes, no justice. Can't argue with that. 13% says guilty, and 13% says still don't know. And That's okay. If you don't know, it's okay. If you don't know, you don't know, and is what it is. All right. So new poll. I don't think it's going to take. I think they're going to take longer than 30 minutes. Let's see. What's another one I could do here? Oh, guys, if you don't mind, please leave a like if you enjoy this so far. What else can we do? We'll do. Trying to figure out a different option here. We'll do 3 to 6 hours. 3 to 6 hours, and then we'll do Okay, so it's not exact, but you guys will see what I put up here. So it is, how long are we going to do how long are deliberations going to be? 30 minutes to 60 minutes, 1 hour to 3 hours, 6 hours to 8 hours, or 10 hours to 14 hours? I'm just trying to show a little bit of a gap here. Yes, Chaucer, it's true. Earlier they said it was in the house, and that was a problem. How long do I think they're going to deliberate? Oh, I bet it's going to be at least 6 hours minimum. I don't think we'll find out till tomorrow. So let's see. What else is are they on break till the final closing? Yeah. Yes, they're taking a break till the state can do their oh, what the heck just texted me? I don't give a shit about that. So are they just on break? Yeah, the prosecutions have got to do the rebuttal because they carry the final burden, so they have the last chance to speak. So they get to do it, but they are limited by going no longer than the defense. That is one of Judge Oliver's rules. So, yes. Jim is saying, I'm just shocked they actually argued. Well, it's got to be him because who else would it be? Yeah, I mean, at least they're being honest about what they're going and arguing about this time. Andrew Peterson saying, I only say 30 minutes for the free pizza. Oh. So Alexander Henderson, you're saying, what is this case? I just saw a clip of the prosecutor walking out. Aside from that, I have no idea what this is. Okay, so Matheau Moore is accused of murdering his wife, Emily Noble, back in 2020. She disappeared on the 24th or 25th of May, and they found her body hanging in the woods a couple months later in September 2020. He's accused of murdering her. Now, they're not sure, the prosecution's not sure, and it's not clear. Did he murder her in the house and drag her out into the woods, or did he murder her out in the woods and do that? Because they're claiming he staged a hanging because she was found hanging from a tree with a printer USB cable. And that's the case. There's been a lot going on otherwise with this case. They've had a couple different forensic anthropologists, a couple other different doctors involved. Today there was like a kinesiologist and biomechanical engineer who came in to testify for the defense. Because the defense's argument is this was suicide. There are some supposed after death perimortem damages to her hyaloid bone, which is common in strangulations, but also to her thyroid bones. But there's no clear evidence of when those breaks happened. They happened sometime after her death. So we don't know. That's really kind of what this case is all about. I hope that answers it a little bit, at least for you. Otherwise, I'm not sure what to say. I guess I have to type out an email real quick. All right, I hear noise. We're back in business. Sorry, guys, about that. It's not usually the case, but yes, in this case, I think they fully believe this guy did it, and the defense attorney clearly believes he didn't do it. So I think there is that give and take there, Mr. Young. I think that's a very good question. Usually, though, it's not the case, and you're just trying to sow reasonable doubt.
At this time, please give your attention to the representative of the state who will provide the rebuttal argument.
I wonder if the prosecutor herself is going to do it, or it's going to be your assistant again. Oh, the bearded creeper guy again. Oh, no, the other guy.
Ladies and gentlemen, I'm not going to stand up here for an hour, 45 minutes. I will try my best to make it short and sweet because I know as the last person that you're going to hear from, I'm also the last person you want to hear from because that means the case is over and you can go back and talk amongst yourself for the first time in this case. But I've been doing this for a long time, maybe not as long as opposing counsel. And when you get up in closing and you say, look over here. Look over here. Look up here. Look down here. That's what that closing was. It wasn't a focus on the evidence that you actually heard from that witness stand. You see in all of these documents, this is the evidence. And that's what you are to render your verdict on, the evidence that you heard, the evidence that you saw, your judgments based on the credibility, your everyday tests that you use to determine the credibility of every witness at your job. That's what you render your verdict on. Now, counsel will hold up giant piles of paper and say, well, you don't know anything about this. Completely ignores the piles of paper here that'll be littered on your table as you walk through all the facts and circumstances of this case. The piles of paper in your lap from all the notes you've taken over the last 2 weeks. That's the evidence, and that's what we're going to ask you to focus on when rendering your verdict in this case. Now, counsel got up here and started off by saying suicide versus homicide. That's what the state wants you to focus on. What she ignored or failed to explain is that the reason we want you to focus on those two elements is because those are the two arguments that have been made throughout the last 2 weeks. You have in your jury instructions a discussion about the facts, the elements of each of the crimes charged. You have part of your jury instruction, a discussion about suicide, because that's what's being argued in front of all of you over the last 2 weeks. So this case is about suicide versus homicide, because if you find that Emily Noble did not commit suicide, or if you find that the defendant, Matheau Moore, committed a homicide, that's when we're going to ask you to reach that verdict. But the reason that's an important distinction to make is because if you don't find one, you find the other. This isn't an accident, as Mr. Sleeper said in the initial close. This isn't an accident where Emily was walking through the woods, she tripped, and accidentally hung herself. The evidence is clear based on the pictures that you've seen from the scene over the last 2 weeks, and it's clear from what you're going to be able to see when you go back during your deliberation. And so it is paramount to understand that difference. Now, again, the focus during the last close that you heard from the defendant is, again, let's ignore the state's experts, that Dr. Agnew's report leads to all these other reports, and so if Dr. Agnew's report is garbage, then the rest of them are garbage. You've heard that over and over again for the last week or so when we've been referencing Dr. Agnew's report. The one thing that's apparently, again, didn't feel the need to discuss is that Dr. Garvin, the defense's own expert, agreed with the paramount parts of Dr. Agnew's report. So it's not garbage. It's not throw Agnew. And I apologize, you're not going to get as much theatrics out of me and you haven't over the last 2 weeks. I'm not going to throw pages on the ground to emphasize my point. That's not me. But to suggest that Dr. Agnew's report is completely garbage and so the rest of this is garbage flies in the face of what the argument has been made over the last 48 hours, which is that, Agnew's report, which is that Dr. Garvin's opinion is the only one that matters here. But not only does Dr. Garvin, and you heard her testify, agree with Dr. Agnew's parts of the report, talking about perimortem fractures, bilateral fractures to the hyoid and the thyroid cartilage. That's what we're here for. That's the injury. That's what led to the death of Emily Noble. What you also heard from Dr. Garvin is that she agreed with portions of Dr. Smock's testimony. She admitted to you, yeah, I cited this study, but when asked about the specifics of that study that she based her entire opinion on when it relates to whether this could possibly be a suicide, she folded. You could tell from her body language as she sat in that chair. Again, body language that you all saw and body language that you all should consider. She did this. She put her arms across one arm, across the other arm. She shut down. It was difficult when answering questions. Mr. Sleeper had to ask specific questions, and then eventually she said, okay, I got these details, and it doesn't fit exactly what we have in this case. And then on redirect, all of a sudden, the arms are moved. She's turning her chair, speaking to you all directly. And again, these are credibility determinations that you're all to make, and that's your job. Dr. Garvin also said on the stand that she was looking for something to refute Dr. Smock. And I highlight that to you because that's very different than when she first started testifying. They said, well, you don't know what you're going to get. When someone contacts me, they don't know what kind of report they're going to get. Could be good, could be bad, could be otherwise. That's my job. It's very different than sitting there and telling you all that she was looking for something to refute Dr. Smock. You ask yourself, why would she be looking, or why would the defense be looking to refute Dr. Smock? And I would submit to you that's because Dr. Smock told you exactly what happened in this case. Now, Dr. Smock, you'll have his report. He didn't cite to a whole bunch of studies. Dr. Garvin cited to a bunch of studies that we learned later on during the examination were bunk, but Dr. Smock didn't list a whole bunch of studies in his report, but what did he do? He sat there, answered questions from counsel, cross-examination questions. She certainly asked him questions about his background, his experience. And he sat there and he told you that all these years of his experience handling strangulation cases, he went through his CV, which is 50, 60, 70, 80 pages, as a lot of these CVs are. I would probably suggest you don't read all of those from front to back, but feel free. Dr. Smock sat there, looked at all of you, and explained to you what he found in this case. What Dr. Smock told you is that this was not a suicide. He explained to you why. He showed you and demonstrated in that chair the cord. It's not possible to cause these injuries. He demonstrated that to you. He said that the cord is about 1/4 of an inch in diameter, and that there's a space in between the two bones where the fractures are from, the hyoid up here. And he demonstrated how you could find it on yourself, the thyroid cartilage, and he explained that to you. He explained to you that the factors in this case, in Emily Noble's case, why we're all here, why we've been here for the last 2 weeks, point to this not being a suicide. Her weight, not possible. He explained that to you. That in his experience, over dozens of years, not possible. He explained to you that the ligature, again, not possible. He explained to you that all those factors that Dr. Garvin supposedly relied on in the study that she cited, those are factors that all weighed in favor that this is not possible. And he told you that not a single study in his research, his years and years of experience, ever found a situation where someone under 100 pounds presented with those 4 fractures: bilateral fractures of the hyoid, bilateral fractures of the thyroid cartilage. Now, although Dr. Garvin wanted to find something to refute Dr. Smock, I think it's clear from her testimony she didn't. She didn't. So not only did she tell you that was what she was trying to do, but she also admitted on the stand she wasn't able to. So we ask you to take that in consideration when judging the testimony of Dr. Smock and the testimony of Dr. Garvin. Now, you also heard testimony from Drs. Richmond, Dr. Hickman, and explain to you their portion of this case. You were just told on the closing of the defense that there are no pictures, nothing to suggest where the ligature was, whether there was a knot. And I would submit to you that's completely false. Look at the pictures. The Montgomery County autopsy pictures, they show you pictures of the neck area. They show you that the 2 cords that went under Emily Noble's neck were intertwined. One went off her back. You can see from the pictures where the cuts were made by BCI when they went out to the scene. And you can also see in the imaging that they did, exactly where those cords were. You also heard testimony from Dr. Hickman that there was no knot. So to suggest that there are no pictures, and there are a lot of pictures, is completely false. Look at the pictures. Look at all of them. From the ones that were taken on the scene from the ones that were taken during the autopsy. And yes, you may have to look at multiple pictures from different points in time. I'll admit that. But do that. And what you'll find is it's clear how the ligature went around her neck. It's clear there was no knot. And the reason that's important is because, again, all of the studies, the study that Dr. Garvin cited to, the study that was shown by counsel during the questioning of Dr. Smock as well as Dr. Garvin, the factors in this specific case, the only factors that matter to you all, were not considered in those studies. The unrebutted testimony of Dr. Hickman and Dr. Richmond is that Emily Noble died of multiple injuries to the head and neck. Dr. Richmond told you about the hyoid bone and how at that point, that's when they transferred the body from transferred the body to Ohio State to continue to evaluate. And Dr. Hickman's testimony on the death certificate is that the death was caused due to manual strangulation. Something that he told you, he determined this was not a suicide a week or so after he initially reviewed items prior to receiving Dr. Smock's testimony. And it was not until later on when that official determination was made and he sat in that chair and explained to you the process, how that process played out. And that's what caused the delay in the time as opposed to just waiting for Dr. Smock's report. Ladies and gentlemen, those are some of the experts that you heard from. You are going to get and you have in your jury instructions that you are to review their testimony amongst yourselves. You determine credibility as you do with any other witness, and you assign the weight that you think is necessary based on all of those reviews. And I think it's clear that you should be putting weight on Dr. Smock's testimony. Dr. Smock, again, as Dr. Garvin agreed with, his testimony, sitting in that chair telling you that this is not possibly a suicide. Now, it's easy in this type of case over 2 weeks to jump up and down, lay on the ground, do all types of theatrics. And I would submit to you, ladies and gentlemen, that at the end of this case, regardless of the outcome, Emily Noble is gone. She's gone now. She was gone when the defendant called the police and said she was gone. She was gone when he reached out to her sister and said Emily Noble is gone, and she's gone today. This is a serious case, and I think that's demonstrated by the fact that you heard 2 weeks of testimony. Now, making the distinction between suicide and homicide, as I mentioned, is extremely important. And as we diligently outlined in our first close and went through the evidence, and I'm not going to rehash that now, I think it's clear from the evidence, from the testimony of everyone that you heard from around Emily Noble's life, there's not a single shred of evidence whatsoever that suggests she would have committed suicide. Not only that, not a single shred of evidence that she would have committed suicide on that special day that she has between her and her sister. Where is it? It doesn't exist, because that's not what happened in this case. What happened in this case is that the defendant, her husband, Matheau Moore, murdered her, killed her, and that is why she's gone. So let's talk about that. Now, again, you were shown a giant stack of documents and said, look at all these messages, and they just want to show you these little flimsy handful of messages. And I submit to you because those messages outline what's happening in that 6-month period prior to Emily being killed. But I'd submit to you when you review those messages leading up and just a few weeks before the defendant calls police, calls 911, 8 hours after he's awake, is that his words, my marriage is over. What you'll also hear from the messages you heard from the testimony from Emily Noble is that I'm not wearing my wedding rings. Now, I'd submit to you, those are pretty important statements to consider when reviewing the other facts and circumstances of this case. Not the messages about maybe 8 months later, what do you want for dinner? 9 months later, I'm cooking dinner. Even 7 months later, what are we doing tomorrow? The statements that you were presented are statements that are directly related to this case, relevant to this case, to what happened in this case. And that's why you should give it its due weight. Now, what counsel said towards the tail end of her closing argument is that Emily wanted to find peace in the woods, in the forest, and that's what she did. Now, we'll talk a little bit more about some of the other facts and circumstances, but ladies and gentlemen, I'd submit to you that she couldn't find peace in the forest if she wanted to. She had no light source. She had nothing that could illuminate the area where she was found. And that brings me and want to draw your attention to the scene that was found. When you heard original statements made by Mr. Moore, he suggests, well, I left the room at 1:30, went to the bathroom, slept in the other room, and when I woke up the next morning, 10, 11 a.m., she was gone. Suggesting that Emily, at some point in the middle of the night, when it's dark out, early morning hours when it's dark out, went to this wooded area that you heard testimony from the three ladies that found her about how it's dark in there, can't see anything, and they explained to you what that looked like. You all were in the woods. You all saw the exact area where Emily was found. You were there in the middle of the afternoon. So you can discuss amongst yourselves if it was easy to see, if it was hard to see. It's different than when you're standing on the street looking up at the sun than when you're 50 yards in, 50 feet in, 60 yards in, whatever the amount was in this wooded area. Not only that, but instead of being there at 2, 3, 4 o'clock in the afternoon, you have to think that according to the defendant's statement, it's either the middle of the night, early hours in the morning, and nothing was found. There's been a lot of discussion about a water bottle, e-cigarettes, but the one thing you didn't hear is there was no cell phone, no flashlight, no other light source, and that's an important fact. The reason that's an important fact is because I'll agree with you, or I'll agree with counsel. Andy Moore's not a criminal mastermind. He messed up. He screwed up. And the reason we know that is from Officer Hollis's body cam. Now, when Matheau Moore murdered Emily in the woods, obviously he would have needed a light source, would have needed something to find his way out of the woods, to climb that real steep hill, trying to get up out of the woods, make his way back home. And unfortunately for him, the one thing he didn't leave behind, besides the water bottle and all the other things, was the light source. He took the flashlight home with him. And we know that because then when he called the next day, reported that Emily was missing, and was showing the officer and telling the officer this storyline, the timeline that keeps changing every time he's asked about it. About 2 hours into that, during a time period that Officer House testified he's out in his car, there's nobody else coming and going from the house other than the defendant. It's during that time period that a flashlight appears in the back of the garage. And again, that's the same area that now Matheau Moore is highlighting, saying, oh, look at this cord. This cord doesn't belong here. I might be crazy, but this cord doesn't belong here. And it's not only the fact that the flashlight is there, the cord is moved, but go back and watch that and go back and listen to what he says. It's not a situation where, oh, I was moving things around and I realized this didn't belong. This cord didn't belong. Officer House specifically asked him, did you touch anything? Did you move anything? And Matheau Moore says, no. You didn't touch anything. You didn't move anything. Now, I would submit to you that that was one lie of many lies that occurred over the period that Officer Hollis was there and throughout this investigation. And the reason that is important, not only because I believe the evidence shows that it's a lie, but that's the information that the Westerville Police Department is getting in that moment. The information they're getting is the information that Mr. Moore is providing them. And counsel wants to make show of a press release that went out the next day and other information that Westerville police may have gotten wrong, now looking back at it years later. But think about what Westerville police is doing in that moment on the 25th, the 26th. They're looking for a missing person. The only information that is being provided to them at that time is information provided by Mr. Moore because he's the last one that saw her alive. So to suggest that, well, Westerville, they were just shoddy police work, they didn't know what they were doing, they got this time wrong, this date wrong in this press release, I'd submit to you that the information that they were working on to find Emily Noble alive was information that was provided by Matheau Moore. Now, you were also just shown a video of Mr. Moore's demeanor when he finds out information from Officer Hollis that the neighbor may have seen Emily that morning. And a lot's been made about the thumping of his chest, his excitement. And I ask you again, go back and watch the body cam. Closing argument is not evidence, just like closing argument for the defense is not evidence. The evidence is what you heard from that box, what you have in the exhibits. Go back and watch that body cam. And think to yourself, what new information did Officer Hollis just provide the defendant? Nothing. Nothing was new. According to Matheau Moore's statement, he woke up at 1:30 in the morning, went in the other room, woke up around 10 or 11, and then Emily must have gotten up and left at that point. So think to yourself, why would now hearing that somebody else may have seen Emily get up that morning, the same thing that the defendant said, that's not new information? Is that the reaction you would have if you were just told, hey, maybe you were right? Or is that the reaction that you give when you find out, well, I might get away with this. Somebody may have seen her this morning or thinks they saw her this morning. So go back and watch the body cam footage. Think about the timing. We talked about an opening that, again, you don't just fast forward to the end, see the ending, and make your decisions. You got to look at all of the pieces as they fit together. And so it's not only important to hear what the defendant said, but it's important to look at his demeanor, his body language, and how those actions, what is happening around that. And that's no different than the cell phone records. What's happening around that? What information do we have, or what information does police have up to that point? Does his reaction seem like it's towards something new information that was given to him or something different? And then going forward. So please diligently review that. Diligently review that timeline. And I'd submit to you that that's not the demeanor of someone that is excited, that maybe his wife left that morning. That's the information he gave police. But it's something different. You also heard that, or saw a video of Matheau Moore seeing Celeste groan when she came to the scene, and Officer Hollis said, "Is that your wife?" And he, oh, I thought that was her for a second. Again, ladies and gentlemen, is that someone that's got the reaction of, oh, maybe that's actually her? Or is that someone that acts like that they may have just seen a ghost? They see someone that might look like his wife. He knows it's not her. If he was that worried about his wife coming home, he certainly would have spent the 10, 15 minutes to walk down the street to the walking path that she did regularly. But no, he didn't do that. He didn't do that either. So ask yourself, these are all pieces and things that are getting thrown around. Things that are, well, look at this over here, look at this over here. But it's important to look at them sequentially as they're happening. As Prosecutor Sleeper said, last week you may have been looking at pieces of evidence and thinking, how does this all tie together? And that's your job now as the jury. As any case, and I'm sure Ms. Benaschi will agree that we, in our minds, have an idea of how a case should proceed, and we try to keep it as linear as possible, and sometimes that's just not possible. But the reliance is on the jurors to take notes, to speak amongst themselves, The reliance is on counsel to get up in closing and to tell you exactly what sequentially is happening. Now, ladies and gentlemen, what you'll see in this case, and it's been presented over the last 2 weeks, and you'll see when you review the evidence, is that, again, the defendant's not a mastermind. What you can see is something that you all probably seen in your normal day-to-day lives, is that one lie leads to another lie, leads to another lie, leads to another lie. You can see that right away, again, in Officer Hollis's body cam. The defendant comes up with a story about this beautiful day he spent with his wife the day before. And now I want you to believe that she committed suicide that next morning. Spent this beautiful day with his wife. They had sex that night. He woke up at 1:30, and then the next day she was gone. Again, you can see from the body cam that Officer Hollis, who's been doing this for a long time, is seeing things that don't fit with what the defendant is saying. He looks in, sees that the bed is made, immediately says that, and you can see the reaction of the defendant. It's like, I just saw that. I just saw that. Thanks for pointing that out. She must have made the bed this morning. And then you can go in there. He goes in there and takes pictures during the search warrant. Go in there on the body cam. You can see the bed. And we submit to you, it's clear that nobody slept in that bed. Just another example of a lie. And fast forward, short period of time later with Officer Hollis in that same bedroom, Mr. Moore is now saying, well, she made the bed, but the pillows are out of sorts. So she must, the pillows don't make sense. Another lie. Sleeping pill. I took a sleeping pill. Sending that to his friends, to Arturo, and the text messages in the early hours of that night. And it's clear that from the phone records, which you'll have, and we ask you to review again, as painful as I'll admit it's painful, but please review those and looking at the timeline of all the events, that the defendant is clearly on his phone up till 4 in the morning, 4:30 in the morning, and then again at 8:30 in the morning. And the reason these details matter, details are important, because you have to compare that to the story that the defendant has been telling Officer Hollis initially when he first came out. He keeps adding on to, he keeps going along, adding different facts. The timing is all messed up. That he then, in his interview with detectives, is going through the timeline, and he immediately comes in and says, well, my time might be wrong, but here it is anyways. And when looking at the demeanor, and again, you ladies and gentlemen of the jury, your sole judges of credibility, look at the demeanor, use those everyday tests of truthfulness, the things you can do when you've got your 2 kids, if you have 2 kids telling you 2 different things, and you have to decide who's telling you the truth, use all those everyday tests. It's nothing special. What you can see in the defendant's interview is clear. The facts and circumstances that aren't at issue, that Emily Noble and Matheau Moore went to Butte, Ohio, went to a few restaurants in Uptown. Listen to his demeanor as he's telling that to detectives. It's fast, it's sequential, it's clear. He's able to give specifics. And then as soon as detectives start asking him about after they get home, that's when the timeline falls apart. That's when it's, well, it could have been this time, it could have been that time. Well, I don't remember. Could have been this, it could have been that. And go back and review that. You could see the clear change. Because instead of getting in there and telling the truth about what's happening, now he has to make sure that not only is he saying, but he has to remember what he said before that, and before that, and before that. And it's clear you can see that story change and continue to evolve. You can also see that when detectives ask Mr. Moore about his marriage. He talks about it being an 8 out of 10. And then when detectives start asking him about specific messages, Emily taking her wedding rings off, then all of a sudden it's, well, you know, there were ups and downs. Trust me, you guys, you wouldn't understand. Tomorrow, everything would have been fine. Again, when talking about specific things, facts that are not in dispute, there's one way of discussing these things with officers to detectives, and a far different way when pressed on specific facts and circumstances in that time period where Emily is missing and where Emily was killed. There was a discussion about some of the searches that were done in this case as well. And I'd submit to you, ladies and gentlemen, that you did not hear a single shred of evidence from that witness stand, any of the documents, any search the defendant was involved in. Not prior to reporting her disappearance, that 6-hour window plus, where the defendant is sitting in that bedroom doing nothing except for being on his phone. Nothing during that, after the report to police, or any of the months after that. You heard from various witnesses that talked about the fact that they went on 10 plus searches and had never met Emily in their life. And I ask you to consider that when looking at the other facts and circumstances. Why would the defendant not want to be involved in the searches? Why would the defendant, who's pretty clear initially to the officers and the detectives that you need to search this area, you need to look in this area, this is a walking path, you should look in that area. Why would he not want to be involved in that search, and why would he have not searched that area prior to calling law enforcement? Again, ladies and gentlemen, we're not asking you to use special tests. We're asking you to use your everyday experiences. Use your common sense and put yourself in that situation. What would you do? Your loved one is missing for 30 minutes and you don't expect it. Especially if you get up and you see wallets there, cell phones there, keys are there, cars there, and it looks like they just disappeared out of thin air. Do you wait 30 minutes before you do something? Do you wait an hour? Do you wait 6 hours before you even lift up a finger? Not until you call the friend, Celeste, who says, "What are you doing? Call the police." Not until that happens do you eventually call police. You don't go on a walk in an area that you know she frequents. You don't want to go check to see if she tripped, hurt herself and can't get up, hit her head, had another medical episode. You don't do that for someone that you're married to, someone that apparently you love. Ladies and gentlemen, use your common sense. The reason that man didn't go on any searches is because he could not be the one to find her. He couldn't. And why couldn't he be the one to find her? Because as he said in his interview, that would make him look bad. And I understand that was in a different context, but he knows. If he's the one that finds her, how is he going to explain that? I got lucky? Speaking of getting lucky, how lucky is the defendant that he points Westerville police to the exact area that she commits suicide? Out of all the places, the eastern portion of those woods, anywhere, any of the walks that they would have gone on, somehow he knows that 4 months later, that's exactly where she's going to be found. As we put it in the first close, that makes Westerville Police Department look bad. They should have found her. But that makes the defendant look far worse. He knew exactly where she was. And he knew exactly where she was because that's where he put her. That's where he killed her. That's where he strung her up to make it look like a suicide. And he knew exactly where she was until she was found in September. Ladies and gentlemen, not only that, but as we pointed out, and as you've heard from the testimony, not only did the defendant not go on any searches, but while everybody else, people have never met Emily, law enforcement is diligently looking for her alive, because at this point it's a missing persons case, a day or two after the report. That's when the defendant is not only not searching, but then suggesting that he's not ready to find a body in the woods. He's giving an interview saying, I didn't kill my wife. He's giving an interview where he's saying, I loved her, speaking in the past tense. The only person that is thinking of Emily Noble in those days after her report of being missing, the only person that is suggesting she's already dead is that man sitting over there. And ladies and gentlemen, I submit to you that the reason he's the only person is because the day that it happened, the day after, the 2 days after, up until the time in September when she was found, the only person that knew she was dead and murdered was that man, because he did it. And that's the defendant, Matheau Moore. Ladies and gentlemen, please, I understand this is a long 2 weeks. I understand there's a lot of evidence and a lot of things for you to consider. Take your time, speak amongst yourself, walk through the evidence, walk through the timeline. The timing in this case is extremely important. We asked you to do that in opening, and I'm asking you to do that again. When counsel implored you to write down all your unanswered questions, fine, do that. But ask yourself, what are the questions that matter in this case? Is the question of, were there bubbles in the water bottle, or was it something else? Are there questions about whether her shoes were tied once or twice? Are those the questions that relate to the elements of the offense, which is your job to go through, the elements of the offenses? Those are the questions that matter. Those are the questions that Dr. Smock answered for you. Those are the questions that Dr. Agnew answered for you. And honestly, those are the questions that Dr. Garvin eventually answered for you. So ladies and gentlemen of the jury, please be diligent in your look through of this evidence. And we are confident that after reviewing the evidence, the testimony of the last 2 weeks, you'll make the only finding in this case that the evidence supports. And that's a verdict of guilty on each count in front of you. Thank you.
Yeah, fuck all that nonsense.
Ladies and gentlemen, it's now the court's responsibility to instruct you on the final portion of your instruction.
Judge doing the last
Again,
part of
I
jury
would like for all of
instructions.
you to open up your binders to your instruction, and in the back of your instructions, there should be 3 verdict forms. And because I'm going to go over those with you, and I'd like you to have them so that you can review them and see as I share with you how these are to be completed. You have them? Everybody got them? You have 3 verdict forms. Each one corresponds to one of the counts in the indictment. The caption of each of these are the same. It says, in the Court of Common Pleas of Delaware County, Ohio, State of Ohio Plaintiff versus Matheau L. Moore Defendant, case number 21 CR I060340, count 1, murder, RC 290302A. Now, each of them will, depending on which count they are, have different denominations, but the caption basically is the same. Let me go in the order of the verdict forms, although you can decide them in whatever order you wish, because you understand each verdict is going to be decided separately without consideration as to your judgment on any other verdict form. So the order you choose to do it rests with you, but I'm going to go 1, 2, and 3. This says verdict on count 1. We, the jury, being duly impaneled and sworn, find beyond a reasonable doubt that the defendant, Matheau L. Moore, is, and there's the word guilty or not guilty, of the crime of murder as charged in count 1 of the indictment. Now, when you deliberate, you will determine collectively, because it requires a unanimous verdict, a decision in this case. So you discuss the case, you address what you find the facts to be, and you'll vote, and you have not completed your determination until all 12 have agreed upon the verdict, whichever verdict that is. Once you have reached your verdict, you'll note at the bottom it says circle the words or word reflecting your verdict above. And so you'll circle the word guilty or the words not guilty. Then you will date it, and this is all to be done in ink, and every juror will then sign it. And you'll note that there's a line for each one of you here that indicates your signature, a place for your signature, and you will sign it. In count 2, verdict on count 2, which is murder, RC 290302B. Again, your duty is to deliberate on this charge to determine your verdict unanimously. When you have done so, you will then circle the word guilty or the word not guilty according to your findings. You will then date the form, and then all 12 must sign the verdict form in ink. And on the final verdict form, verdict count 3, felonious assault, same process. You will then deliberate on this count, unanimously reach a verdict, and then whatever that verdict is, circle the word guilty if it's guilty, or the words not guilty if the verdict is not guilty. You will then date the verdict form, and then all 12 will sign the verdict form in ink. And that is the process that you'll follow to complete those forms. I'm now going to back on page 12 to conclude the instructions to you. So if you'd like to read along. You may not discuss or consider the subject of punishment. Your duty is confined solely to the determination of whether or not the state of Ohio has proved the defendant's guilt beyond a reasonable doubt. If you find the defendant guilty on one or more of the charges, the duty to determine punishment is placed by law on the trial judge. So it is not something you need to address or consider at all. Circumstances in this or any case may arouse sympathy for one party or the other. Sympathy, of course, is a common human experience. The law does not expect you to be free of such a normal reaction. However, the law and your oath as jurors require you to eliminate sympathy during your deliberations and to disregard it in reaching your verdicts. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, and then apply the facts to the law and to render your verdicts accordingly. Remember that you are not partisans or advocates in this matter, but are instead the judges of the facts that are in dispute. In fulfilling your duty, your efforts must be to arrive at just verdicts. Consider all the evidence and make your findings with intelligence and impartiality, without bias, sympathy, or prejudice, so that both the state of Ohio and the defendant will know and feel that their case has been fairly and impartially tried. If during the course of the trial, the court has said or done anything you consider an indication of my view of the facts, I am now instructing you to disregard that. It's not my job to determine the facts, it's solely your job. Your initial conduct upon entering the jury room is often a matter of importance, and it is often not wise to immediately express a determination or insist upon certain verdicts. If your sense of pride is aroused, you might hesitate to change your position, even if you decide that you are wrong. Thus, consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement, if you can do so, without disturbing your individual judgment. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the entire case with your fellow jurors. Do not hesitate to change an opinion if you become convinced that it is wrong. However, you should not surrender honest judgments simply in order to be congenial or to reach verdicts solely because of the opinions of other jurors. Again, because this is a criminal case, the entire jury must agree upon your verdicts. That is, and I repeat, all 12 jurors must agree on each verdict on each count presented to you. Moreover, the law requires that all 12 jurors sign the appropriate verdict forms in ink. When you enter the jury room, court suggests you first select one of your members to serve as the foreperson. The foreperson will see that your discussions are orderly and that each juror has an opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. If during the course of your deliberations you have an occasion to pose a question to the court, you may, under certain circumstances, or the court may, under certain circumstances, furnish an answer to you. If after you enter the jury room a question should arise, the foreperson should write down the question, specifically inquiring what your question is, and then should summon one of the staff members. And I believe here there's a light switch that you can use. Okay, you got the drill. So just hit the light switch and the court staff will then obtain your question and the court will provide a response to you. I will place in your possession the exhibits. You already have copies of the jury instructions and the verdict forms. The foreperson should make sure that these items are returned to the courtroom once you have reached your verdicts. Until your verdicts are announced here in open court, you are not to disclose to anyone the status of your deliberations or the nature of your votes. When all 12 jurors agree on the verdicts, all 12 of you should sign and date the appropriate verdict forms in ink, and then you should summon a staff member by using the lighting system for the jury in the deliberation room. You then will be brought back to the courtroom where we will announce your verdicts in open court. Jurors 13, 14, 15, and 16. We ask you to serve in this case as alternate jurors in the event any misfortune were to befall any of the other 12 jurors. They all look pretty happy and healthy to me, so I don't know that we need for you to serve in that capacity. Now, this may be good news or sad news, but there'll be no further requirement that you be here during the course of deliberations. However, I am going to ask you to do two things for me. One, make sure, and I hope you all have cell phones, or at least you'll be near a phone that you can answer. I'd like you to provide that communication information to Becky. I do so because there may be, during the term of deliberations, something that would befall another member of the jury, which would require an alternate to fill in and conclude their portion and seat as a juror.
Legally, I don't think you can
So
do that
you're
once he
not
discharges them,
entirely,
technically.
removed from these proceedings. Correspondingly, I'm not going to tell you you are released from your admonition. You still must follow your admonition until the verdict has been rendered by your colleagues. So still, keep to yourselves, as you have been doing the past 2 weeks diligently. What we will do is, in the event the jury reaches a verdict and you did not have to be called back, the court will call you and not only advise you what the verdict is, but indicate to you, and I'll tell you now, you will then be released from your admonition and you may discuss the case with anyone you wish or read anything about it that has been set aside. I have noticed all of you have been paying very close and diligent attention to this case in anticipation you could serve, and I appreciate that greatly. And I, most importantly, thank you all for the service you've given to this court. Your role here was important. If something had happened to a juror, we needed to have you fill in and continue with the case. So your role is significant in our justice system. And again, I thank you. When the jury retires to deliberate, you may go out with them, and then Becky will indicate that you are entitled to go on your way. But just make sure that you're available for communication with the court in the hopefully unlikely event we would need you to come back and serve in a capacity to conclude these proceedings. Would counsel please approach?
Okay, guys, the judge is a retired judge. He's a judge from down by Dayton, Ohio, over almost an hour and a half away. He is a judge who was on the bench for probably almost 20 years, and he's now retired. Once he's retired, the court uses them as a visiting judge, and he fills in places where there's a conflict of interest or a judge is unavailable. So if a judge gets sick or if a judge leaves office for whatever reason, He is a visiting judge. He is no longer actively presiding anywhere. He fills it kind of like a substitute teacher. Now that's important because he doesn't have to worry about elections. He doesn't worry about anything else. Yeah, well, this guy, I mean, he's old. Yeah, I'm pretty sure he got his law degree back in the 70s. I mean, dude's old, man. Old timer. You know, he had a 25-year career as a prosecutor. So he's an old school guy. So yeah, it's the only person up for election in the situation is the lady in the brown/red hair, and that's not until 2025. So the prosecutor's not up anytime soon either. Sorry, I just wanted to make sure that was clear. There is no issue about that. Let me see here. Where did we? So guys, yes, as I tell you, when the police come to talk to you, shut the fuck up. I bet Matthew wishes he would have shut the fuck up now in hindsight. Looks like we got more to talk about.
With these good lawyers out here, I'm going to make a change, kind of a major change, actually. They've asked me to specifically have 2 verdict forms on each count. So instead of 3 verdict forms where you can put an alternate on, I am going to draft 2 verdict forms on each count. And one verdict form is just going to say guilty, and the other verdict form is going to say not guilty. So rather than taking one of the forms and circling it, you have a specific singular form that will reflect your verdict. And again, whether
that's not abnormal,
guilty or not guilty, all 12 must agree and sign the verdict forms. But that I'm going to change that and then provide those 6 verdict forms in the jury room. When you reach a verdict on one count, one way or the other, you do not fill out the other form. You'll just leave that form blank. However, when you return back, you can provide to the court all 6 forms, and I will review the verdict form that you complied with, or you determined your verdict. So that's the one change I'll make. So you don't need your verdict forms anymore. You can write notes on them if you want. Oh, and by the way, I also want
you should confiscate those, man.
You take your notes back with you.
That's fucking bad luck.
Understand that you're entitled to take the notes with you. Refer to them during the course of your deliberations. We will, again, take your notes when it's over with, and we will shred them. So they're not going to be made a part of the record to reflect upon what you wrote. Those are confidential and personal to you, and they will remain that way. But feel free to use those notes in any way you feel appropriate, and follow the court's instruction on notes regarding any discussions about what someone remembers or what someone wrote. All right. For 12 of you, I am now formally removing you from your admonition not to talk to each other about the case. In fact, your duty is to talk to each other about this case. So I'll leave you in the hands of our court reporter, and we are in recess. Thank you.
Okay, yeah, no, take all the, you don't take all the, yeah, that's just not good. If they have jury forms or verdict forms, no, you only give them the ones you want them fucking with. Come on, Judge, that is not, I don't like that at all. Don't like that at all. So.
We need your phone numbers too if you want to leave. So
I also think it's actually illegal for them to recall the jurors. If they're dismissed, they're no longer there. Although that's not usually been an issue of contention.
we are on the record outside the presence of the jury, all parties, including defendant, are present. Yes, sir.
I just want, yeah, and this doesn't need to be on the record.
Oh, okay.
That's
right. We don't have the record.
For scheduling purposes.
Being recorded, though, it's still the record.
Generally, just let the jury.
I mean, we could still listen to it. Yes, the judge has a very good radio voice. So, yeah, guys, you always shut the fuck up. Because now, look, he may have said something completely innocent, and now they're using it against him. Everything he said Everything you do or don't do, they'll use against you. If you help look for them, that means you know where you're leading them away from it. If you don't help, it's because you don't want to show them where to look. Yeah, everything you do, a prosecutor can and will use against you. So you'd want to keep your notes. I think you'd have that right sometimes. It depends. Some places just can't take them and you don't ever get them. You lose them. Did Anne of Green Gables is asking, did he take the stand? No, he kept his mouth shut. Rightly so. So I know there's a couple of starred comments, and I'm going to switch to me talking now so long cucks can fuck themselves. Hi, fuckers. I hope you try to copy strike me now. So Shizzle's talking about, meanwhile, in the Parkland shooting trial, the defense is trying to blame his mom for how he turned out. It's an entirely different situation there. Their only goal in Nicholas Cruz's case is to avoid the death penalty. If he gets a life in prison without parole, that is the victory. So when you're in a death penalty case, you fucking Twinkies did it. The gangster rap made me do it. Anything made you do it. You look for something. You got to get out of it. That's just how it goes, man. You may not like it, but that's an entirely different game plan. Especially when you fucking flat out admit to it. So that's a little different there. I'm going to take these off now because I don't have to listen anymore. So get them off my ears. Bifrons is saying, is Delaware County a super low crime area? It's not super low, but like if you live in Columbus, Delaware County is not a bad place to live. It's pretty chill. It's kind of expensive, but yeah, I mean, I would rather live there than in the Franklin County where Columbus is. I mean, most people try to live on the outlying counties surrounding it. So it's pretty good. It's pretty good. Pretty good schools, all that fun stuff. Ron Sappington says, I've noticed people seem to be happier and non-confrontational before killing themselves because the plan is already made to leave this world. Yeah, that's a very common thing. You know, they're at peace, finally. Aaron Gogol says, why would he not want to be involved in the search? Because if he had been involved, they'd say he was controlling the investigation. Exactly. If he helps, he's steering them away. But if he doesn't help, he's trying to steer them away. So once again, it's talking with them. You can't win. None of your actions are going to be winnable. You're going to look like a bad guy no matter what. And yes, in this situation, 99% of the time, the husband did it. I mean, he's suspect number one. So yeah, they're going to focus on him to start with. Jim Satala says, and Jim, like I said, I always love when you got something to say here. All this proves is that you should never report anyone missing and never talk to the cops. Well, maybe you should report someone missing, but after that, no more talking to the cops. Anytime you talk to them after that, yeah, you look like a suspect. But also remember, if you sit there and say, well, he used a lawyer, well, that's going to make you look sketch too. Everything you do. But at least if you're quiet, they can't say you said something. Alex Henderson says, I loved her. Why'd she leave? Seems like it would make a total sense as a reason to speak in past tense to me. Yeah, but remember, these guys are looking for any reason to jam you up. So they will take advantage of everything you say. And like I said, I bet Matheau Moore now is wishing he'd shut the fuck up. So David Davidson says, I bet Papa Wolliver tells the best stories. Oh, old-time judges, old school judges, especially retired ones, they're just full of stories. There's this one judge I've been in front of a couple of times. He's old. I think he does it so he doesn't die. Talks about when he was in Cleveland as a defense attorney running into Don King doing stuff. So, yeah. The old school judges have the coolest stories. I remember this one judge telling me about a murder case he tried in 1968. They always have great things to talk about. HM, the district attorney elections matter. Pay attention. Very true. Commonwealth's attorneys, state's attorneys, district attorneys, prosecuting attorneys, in Ohio they're called prosecuting attorneys. All those elections matter. And if you live in Delaware County, you should look at this and say, do I want this lady in charge? Because ultimately it's her decision. She's calling the shots. It just, Shizzle saying, it just sucks that we live in a society where everyone should have a retained attorney just like we have doctors. Yeah. Yeah. I mean, it does suck. Alexander Henderson, that's what the rebuttal felt like, throwing both sides of everything he did back in his face. Yeah. I mean, you are dealing with people who are, you can't win. You can't win. If they're convinced you did it, then everything you've done is something to further that. If they're completely convinced you did it, you're not gonna make it out of there alive. And that's just sadly, that's the nature of it. That is the nature of it, sadly. So I would, just say that. Let's see here. You have a doctor? Oh, I think you're talking to Shizzle. Well, most people have like a primary care physician they work with or establish a relationship with. Maybe he's fancy enough to have an on-call doctor. Justin Smith says you can't report someone missing and not talk to the cops. That would look horrible. Well, you can talk only so much. When the police arrest you and they put you in the back of a police car and they read you your Miranda rights, once they start reading you your rights, that is the hint to shut the fuck up. If you haven't already shut up, when they tell you you have the right to remain silent, when they're giving you the warnings, they're giving you the warnings because they think you might be a suspect. If they either think you are the suspect or they think you could be a suspect. At that point, you should realize the game is afoot. Shut the fuck up. If you haven't done it yet, do it then. Saying, oh my God, I didn't do it. Imagine if he hadn't said that. Imagine if he hadn't said those words. And imagine, because once he's been Mirandized, that post-Miranda silence cannot be used against you. Because now you're asserting your constitutional rights, and that cannot be commented on. In addition, and he talked about her, that he loved her. Imagine if he hadn't said those two things. Those two things. Like, and look what they harped on. You have to shut up. Shut up, shut up, shut up, shut up, shut up. So like Dave Chappelle said, he's like, shut the fuck up. Sky Queen says, but they also use his words before he was Mirandized. 100%. And that's why you don't talk to the cops if you can avoid it. Sure, my wife was missing. When did she disappear? Then. I got nothing else to say to you. You can leave it at that. But you keep talking, you're going to dig yourself into a hole. And that's why you also don't talk to the press. Because notice what they talk about. Notice what the prosecutor said. He got up and talked to the media. They point that out, and they will use it against you. Don't talk to the press. Don't talk to the cops. That's why she wanted somebody. That's why he wanted Toby Walker saying. That's why he wanted somebody else to be a spokesperson for the family, so as not to further incriminate himself. Yeah, and remember, this is also a PR situation. If you look sketchy, then it makes it more like people are going to say, okay, well, we have no problem with this person being prosecuted. Chaucerian fraud. Hello, police. My wife is missing. I don't wish to answer personal questions. Click. Okay, obviously you can answer some, but be intelligent about it. Really what you should do is like walk in with an attorney saying, my wife is missing. Here's some information. I mean, I'm not going to lie. I already told my girlfriend, future Mrs. Martin 2.0, if I disappear or I die under sketchy circumstances, I've given her a card. It's got attorneys' phone numbers on it, their cell phone numbers. Her first thing to do is call one of those numbers. Not the police, not anybody else. She calls a fucking attorney first, and I want her to call an attorney first. I don't need her being jammed up or shit all over by some dumb flatfoots thinking she killed me. Now, yes, if I'm sitting there, carving the turkey at Thanksgiving, and for some reason I decide to gargle the turkey trimmer and start bleeding everywhere, okay, fine. I hope she calls the ambulance first. But she walks in and finds me dead. She closes the door, calls an attorney, and then calls 911. The Pants Maestro, pretty good name. Legally, Sean, how's this going to a jury? Is it judicial weakness or our laws is broad? I brought this up yesterday, but I guess we'll go through it again. And I'm not saying that to make fun of you here, because I don't know if you were here for it. There are rules of criminal procedure in Ohio, and the rule as far as regarding directed verdicts and acquittals is pretty straightforward. Well, if this thing fucking loads, it'll be straightforward. And now the damn thing's frozen, so I don't even know if I'm talking to you guys right now. Fuck. This is just great. This is just great. But for the use of, the motion to dismiss or a directed verdict. It's not really a J&OV in a criminal case. That's a civil thing, but it's pretty much the same thing. All right, there we go. Sorry, guys. I'm sorry for wigging out too for a second. That was just pissing me off. We are going to go down to Rule 29 of the Rules of Criminal Procedure. So this is the rule. This is the motion for acquittal. It's not that the law is, it's not weakness. It's just you view, and when you make this motion here to, that the evidence is insufficient to sustain a conviction for the offenses, you have to look at it the light most favorable to the non-moving party, which in this case is the prosecution. So every bit of evidence they've shown, you have to look at it in the most favorable light, thinking, okay, it's true and it's credible. Well, at that point, unless they've not presented something or they have suffered a structural fault in their case, generally their cases are going to be given to the jury. Now, I think at the end of the day, I think we benefit from having juries decide things as much as possible. I think that's a healthy check on the system. Now, do I think this judge was weak about it? I like to call him a pussy because he didn't make the tough decision, but I understand why he also didn't do it. There is enough there for him to let this go forward. Yeah, that's what I would look at here. And when you look at this rule, it's just, you talk about they haven't met the elements, to a probable cause standard at the very least, and a jury couldn't make a decision. But that's it. So JC saying you gave her an out. Yeah, I did. I don't want her to sit in jail or any shit like that. That'd be horrible. Toby Walker is saying if you murder your partner, get an attorney before you report them missing. Might not be a bad idea. What is the extent of not talking to the police that you suggest? Like, what if it is a traffic stop? You answer the bare minimum questions you have to. Hi, sir, is this your vehicle? Yes. Is license and registration, please? Sure. Can I, is this address correct? Yes. Do you still live here? Yes. Anything like that, I would tell you to answer. When it comes to, hey, where are you coming from? You don't have to answer that. Where are you going? You don't have to answer that. Do you mind if I look in your car? Obviously, you don't have to answer that. You tell them, fuck off. No, Biggie, you ain't searching. Is there anything in the car I need to know about? Those are all the questions you don't have to answer. And you shouldn't answer. So that's what I would tell you. That's how I would look at it. So those are the questions. If they tell you have to answer me, if you've provided him with license, insurance, and registration, and you've given him all the stuff and he can verify that's all correct, that's all you have to show. The rest of it, fuck him. Now, guys, I am going to have to switch over to the car because I have to go to the post office and go bitch at the postmaster because I've been having some issues with my mail. So we are going to be switching over to Los Telefono. But I can answer questions as we're driving. Chesterian Fraud saying, even if she murdered me, I want her to have representation. True. But I also just don't want her to sit in jail if she didn't do it. Ethan says Sean gets murdered and gives her the keys to success. Hey, if she comes at me and she takes the belt, if she's able to get one over on me, all the power to her. I mean, I'm not saying I'm the most dangerous game in the world, but if she figures out a way to take me down and gets it done, I'll golf clap to that. Toby Walker, saying it's very upper middle class and or bad guy to have an attorney on speed dial. We don't have to have him on speed dial, just developing a rapport with one and saying, just having one in mind. That's all I would recommend. Just have one in mind. Have a number written down somewhere. Poor but decent folks don't have the access. Very true. Or the need. Not true. Just because you haven't been fucked in the ass by the government doesn't mean you won't. Or can't have that happen. Not everybody needs a fire extinguisher, but it's a good idea to have one. Okay, I'm still live. Okay, yeah. Well, I just wanted to make sure we were. No, we're talking. The phone's more important. No, it's just things weren't working right on the my computer froze up. Someone is in a jail cell calling for help. No, they're calling for the other attorney in this office, the guy I rent an office from, rent stuff from. They're calling for him. Well, there, Justice Smith saying, see, the attorney didn't answer, so now they're talking to the cops. Well, they're not calling for me. I know that much because it wasn't my phone ring. It wasn't my line. But he's got people answering their phones. You guys are smart asses. Oh my gosh. Crime Talk aficionado, proof that Sean really loves his girlfriend. I do. And if that's the gauge of it, then yeah. I got no complaints. Let me see here. Okay, Toby, if you're taking off, have a nice night. Take care. Matt is saying if she takes over, she'll mute herself less than me. Yeah, she's actually pretty competent at stuff. So, yeah, I wouldn't doubt that for a second. I would not doubt that for a second. Everyone gets their turn. Yeah, everybody takes a turn in the barrel at some point. Government is pro-ass fuckery. Yeah, they are. They are pro-ass fucking. All about that ass. Harvey gunsmithing. I've got a lawyer and retainer solely because in my business the government loves to fuck us over. Yes, they do. And it's a good thing you recognize that because that is 100% true. What the hell is wrong with my... What the fuck? All right. Do you have a 24-hour line if someone is getting arrested? Do you like hop down there right away? Or do you wait till you're in the office? There are some people that if you get a hold of my cell phone number and you call and like you tell me you're down to fuck and you got some cash and you want to pay, or if you are a former client of mine, a previous client of mine and something happens, yeah, I've shown up at the jail middle of the night before. Not often, but I do it sometimes. Otherwise, yeah, you probably wait until the morning. Okay, why is this not... My phone is not working with this. I don't know what the fuck is going on here. Perks of hiring... Ethan saying the perks of hiring means the next time you commit a crime, I come quicker, like real subscription perks. Yeah. Well, that's the ultimate subscription, is put me on retainer. And I'd be waiting for my public defender. Some people might be. Crime Talk aficionado saying government is all about getting that butt. Yep. 100%. The kids say 100. Or as they say nowadays, I think, no cap. I fucking forget. I watch enough TikTok. What the fuck is wrong with this thing? All right, guys, I am going to... I'm going to be heading out from here, but I will leave things running. I'll leave it like this for now. So I can cover things up. Get rid of Yeah, guys, I'm here. All right, hold on here. Sorry, I had to get things sorted out. Okay, do I practice in multiple states? No, only Ohio. Muted, no volume. We are on music. Yeah, listen to your heart when it's calling to you. Boomer strikes again. Thanks. Fuck you guys. Fuck all of you guys. If only you guys were all about super chatting like you are, making sure I. You guys worried about the super chats as much as that. Real quick, Ethan says people calling from jail help. Sean, the postman angers me. Well, hey, if you're not mad at the government, I don't know what to tell you. Ethan, I'll get to this one in a second. All right, guys, I gotta hop in the car.
Those are for jury
Okay, I am back. Hello, guys. Fuck you, Verizon. Fuck your 5G. For God's sake. Fucking A. Okay, guys. Sorry, I'm trying to catch up on all this. This was just absolute bullshit. Couldn't get fucking internet signal for like whole fucking way home, and then all the traffic. Such bullshit. All right. Yes, this stream is sponsored by Cornell Lighting. Sean is really giving me that postman. I wonder if he gave him a free heli ride. You know what? If I had the chance, I probably would have at this point, because just, when you have 5G on your phone, but it's like, oh, sorry, we still can't connect to the internet. Absolutely. Just, fucking annoying. Yes, Matthew is correct. There's 3 lights. There's a middle one. Then there's the green one on the bottom. Yes, I came back on for a second because apparently Verizon's 5G will connect for a second and then it gets all autistic again. Oh, God. Yes, Ethan's 12 jurors, 13 sets of toes. No evidence. You guys are awful. You guys are awful. Yes, Ohio's Eastern Standard Time. I don't know how late he's going to let them go for, but he'll probably let them go for a little while. They could stay really late. There are some judges who make you stay till 10 o'clock every night and deliberate. Some let you decide on your own time. Bifron says, I like Sean. It pisses me off he doesn't have 100,000 subs. Yeah, me too. Arash. Sean is the closest thing to our generation's Dr. Martin Luther King. Presented with, I won't comment on that. What happens when the light turns green? There's a verdict. Sean cell services. I don't think my cell server is barely working. I'm running at Zach Morris phone speeds. Oh. Yeah, the jurors are going to find the toe. They can throw the toe bones in as a soup stock. Okay. Yeah, I think I might have to do that, but I've never had that problem where literally I drove back the entire way and it would be like, oh yeah, you got a full bar. Sorry, with no internet connection still. That was just pissing me off. Absolutely ridiculous. So, anyway, sorry about that, guys. I think I caught up to everything. Ethan did have a question for me. What made you decide to do criminal law? Because I feel like that's where, you always go. That's where you're going to go to trial. And I thought trial work would be fun. And I interned in a prosecutor's office up in Toledo, and I really liked it. Criminal law is fun. It's the fun, sexy thing too. You don't make Maserati money doing it. If you want to do that, you go do personal injury like Attorney Tom. He's doing good for himself. You do domestic relations stuff like the lead attorney. That's how you go ball. Or, DUI guy, just doing like DUIs. Like, yeah, those are ways to do it. I think criminal law is interesting. I also feel, it sounds hokey, defending people's rights and being involved in, that part of that business end of citizenship and civics. Literally what I'm doing is something you learn as a kid about the Constitution, which is kind of neat. My theory is still that the Bone Girl stole the toes for her personal collection. She could have. So, yeah. So that's where we are right now. So we're waiting on them to come back. We will center up on me for now. Did just want to let you guys know, but apparently I think most of you already do know. Tonight at 9:30, we will be having another live stream. We'll be covering this. Aaron, I know I'm way too optimistic about the degree which kids today are taught the Constitution, but hey, a man could dream, can he? Oh, my mods are back. My sexy mods are back. Coming to Thought Patrol. So let's see here. Critter. Hey, Critter. How you doing? Hope everything went well for you guys today and you guys didn't get cucked covering the cruise sentencing. How is that going, by the way? But yes, they do love me. All the ladies love me. You booted them sex bots if they weren't hitting the like button. Yeah, hey, do what you got to do, man. I fully support you guys. I support all my mods because unlike, Ricada's mods, mine aren't gay. Mine are God's people. What was I doing? Okay, where am I at here? Oh, 103 likes. I'll take it. I think I'm going to end the poll now. We'll see what happened here. All right, so the poll is over. 44% think it's going to be 1 to 3 hours deliberation time. Okay. 27% think 6 to 8 hours. 17% think 10 to 14. And then there are 10% of the people who said 30 to 60 minutes, and they've completely lost already. Sean, Lane's asking, did I see Farron last night? No, I did not. Rackets is the president of the USA. I think you were chosen as the head of the FBI or CIA. Yeah, somebody put me down as head of the FBI, which is funny because I would abolish it pretty much right away. So, yeah. They wouldn't last too long if I was in charge. Yes, Justice Smith, 10% are wrong, yes. Just a little bit. Oh, come on. So let's see here. Oh, we got a question. We got a question. Well, Ethan, are you a law student right now? Even if you're not, shoot me an email. I'll be happy to talk to you about stuff if you have questions. I can give you some insight because I did work as a public defender for a couple of years. 7-Eleven's an inside job saying I wasn't wrong, the jury is wrong. Yeah. But yes, the jury is bright yellow. They got a question. HM says yellow light means hit the gas. They're asking, when can they leave? They want to go home. Yeah, that could easily be an issue. They're asking that because the judge didn't clarify that yet with them. Sometimes that is the question. Your undergrad going your junior year. Oh, okay. Well, good luck with the LSAT. Why would Trevor Summers choose to defend himself? Because he's an idiot. I think primarily he wanted to go up there and kind of be awkward to his wife. Because he did cross-examine her, and that was when he took over. I think that was solely just to screw with her and get one over on her. Also, I mean, that could also just be complete hubris. I mean, he thinks he's smarter than everybody. So, I mean, who really knows? Usually it's a combination of like both. You know, somebody thinks they're smart and then somebody's just completely wacko. Every once in a while you get somebody who wants to be a dick and cause problems. Yeah, they're asking, how do you spell fuzzball prosecutor is annoying? But who knows what the question could be? I mean, I know one time I had a question where the jury sent back a question of, we're voting guilty, but what do we do with the other forms? How do we mark them? So you're like, okay, well, that's a preview of the verdict. So that happens sometimes. So, or it could be like, in a, Matt saying, one of us wants to vote guilty. Can we have a long USB lead to help us and get an alternate? They could be doing that too. So it's going to be a couple of minutes. Even though the defense attorney was, Minashi was probably told to stay close because her office is downtown Columbus. It's a little too far away. She was probably told to stay in the area. She's probably in the courthouse somewhere. The prosecutors are nearby at their office. They're, hanging out. So, yeah, it'll be a couple of minutes, but they're going to get everybody together. They have to get, they probably have Matt Moore. He's probably in the back. But it's also close to dinner time, so they may have fed him already. Okay. Let's see here. Are we back yet? We're still waiting. Sorry. Stupid lights on green. We want green. What if no one sees it? Oh, somebody's gonna see it. Maybe it's a bathroom break. They should generally they have a bathroom in the jury, like there's a bathroom off to the side in the jury room to prevent this being an issue. Their courthouse is a new courthouse, so that's not a problem. Yeah, man, I don't think that's the case either. What does this switch do? Hellcat, how are you doing today? Hello. They 100% know what's going on outside that courtroom. If this dude is guilty, you can fuck a ham sandwich and then convicted of rape in this county, apparently. Hey, you can indict a ham sandwich. I mean, I've said it before and I'll say it again. When you get indicted, you're already behind the curve because everybody thinks you did it. So it's hard. Oh, Ethan's saying no, the screech is for us at home. Okay, fair enough. What? You gonna bark? Bark. Come here. Hi. Are you all good now, puppers? You got fed? Interesting. You guys are having an encounter with one of the dogs and they're keeping their mouths shut. It's pretty crazy. But yes, as I mentioned just before I left, the defense attorneys across the state are commenting on the temper tantrum that occurred this morning and, made the comment like that would not happen if we tried it. And that's true. If we had walked out and said it was a sham and said, fuck this and walked out of court, hoo-wee, I'd be sitting there with some bracelets on. So. Okay, guys, sorry. I am looking something up here. Sorry. There are a bunch of attorneys shitting their pants over that, and I think rightfully so. Okay. Jackie Randazzo, there's going to be a question. We don't know what it's about. Yeah, the prosecutor walked out this morning, which I thought was a load of shit. I can't believe the detective is still there. He's like part of the team. Oh, yeah, he's going to stick around. All the work they put on this case, they generally hang out. No, the judge denied the motion because he did it in the most light, most favorable to the prosecution. He did circumstantial evidence, and then he made a ton of inferences, which I don't think he should have done, and it's bullshit, but you know what? It happened, and you can't change it. So, just a question, Jim. Just a question. Yes, 100% correct. The jury was not there when he walked out. No, but I would not have the balls to do that. I can tell you that much. You call me a bitch all you want. I ain't doing that. Let's see what happens, guys. All right, we're waiting. Ooh, even Court TV's now got a thing about this going down. Yeah, yeah, it's catching on. So let's see where we are. Which prosecutor walked out? The beard guy. But the actual prosecutor, Melissa Schieffel, was not there. But yeah, they basically said, "Fuck you, we're not coming in right now," because they had other stuff they were doing. Yeah, it'd be nice if they had to suffer consequences for their actions, Aaron, 100%, but they won't. Look at all the discovery behind them and all their trial prep. That's a whole table full of banker boxes. God dang. That's a lot. So we're still waiting. Well, I mean, like, what's the boldest thing I've done for my client? I mean, I've shot my mouth off before in the court, and I've had a judge threaten me with contempt more than once. One time, do I think I deserved it? Sure. The other times, do I think it was a bit irrational? Yeah. But like the one time I did it, I'm pretty sure I was this close to like at least being taken in the back for at least 20 minutes. But I mean, yeah, I'm willing to do that. I mean, I've showed up and you know, I ended up meeting with a client who got raided by a narcotics task force. And when I was out there at his house doing some of my own investigation, looking at like when the police raided it, where they raided from, and how it looked when they came in, I ended up getting surveilled by the narcotics team because they thought I was there buying drugs for a little bit. But I mean, nothing super crazy. Nothing super crazy. I mean, that I can really comment on. There's some other stuff I've been involved with that I really can't talk about. So how much do you think this trial cost, Matt? Well, the bigger thing is like, just think about how much sanity, your son dies, your wife dies, and now you're sitting in jail for a year. I mean, I mean, they could take everything from you. Can the judge file a grievance against Fuzzball? Oh, he certainly can. And I would argue if nothing happens to him, that is a fucking travesty. I mean, that is fucking pathetic. Like, bro, you need to fucking stand tall. Like, when the judge says your ass is staying here and listening and you call it a sham, why is it a sham? He's just talking about a ruling that was made the day before. It's not like he's asking you to go forward and proceed without her. He's literally just going to say, I made a decision. And you're going to sit there and cry and call it a fucking sham? What kind of bullshit is that? And then you just walk out? Fucking A. Like I said, he got bigger set of balls than I do, but it also helps that he's a visiting judge they're never going to see again. So you could be a big fucking dickhead. If it's the judge you're in front of every day, he probably would have thought twice. Yeah, that could be very true, Jim. Yes, Rules. We are on jury watch. Hey, y'all. Yes, he could have held him in contempt and had him stacked in the back. Matthew, if you vote NG, they're going to say you haven't been watching the trial. Well, the juror's been watching the whole fucking trial, bro. So I don't know, like, how they would disagree.
Thank you. Have a seat. Ladies and gentlemen, you've given your indication you wish to conclude the evening proceedings today, and so that will be granted. As always, you get to go home tonight. I do wish not only to share with you to remember your admonition, but I think that's even more important since you've begun your deliberations. The case is on your mind. And I think I'm going to make this even more of an emphasis tonight. When you go home, don't think about this case. You only deliberate when you're all 12 together. So it's even more important that you relax, have a good meal, enjoy yourself, take it easy. Don't think about the case. Get a good night's sleep.
Don't kill your wife.
Come back tomorrow. Now, I also understand that it's your desire to be here at 8:30 tomorrow to resume your deliberation. So what we'll do is what you've always done, go to the third floor.
8:30, goddamn, they are like dedicated to this.
We'll then bring you up here and take you to your jury room. No need for us to get together or be in court. As soon as you go in and when all 12 are there and you close the door, begin your deliberations. Any questions? All right. Have a good night. Thank you.
No, I was expecting that, Matt. It's getting kind of late in the day. Remember, these are people with daily lives. They've got jobs and families, and like even though they haven't been working for the past 2 weeks, like they got kids. But yeah, they want to start early. That I will give. These are some go-getters. Usually jurors are like how fucking late can we show up? Like, can we show up at like noon? So
Great question. Just be available. I mean, the only time we'll need them is if they have a question or that they've reached their decision. So, as always, do what you want to do. Free to roam around the county, but just be available. Thanks.
Wow. Oh, so he's telling them they could stay within the county. So they're going to make Diane hang out tomorrow in Delaware. The county seat of Delaware is Delaware. She works out of Columbus. So I have heard a thing or two that Diane may have taken this case pro bono. I'm not sure. Or she took it initially under retainer and then she just went pro bono for the rest. Don't know for sure about that. But anyways, yeah. Oh, there's the dog now. Yeah, imagine trying to walk out on Borowski. Well, there are a bunch of judges I would not want to try that on. Most judges I would not try that on, especially if I ever wanted to practice in front of them again and not be treated like shit. So, yeah, guys, this morning the judge started off his Rule 29, his motion and discussion about the... Oh, Ronnie, say you'll see everyone tonight during the live. Yeah, we'll see you then. He wouldn't get back in if he walked out on Borowski. I think Borowski would have held him in contempt and demanded show cause right then and there. So, Jalen K is, I think, not guilty. Not guilty all fucking day long. And it's not just because he's defendant. I mean, there's some of these where it's like, okay, yeah, you're screwed. This one, no. Yeah, so that was a big thing this morning, guys. Literally, the judge said, well, I'm going to discuss my ruling because he hadn't discussed it till this morning. And Beardy McBeard Pants said, well, this isn't fair. The prosecutor's not here. You knew that. And I guess there was some sort of phone pretrial where the prosecutor indicated she had some sort of obligation she couldn't be at right away because she was doing her prosecutor job somewhere else or something where she couldn't be there right away. And the prosecutor, the assistant, started, throwing a temper tantrum about it. And then he said, I'm not going to sit here for this sham of a proceeding. The fact your boss wasn't allowed to be there, I'm not sure why you're going to call that a sham. Takes a big old set of balls. And then he just walked out. Judge said, you're going to stay here. And the guy said, fuck you, basically, and walked out. And then about 5 minutes later, while the judge is still working through his ruling, they all march in like the asshole brigade. So, yeah, it was very interesting from their part. Brittany says, isn't it his job to stand in for her? Yes. Yes, it is their job to be there. They represent her. They represent the county. And the idea he can't stand there through the Rule 29 motion without her, because I think they thought they were going to lose. I really do. And when you listen to it at the beginning, it sounds like they're going to lose. It was really sad to listen to. I'm going to recap the beginning tonight because that just needs to be discussed. That needs to be aired out. The world needs to know about it. So, yeah. Hey, y'all says that's soy rage. Easily soy rage. Does it take big balls or wet panties? I mean, it could be a wet panty. I mean, it could be a soggy tampon. I mean, either way, it's not something I'm ever going to do. I ain't ever up and walking out of a courtroom like that. The only time I'm in a courtroom in the middle of something like that is if there's like a fire or something like that. A fire breaks out. I'm fucking out of that courtroom. The spider gets on me. I might run out of the courtroom like my hair's on fire. But absent some like disaster happening or an emergency happening, or you got to poop real bad, you might poop your pants. It's going to be like a photo finish. Those are the only times I'm running out of the courthouse. Otherwise, you stand there and deal with it. You take it. But that's your job. You think it's going to be unfair? You think you're going to get hosed? Too bad. You got to sit there and take it. So, Shizzle, hold on here. I think I have a copy of it somewhere we can watch, actually. I think I found somewhere on Discord somebody actually had it downloaded. Let me see here if I can find it. Yep, I got it right now, guys. I got it right now. We're going to watch this. We're going to watch it live. Well, not live, but we will watch it. These are getting a little specific, Sean. Are you confessing? Well, when I talk about what I've done or gotten in trouble for, I keep that quiet, but I've pushed the limits a couple of times. You kind of have to. I mean, zealous representation is zealous representation. I mean, you gotta, as the kids say, you gotta be all up in them guts. I know that doesn't really work there, but it still works. Wait, where did that thing download to? Oh, know the examples of when I'd run out of a courtroom? Well, hell yeah, those are very specific. Well, if there's a fire, yeah, I've never set a fire in a courtroom, so I mean, it's not like I'm confessing through projection or nothing. So as far as shitting my pants, I've never shit my pants at court. I'm just saying, if I thought I was going to, I'd be like, Judge, I really gotta go. There's a spider. I mean, I've panicked in a courtroom when I thought there was a spider on me. That was really kind of scary. I mean, to sit there and shit my pants in court. Your mom shit her pants in court. Anyway, here we go. Here we go. We're going to share this bad boy. Uh-oh. 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 What the fuck was that? Woo! All right. Here we go, guys. Listen to some real shit now. Okay. Okay. I guess we're going to have to see the cuck logo till I can get that edited out. Here we go. Turn your music up. It's outrageous. You mean like trying to prosecute a guy with a bullshit fucking case? That's pretty out-fucking-rageous, you fucking asshole. I mean, if we're going to talk about outrageous fucking shit, how about that? You're prosecuting Matheau Moore with this dog shit of a case? That's outrageous. That's the sham, you motherfucker. I mean, I can't even trust you, dude, because your beard and your hair are the same color. Looks like you're wearing a fucking helmet. Don't come sit here. Oh, she can't be here. Why? Because you're worried about getting dicked on TV. I get that. You don't want to stand there and be the guy taking it up the ass from that judge on TV. I get it. That's not fun, But like I said, when it's your turn in the barrel, man, you got to sit there and take it. I've been an assistant prosecutor before, and I've had to eat shit for my boss. Why? Well, one time it just worked out that way. The other time, I felt like I kind of politically was forced to eat shit. But you know what? You open your mouth, you eat the shit, and you move on. And then when you're a defense attorney, you got to eat shit all the time. Things don't work out most of the time in your favor. Things don't break the way you want them to. And sometimes the judge is just pissed at you. You got to eat that shit. Wait, it's muted? How the fuck is it muted? I put it on. Wait, you guys seriously? It's muted? Oh, you gotta be fucking kidding me. Okay, you know what? All right, fine. All right, fine. All you fuckers want to laugh. You guys want to sit here and laugh? Oh, boomering it up. Here we go. Fine. Daddy will let you hear. Apparently, we got to do it this way. We'll do it live. Oh, live TV. Here we go. You know what? I like this better. Here we go. I would
object to going forward anyway right now.
Here we go.
No, I'm sorry, but I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, I don't.
It's
Okay,
not
your
accurate.
objection's noted.
Your Honor, that's not accurate. Oh.
We had a phone status conference 2 weeks ago in which Ms. Schiffel.
Your objection is noted. Okay?
That's Judge Speak saying, shut up. It's done. Take your L. That's what the judge is trying to say. Oh, by the way, can you guys hear it now? Can you hear it now?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was put
You're
on
going to
notice
sit
of
here.
her unavailability,
You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
It's outrageous. It's shocking. I gotta grab my pearls. You fucking pussy. And show you a fucking outrageous thing. What you did today was out fucking outrageous. Your closing argument was fucking outrageous. Yeah. Oh, this is a sham. What? The judge is giving you his ruling. Like, you could sit there. But no, he wanted to bitch out. My boss is here. What? So what? It's like he's going to say anything you need to hear right this second. Fucking bullshit. I would never fucking do it. I would never, ever do that. Number one, I don't want to go fucking get arrested. I mean, I'm too much of a little girl for that. Fuck that noise if I don't have to. I'll push my luck enough in life. And been arrested enough in life. Don't like it. Number two, you've got some rules as an attorney. You got to be respectful. You have to have decorum. You got to have candor. You have to show the proper respect to the bench. So number two, that blows my fucking mind. Number three, considering he lives in Delaware, it might not be this big a deal for him. But number three, he might hope, well, I hope to God he gets a letter in the mail from disciplinary counsel from the Ohio Supreme Court that says, yo, bro, hey, come on down and talk to us about why you're acting like a fucking cocksucker in court, basically on national fucking television. I mean, I really hope this judge fucking grieves him. Should have fucking grieved him, and he better fucking do it. But you know why he won't? He's a visiting judge. He's gone. It's like fucking with your substitute teacher. It's done. Nobody's ever going to hear about it. And the judge he's in front of normally isn't going to give two shits. Now, you notice he wouldn't do that in front of the judge he's in front of all the time because that judge would fucking rape his asshole out with a chainsaw. But that didn't happen because, you know what? He pushed it because he knew he could. He fucked with the substitute teacher. Fucking bravo. That's some real manly shit there, bro. Look at that little fucking beta shove. Look at that beta ass shove. What a little bitch. Sorry, I had to go back to this point.
This is outrageous. You're going forward.
It's outrageous as a sham. Push a little fucking door out of the way. Come on, man. Now you fucking like.
It's outrageous. You're going forward without the prosecutor.
I mean, if you're gonna do that, dude, you better storm out of the fucking party like your name is El Nino. Like, you're just gonna be like, this is so wrong. This is so wrong. And you just tap the elevator button. What? Come on, man. Like, don't even hit the fucking pit. Like, listen to that. He doesn't even fucking hit the panic bars hard. Not even just like Ray Lewis style, just going like, boom! Like, no fuck yous like that. You're just like, you're acting like you're so fucking offended, and you're just like, like you're fucking polishing the door with your tampons. Come on. Fucking gay-ass beta shit. Beta. There's so much soy in there. And, oh, I'm sorry. Kyle Bogue. For $5. Thank you so much for your support. I appreciate it. For the super chat. What a crybaby. Judge should have thrown him in contempt. Beta. Jim is asking, do I think this was the prosecutors trying to set the stage for them to claim the judge was biased? I don't know. I mean, these guys are bitching out on us, so who knows? Like, you could claim that's a strategy, but they bitched out. So it's kind of like Hanlon's razor. Never attribute to malice what you can attribute to stupidity. I guess I'll start my own razor. Never attribute to cunning and planning what you can attribute to somebody just being a bitch about. So, Don Moore says, now I know what tape to review later. We're reviewing this tonight, 9:30. Oh, ooh, child. Strap in. We're going to talk about this more. I'll have time to like simmer and think about it. We'll have time. We'll talk about this a lot more. We'll have a lot more. Brittany says Menashe took it like a champ. Yeah, she did. But you know what? When that stuff happens, when you're on the other side and you're like the opposing party, even in a civil case, is just getting fucking shelled. Like, either the judge is just lighting them the fuck up, or they're just crashing and burning. Anything when it's going wrong, all you do, especially if the judge is like losing his shit on the other side, you just take your shovel and you just dig a little bit deeper. You dig your foxhole just a little bit deeper. Why? You don't want to catch any stray bullets. You just sit there, eat your fucking K rations, and just life is good because you're not getting shelled right now. You just let them take it. You're like, you got it, bro. I'm just going to sit here. You don't fucking say a word. You don't react. I mean, it's like a T-Rex in Jurassic Park. You don't fucking distract him. You don't want no movements. Nothing. You just sit there and just hold your breath. And then after it's over, you could like maybe talk to other people like, holy shit, you see what he got? Oh my God, they got fucking wrecked. Or, word gets around. People are like, hey, were you in there? And you're like, yeah, man, they fucking lit him up. You just stay quiet. So many good clips here. Yeah, Laundry can find him. Maybe we'll have him. Ray Lewis style. Brittany, you should 100% compile this shit and use it as an intro, like Lunchbox and this dude and stuff. I might go ahead and do that myself and work on an intro from that. I don't know. I was like on a little bit of a spurgy tear there, so. Yeah, he did not storm out of Chaucer fraud. He did not storm out of court. He flounced out of court. Yeah. Bren, yeah, fuck them doors. Yes. Also, I'm not sure I'll ever be down in Delaware County trying a case. That's like 2 hours from me. So, and even if I do, All I know is I get this guy that riled up and he'll fucking queef his way out of it. So that'll be good to know for the future how easy it is to get him off kilter. But we're still not done. We're still not done.
I have prepared my remarks and my decision here today.
And the judge just keeps
and I
going.
am,
And then we've got, hold on
I guess,
here. Hold on.
Esther,
Then the judge starts talking. Then we got to find the, hold
this
on.
time.
I got to find the spot where. Then we get to when they show up.
That evidence, based upon the conclusion that the court's finding that this is a homicide and state suicide, is also rather consistent with the thought that the
Okay. Now they all come in. They all come in. We're the squad. Now, the prosecutor, and this is the prosecutor right here, this woman, she walks, and obviously she can't fit in between the lectern and the table. Okay. She has to walk all the way over by Diane Menashe, and she walks all the way around the front of the tables. She didn't like walk behind with her little suitcase full of shit and her suitcase full of grievances. She walked in front of the tables. Now, I generally, and this is something I always feel, the front, that edge of the table, the front edge of your table right there, it's kind of like you're in World War I. It's like the trench. That's the edge of your trench. And what's in between there is fucking no man's land. You know, I don't go forward of that table unless I ask for permission. Now, if I can drop something off the front, I'll go pick it up. But no, I don't generally go wandering around the front of the courtroom unless I ask for permission first. You know, especially if like he's on the record. I mean, she just walk in like, fuck you, motherfucker. You know, I'm just walking in like this. You know, what are you going to do to me? Now, yeah, I think she's probably got him called out. You're just a visiting fucking judge. This is my county, motherfucker. But the rest of them coming in late like that, you can't do that shit. You can't do that. Okay, look, all of you out there, make sure I got this right. All of you out there, you, yes, you, don't ever do shit like that. Do not. Yeah. So, yeah, you don't do that. Like I said, that's the way I treat it. Now, there's some attorneys like, oh, I walk all over the court and do whatever. I've tried to do that and seen attorneys try to do that. And some judges say, like, you know, the judge stops you like, bro, what the fuck you doing? This is my courtroom. What are you doing? Ask permission. So I always treat it like it's a battle line, man. You don't, you know, in World War I, you hopped out of the trench. What happened? You got fucking clipped. So what happens if I'm in the trench? You stay in the fucking trench till it's time to get out. You poke your head up above the trench, you know, boom, you're gone. So, yeah, I didn't go run around the front. Jim is saying, you know, Sun Tzu never said and never interfere with your enemy when he's fucking up. A lot of people have said that, even Napoleon. Right after he said, stay strapped or get clapped. Well, he also said, protect your neck. Ethan saying breaded decision, but Chad judge regardless for plowing right through that crap. Yeah. Hillary McIntosh. OMG. I wish YouTube had told me you were streaming, been over on LNC listening. Well, that's okay. Well, now you know I'm here, and tomorrow we'll be here doing jury watch. So come on over. Sky Queen saying he should have changed his mind after that. No prosecutor, no case. I mean, I've never seen that before where the prosecutor's like, fuck y'all motherfuckers, and just walked out. Like, I've never seen an empty table like that. Woo. I mean, in the offices I worked at, if I had done that, the smaller of the ones, I would have been packing my shit, probably would have already been packed for me. You know, I've been packing my shit within like the half hour. The bigger one, probably still packing my shit. Will you tell us what Elaine's asking? Will you tell us what the colleague said about his flaunting out? I mean, I will say as much as I can without disclosing identities. All I can say is people are calling them out. Like, there's no, like, we all agree there's no way in hell we could do that. They did that in the Husel case. The judge said about wandering around. Yeah, but the judge will make that clear at times. But when you, like, basically told the judge, fuck off on the record, and then you come in the middle of while he's doing something, you should be very, like, I'm going to come in and sit down and hope you don't kill me. Yeah, trust area front. Wu-Tang! So, anyways, we'll finish this up.
The evidence provided the fact that suicide over a significant period of time has affected the difficulty in the lives of both the defendant and his wife, which likewise has a bearing upon why that could very well have been staged by her husband. Again, at this time, considering all of this evidence and in light of what the court has preliminarily addressed regarding the nature of the court's decision, I find at this time that taken in total, the state has met its threshold burden to allow this matter to be considered by the jury, and thus the Rule 29 motion presented timely at the close of the state's case will not be granted. The court will simply state for the record at this time, and particularly since we are coming to the close of the state's case due to our unique...
Interesting, you know, they act like a bunch of fucking bitches about it, and they still won their motion. Like, they still survived, despite acting like a bunch of fucking dickheads. If only it worked that way for the defense. If only.
Agreed circumstances. 9 motion decision, we are now opportunity, if you wish, to go over jury instructions. Are there any, is the state ready or willing to discuss jury instructions at this point?
Yes, Your Honor, I am. Thank you.
All right, what would you, what changes, deletions, additions?
I will give the, you know what? I'm not going to lie. If I was this judge, I'd be like, are you guys want to talk about, like, jury instructions, or are you going to fucking walk out again? You know, I'd ask the prosecutor, like, if I say something you guys don't like, you going to walk out again? If the jury verdict doesn't come out the right way, you got to fucking walk out? You know, if the jury comes back not guilty, is fucking Soy Pants going to scream, "This is a Sam! Oh, whoa!" And fucking cry about it? I mean, that's not a good look for the fucking community. I mean, if you live in Delaware County, that's your fucking assistant prosecutor right there. That's your fucking prosecutor's office operating like that. Fuck that shit. Fuck that shit. Yeah. Yeah, Ethan, you know, I was going to get to this and I was about to say it, but I'll let you put it up there. These people have the power of the state. They can work with the police to investigate you, charge you with crimes, then prosecute you for those crimes and throw you in fucking prison. And then they pull shit like that. My pussy's loose. It's so wet. Oh, my tampon's so soggy. Oh, help me. Oh. That's basically what he did. And then you hear his shoes squelching as he walked out because it's just fucking leaking everywhere. That's what you heard. And that's the guy who probably thinks, I'm a no-nonsense prosecutor. I go after people and I don't take no shit from nobody. You bitched out on fucking national TV, bro dog. Like, you bitched out. You know, your time to stand tall and be a fucking man on, you know, in front of the world. I mean, and you just fucking, like, took your tampon out and started swinging it around, fucking getting everybody wet. You know, I hope that was worth it. I mean, you think his parents are like, well, that's our son, the lawyer. Look at him. He acted like a little, you know, and they're like, well, what's your son do? Oh, he's an assistant prosecutor. Oh, great, Margaret. Well, what does he do? Well, he acted like a little bitch on TV today, but you know what? It was great. Yeah, I'm sure that's what's going to happen. My parents would have been fucking mortified if I acted like that. The lack of disrespect for the court by the state would displease me if I was a juror. Yeah, it's a good thing the jury wasn't in there because that was fucking disgusting. They were both gonna go through shit, so that means he could have done it. I'm not sure what you're getting at there. Sorry. Critter says, I really thought he was going to walk today more. Yeah, I thought so too. But Ronnie Weaver, yeah, the jury was not inside the courtroom. But for shit like that, I think that would change how the jury feels about a case. Chaucerian Fraud says, this judge seems like a straight shooter. He did not let them affect his decision. Sure. But, you know, now it's clear you can do whatever the fuck you want in front of that judge and he will not stop you. So it's kind of like a parent who calls out a kid and then, you know, I'm going to I'll spank you, and then you don't do it, or I'll ground you and nothing happens. I don't know what we watching from Gixxer 1000. You're watching a grown-ass man with a law degree throw a temper tantrum like a 2-year-old. Not me, the guy on screen. He melted, and for what? Yeah. Honestly, this is what we get to look forward to with the current graduates. Yes. The defense attorneys don't work down the hall from the judge, though. Yeah, but in this case, Stabby, this is a visiting judge, so they probably won't ever see this guy again. If this had been the judge that guy's routinely in front of, I think he would have been a housebroken bitch. Judge says, put your ass in that chair. Yes, Judge. Drew Bradley's asking, was this his attempt at a Binger spotlight? 10 seconds of fame, rather hope that he gets noticed. I don't know. Like I said, never attribute to cunning and strategy what you can just attribute to somebody acting like a little bitch about. Yep. Well, I think there was some wet ass pussy in there. You know, get a bucket and a mop because your shoes are squishing on the floor. You have to shampoo that fucking carpet, I bet. Ethan says, in the judge's decision, he said the facts show suicide affected both of them, and they were both going through things, then use that as evidence. Moore could have done it. Yeah. Once again, like I said, guys, when it comes to that Rule 29 motion, it's in the most favorable light to the state. So you can't draw inferences, but you can, and he did there, but you have to see it in the light most favorable to the state. So it's, like I said, it is really hard to get a Rule 29 motion and win at the close of the state's case. It's really, really hard because you have to give them the benefit of the doubt on goddamn near everything. Ethan says, yes, Sean's parents watching his stream with sex bots and talking about hunting down the postal workers and then screaming at a man waving his tampons around. Hey, my parents raised me right to call it like I see it. They also raised me to not like government, so they'd be okay with me going and arguing with the postal workers. And I wouldn't argue with them. I'm just like, hey, where's our mail? We haven't gotten it in a couple days, and we got it all straightened out. It's all fixed. It's all good, man. Chaucerian Fraud, Beta's Razor. I like that. Hey, you know what? Actually, you know what? You're on my stream. I'm taking that. I'm just like, well, actually, I'm going to go over here and go like this. Boop. That's mine now. Beta's Razor. Lawn Nerd Clips. Beta. Soy boy. Yeah. What legitimate reason, Stabby's asking, what legitimate reason would the judge have for not holding the prosecutor in contempt? Because that turns into a big shitstorm. Because then you gotta he gets arrested, and then you gotta deal with those sheriff's deputies arresting somebody they work with all the time, and then the prosecutor's gonna get involved. To be an attorney and get held in contempt's a big fucking deal. Then that turns into like that gets known all over. And the judge probably realized if he does that, the jurors are going to find out about it at some point. Like, that's not something he can keep quiet. He did it the most professional way he could. I will give him, I think he pussed out on the Rule 29, and I think he pussed out on that. But in hindsight, he probably did the right thing. Brent, the visuals. Well, Brent, I don't know how long you've been around, but I'm I'm very colorful with my speech. So don't worry. There are a lot of visuals. Stick around. You're like Jasmine, and I'm like Aladdin. Like, I can show you a world. By Francis, I'm writing that down. I prefer a yoink, but a bloop is acceptable. So what actually happens after you're held in contempt? Well, if you get held in contempt, you're generally allowed to purge the contempt. You're told to show cause. Now sometimes that show cause is a hearing like right then. Like, okay, we're doing show cause right meow. Explain why I shouldn't hold you in contempt and put you in the back. Or you might get put in the back for a little bit and then given a chance to purge the contempt. And you're like, okay, judge, look, I'm sorry. I didn't mean to do it. And I'll talk about this later tonight. There's a good example of a case out of Detroit where a family member of a defendant got held in contempt and put in the back. And then like an hour later, she was released after she said, look, I'm sorry, I was being immature. That's usually how that works. Now, if it's not in front of the court directly right that second, you might have it set for a hearing, show cause. Hippity hoppity, your meme is now my property. Do you like go to jail? Yeah, if sometimes, like if you act like a big enough fool, yeah, you're going to jail. You're getting arrested and taken in the back. And do you get a court date and bail? No, you don't get bail. You're not entitled to bail on a contempt issue. You so grossly disrupted the court, you don't get bail. But what happens is the court you have a reasonable right to appeal that finding of contempt. But also, like I said, a lot of courts will, like, if you act a real big fool and the judge arrests you, he might bring you back after an hour or two. Like, have you learned your lesson? Do you agree that was wrong for you to do? Sure. Or sometimes with a little more famous contempts, like there was a famous journalist, Judith Miller. She would not disclose the name of a source, and she was held in contempt by a federal judge, and she kept it strong for like 200 some days. Every day the judge would bring her back into the courtroom and say, will you disclose the identity of this source? And no longer, and that's all she had to do to get out of being held in contempt, was disclose the identity of a source. And she said, nope, I ain't saying shit. And the judge said, okay, well, you're going in the back. We'll talk to you tomorrow. And he did it day after day after day after day after day after day after day. You have to give the person an attempt to purge routinely, especially if they're held in custody. But if they're held in custody, the longer you hold them, the more oversight and the more appellate courts are like, you better be really having a good fucking reason now. So, Brent, I am here for it. Iron Rules for $9.99. Thank you very much for your super chat. I truly appreciate your support. You always make me smile. Well, thank you. Brittany said Judge Borowski almost contempted the assistant. Yeah, the paralegal. Yeah, he was really pissed with her. But I think it became clear that was more of the attorney and the witness kind of saying things in a stupid way that made her look bad. But yeah. Absolutely unbreaded journalist. Yeah. Actually, hold on here. We'll look this. Hold on. I'll bring this up real quick. Judith Miller. Actually, how many days did she stay in? Yeah, contempt of court. Yeah, she was initially sentenced to 18 months in jail for the contempt at the end. So I'm trying to see how many days she actually stayed in contempt. Let me see here. So how many days is she? I'm trying to see here. Oh, I'm sorry. After 85 days, sorry, it wasn't like 200 days. 85 days though in jail regarding the source, and then she gave up some information, but it wasn't I'm sorry, it was 85 days. Yeah, Justin, she held out for, I'm sorry, it was 85, not 200. She held out for a long ass time. But that said though, I mean, her husband was sick and kind of ailing, and going to jail. Here's the thing, that's pretty committed, going to jail for 85 days. I mean, that's some like gangster shit right there. So like I said, 85 days. Gixter 1000, you're awesome, my brother. Brother. Me. Brother. There we go. Brother. How many White Claws up to this point? I got 8 Michelob Ultras and 1 25-ounce Bud Light and a little. Nothing right now. Might be a little Bud Light tonight, though. No White Claws tonight. I think I'm out. So, guys, listen, it's 6:45 for me. I got to get ready for tonight. I will be back on tonight. We can talk more. We'll definitely be covering this a little more in depth. And, yeah. So, really, that's it for now. And remember, guys, until next time, just because you did it doesn't mean you're guilty.